Hey, good morning, and I am starting it late today. I didn't realize there was video, but there is video, and it's back at 2 p.m. So in 1.5 hours, we're going to have additional video from the POEC. It's day one deliberations. So apologies for not having the first half of it. I honestly didn't know there was more video. But Railroad had let me know, and I defrosted the trailer, got the equipment out, and set it up as quick as I could. So here we are. So we missed the first half of, or the first part of the morning, and we'll learn together exactly what it is we're doing here today. Let's see who we got here. And this was a last minute thing, so look, if we only have 2 people here today, that's absolutely fine with me. But we will be checking out what this deliberation has for us. I did catch about the last 30 minutes of it or so, and yeah, it looks like we are going to have lots of different things to think about and talk about for this. So let me go and actually find the video, and I can see if I can rewind a little bit for you guys. But yeah, we have deliberation time. Anybody in the chat, go ahead and say hi. I think Terry said he was going to come show up. We've got 5 viewers. Wow, thank you all so much. That was last minute, so thank you all so much for coming. Now let me go ahead and take a second here to try and find a source of that video, because you can't rewind the live stream. Trying to rewind and see where we're at. So how is everybody today? I kind of felt weird not doing a stream at all this morning, and then found out last minute there is one. Thank you so much, Railroaded. Hi, Jennifer on Facebook. Thank you for coming. Yeah, we're doing some deliberations today. We're checking it out. Oh, cool. Come and join us, Anita. I get my coffee too. I had to defrost the trailer, had to defrost my equipment. We flew in very late last night. Everything was late. Hi from California. Okay, cool. Welcome. 10 viewers. Great. This is awesome. Okay, it looks like, yeah, our good friends. Sorry, let me get that volume. Our good friends at Maverick Media, looks like they're playing it. So let me go take a look here. They are. All right. So what I'm going to do is I'm actually just going to play it from the beginning, and we're just going to be an hour and a half behind, and we'll skip the lunch and we'll catch up. We'll just be a little bit behind. But what that will do for us is it allows us to all now catch up from the very beginning of this, so we don't miss a single thing. Hey, Ellen, Railroaded. This is stream is live Ontario. This is okay. Let me try that one, Railroaded, because I'm going to rewind Railroad. So I know you've seen it already, but that'll give us a chance to actually catch up. Okay. So give me a second here. Oh, you're awesome, Railroaded. Okay. Get the link. Perfect. Thank you, Railroaded. So I'll use that, and we'll go from there. So what I'll do is I'll just do about a few minutes here, get us going, and then we'll get right into it. Hey, Terry, nice to see you, buddy. Ellen, thank you for coming. Hey, I have a wrench. I don't know how to use it. So, Ellen, what I did is I made you a mod. So if those 6 things come up, whatever, you can kill them, you can take them off, and you can also drop links into the chat now. Made you a mod. And so if that's cool with you, then we'll leave it that way. If you want me to take you off, take you off. But it just means you can actually help and with the chat. Can't clip his stuff, but he's rebroadcasting and can rewind there. Perfect, Railroad. I'm going to do that. And Railroad will just be about an hour or so behind. So today is going to be a little wonky, but I'll stay with you the whole time so we can get all of this on here as well. And yeah, you guys, I got in really, really late last night. The plane was delayed, and it was also luggage was delayed. But lucky me, what I got to do that entire time was I spent it with Keith Wilson. So he took the same flight out. I didn't know that. Saw him on the plane when we were transferring to Winnipeg. And then I got to have dinner with him, have some drinks with him, hang out with him. When you got King's Counsel in front of you, you get to ask a lot of questions without a retainer. So that was wonderful. I learned so much about what they're going to be doing going forward. I talked to him about the Peckford case. I talked to him about other freedoms and stuff that they're working on. He's an amazing gentleman. He works with the Danielle Smith. He's one of the advisors. I asked if I can help with the campaign, that kind of stuff. And it also turns out, Railroaded, that he is one of the members of the National Citizens Inquiry. So I asked him if he can tip his hat on my name, and he said, yeah, we'll take a look at that package. So we got to know each other. Cool. It's so great to see you both just pop in here, and Terry as well. Oh, that's awesome. Okay. We also want to talk about what we want to be doing going forward. But if this is another week of this stuff, then I'm just going to keep doing that, and we'll keep thinking about what we're going to be doing going forward. I did get a confirmation from Keith last night that they are going to give me a copy of everything they're allowed to give me a copy of. So that's going to be more than the public database version, because there is still documents that they have that they're allowed to share. So he's confirmed he will do that for me. And he does not live far from me, as it turns out. He's about an hour away from me. So we'll make all that happen. And we'll get all that information onto our server. So when we start analyzing it, we got everything we can get our hands on properly and legally. So hit hide is all, something like that. Yeah, you'll see on the chat, you'll have those ... You can click it on anybody and you'll see what the options are. And then if you ever have to use them, you got the power, Ellen. Prairie, welcome. Nice to see you. Thank you for coming back. Everybody, this is great. I'm gonna have a good time here. Do you want to know a little bit about my trip? It was really fun. My last couple of days was really exciting. I got to meet the commissioner himself. So as he was walking out, I stood and chatted with him for quite some time. He's a nice gentleman. He knows he's got a lot of work ahead of him, and he's willing to do it. So, and I feel comfortable that, you know, he's just a normal dude with a lot of things going on. Hey, Prairie. Yes, spill, Jason. So after that, I hung out with a friend from Twitter. He made his way out there. You may have seen him in the video. He's the guy with the flag, the big flag that had it all signed. So after we did some touring around Ottawa, the different sites, we connected with a friend. He took us to the Parliament Hill to go see some of the sites. We went to the Terry Fox Monument, got some pictures there. There's police everywhere down there, by the way. The PPS is everywhere. We felt super safe. Everything was fine. We were never confronted with anything. We were enjoying ourselves. We got to go see the War Monument. We got to go, actually, really everything. It was a nice time. Friend Alex, Mr. Green Mr. Green Thumb on here, joined us, took us around, gave us a tour, told us so many stories. I'm going to get him on again, and he can share them with you, because he has great stories about a trucker named Brian. So we'll share that. Hey, Kendra from Saskatchewan. And then Ellen on the way home, got a ride to the airport, and then, Keith Wilson. So we had a 3.5 hour delay in Winnipeg, and just chatted about everything. So he is spending a lot of time on his submissions, he said, and they're looking at maybe judicial review and the Peckford case. So we spoke a lot about the Peckford case. Going all the way to Supreme Court is where he believes it's going to go. And I believe it has to go there. We need a decision some way or another on the Peckford stuff. So good news there, good optimism there, and he's working hard on that. So hi, Kendra from Saskatchewan. Welcome. And Ellen, did you disagree, Terry? No. What we did was the flag that we Tom had with all the signatures of the truckers, and he asked me to sign, by the way. I was taken back on that one. We stood in front holding it. Nothing was placed onto anything, because there certainly was supervision. There was plenty of supervision around, but we got pictures of all of us standing in front with that flag. I'm going to get my hands on it. I'll share it with you. And my Tamara Lynch tweet, whoo, I had trolls and frustration and stuff like that before, but nothing like this. We're into several hundred hate messages sent my way. They're just incredibly interesting, because there's like 5 or 6 of them just repeated with different people, and all they do is they send like a laughy gif or a bunch of emojicons, and then they spew out a lot of hate. But I attracted all of that just by saying hi to Tamara and posting a picture. Good news with that, though, is I asked her for permission to make sure, and she said yes, it's your property, you can do what you want. She just couldn't be live. streaming, not because she's not allowed to be, it's just because the content of her conversation is restricted heavily. And you'll see in all the pictures that I have when Tamara's around, so is Keith Wilson. The lawyer was always around. So she is still under those bail conditions to this day. Brave woman that had to go through that. And she sat there the entire time, looked at Trudeau the entire time when he testified. And that was kind of cool. And by the way, that whole event with Trudeau was pretty neat in that, well, there he is. He's sitting right there. That man is sitting right there. He does seem, in my opinion, to be very skilled at controlling like everything about him. His entire demeanor, every move he makes, every head thing he does. He seems to be very, I don't want to say acting because that's not the right word. It's just very much in control of everything. He stared into space a lot. Didn't make eye contact much. But I think a few times we did make eye contact. And he may have done a good you know sync to me. Whatever. But it was kind of neat. We all heard his testimony. We all have some problems with it. And we're definitely going to be going through that with a fine-tooth comb. And I also spoke to Keith about the earpiece for Freeland. He doesn't think there was an earpiece. He was looking right at her. And at that moment in time, and he reminded me because I wasn't paying that close of attention, but he was, there was a Zoom call. They were working with a witness on Zoom. So he believes that what she was doing said she can't hear the witness on Zoom, then not an earpiece at all. He was far closer than I was, so he saw. But I did ask him about that. He didn't think there was an earpiece, and he does recall that there was audio issues with a Zoom call at the time. And he specifically remembers it because Viva Fry was texting him at that time saying, hey, what's going on? My viewers thought there was a thing here. And right at that time, he gave him his side of the story. So that's fresh from Keith there. And I'm buying it. I'm buying that explanation because really, an earpiece? Hey, Jim, welcome, bud. Bots spew the hate. They certainly do. Just go to my Twitter, go to my pinned. It's got Tamara there and just enjoy. I've never seen that before. It's kind of neat. It's kind of neat to see that happen. I kind of feel like there's a bit of a badge of honor there. Your thread was, yeah, for sure, Ellen. It was, wasn't it? My gosh. But there's only like a half dozen different messages or so, and then they're repeated with different names, slightly different. So I think there's a lot of bot going on, or it could be a bunch of people doing it. But thanks for the effort, guys. You spend a lot of time on me for no reason because it will mean nothing to me. I have my positions and I'm strong with them. So whatever. Go ahead and type away on Twitter. JT clone? I don't think so. Eleanor. I think that was the real deal. It was still kind of neat. You know, don't have to like a person to, appreciate the situation that you're in. But it was kind of neat. Thanks, Eleanor. Perry. Who's that? Somebody new? Jason? Oh, look at that. Yes, PEI. Here, 10th man sent me your way. Yeah, cool. Jason, nice to meet you. I don't get a lot of tense videos and stuff. I don't follow a lot of his stuff, but when he's on the panel, he's awesome to talk to. He certainly has a very, very strong and interesting view, and we share a lot in common when it comes to where he sees the system and the people and our roles together and how we mesh together. We're on similar wavelengths, not completely, but similar. And I think I got to get to know him a little bit better. Hey, Ellen. Oh, yeah, you guys are following what's happening in China and Brazil? Is freedom starting to win? You have to keep a close eye on all that. He was so happy when a strange woman clapped and cheered for him, like he immediately wanted to bow. Yeah, we love you, Justin. So she was the row behind me and on the end. And I was on the right side of that, the row in front of her. She was right on the far left. And beside me was the anti-protester. So when she stood up and said, we love you, Justin, the one beside me, I can't remember her name. Her daughter was there, but she started clapping as well. So there was two people kind of cheering him on there, but that's it. Okay, but it was a packed crowd. There was no empty seats. So, I don't know, at least 100, 150, maybe 200 people in there. Two made noise for him. And I assure you, the rest of them wanted to say something, but they also wanted to not ruin the the image that the convoy team's been working so hard on keeping. So I do appreciate everybody in the crowd that wanted to stand up at some point, because I know I certainly wanted to yell a couple suggestions for the new parliament. But thankfully, everybody was good about that. And by the way, there's a lot of pictures of me being in the crowd when they're talking about this stuff in the press now. So that's kind of weird. I wonder how China is going to handle the zero COVID policy protest happening now. Jim, this is very, very good. Keep an eye on. Azario, welcome. But yeah, Jim, we keep an eye on what's going in Brazil and China. Hey, Azario, but I didn't know about this day. So here we go. We're just going to wing it. And Azario, I'm playing it from the beginning so we don't miss a thing. I have a source for it now, which is great. So I'm going to be getting that going, I think maybe in 15 minutes. 15 minutes, I'll start the stream from the beginning so we can all watch it together. Look at that. Family's back together, railroaded. It's like we never left. Hey, welcome, Murray. You never looked directly when you were aligned. Yeah, he was into space, and he's not even looking at a screen, like, because his screen's in front of him. He's looking into a point in space. And he also went back to it often. And another habit or arrogance that I noticed was sometimes when the lawyers were asking questions, he was completely distracted, like playing with his water bottle, cleaning stuff off the table, swooshing it away, just focused anywhere but the lawyer. And he also went to his lawyer on hard questions. There's people that say he touched his nose or whatever, but he doesn't have to touch his nose to signal to his lawyer. Just eye contact will do it. He just looks over and says, yeah, bail me out. And they did. They did quite a few times they did that. Hey, Jim, welcome back, buddy. Azario, welcome, Jason. Take care. I got to get back to work. Thanks for swinging by, Jason. Take care, bud. Yeah, work safe, Jason, for sure. Hey, Azario. What do we got here? Ontario, Sault Ste. Ontario TV. Okay, so that's another stream. That might be the one you sent me already. Yep, that's the one we're using. Railroaded. Yep, that's the one we're using. So we'll go ahead and do that. To my friends out in the GTA area, I got to come back to Burlington. So I'll be back there December 8th through 13th or 12th, something like that. Yep. So I got to be back. So if you want to get together for the weekend of the 9th and 10th, maybe we'll do something. I think Arzario, maybe I'll hit you up. Maybe we'll do something. Anita, what are you going to do with the Ontario College of Physicians' weird suggestions? I'm not there, so send me more information on that. I think I don't want to comment on that yet because I think I just heard in passing some of that. I got to get some more information on that. Pretty sure Railroaded shared something already, so I got to look into that some more. And also all of you that are on our Discord, come and join. We're gonna get that project going. We did that little poll for fun to see what would happen. We were at the 90% for until the trolls started showing up, and then the poll kind of went down a bit. But we had 3/4 of people say, yeah, let's go ahead and analyze all of that information. And when I spoke to Keith about that, he saw it was a great idea. And what I might ask him to do is once a week, we'll recap and update him, maybe spend half an hour chatting with him about what we've done the previous week and where we should be going with it, in order to give us some guidance and some suggestions on what it is we should be looking for, and some feedback on what we've done so far. So that might be a cool part of our, data crunching and analyzing here. What's this? Okay, I have links. Cool. Yeah, throw them in Facebook, and I'll take a look at those. Thanks, Anita. Denise, hi. That's a good point. I have to look at once for the clues for his lawyer's help. Yeah, just look. Just look. You make eye contact. You know when humans make eye contact. Yeah, that's all he has to do. He doesn't have to signal. This is not a poker game. But it's kind of neat to see how much he's a nodder. Okay, so he does a lot of this. Okay, Freeland was like all over the place, playing with her hair a lot. He's a nodder, but he stayed focused in thin air, just looked into space and answered questions as calculated and as constructively as he could. Is that about the unvaxxed and the doctor should put them on the meds? Oh, is this about if you don't take... I'm not going to comment. I got to get a link. Very, very little information on that. I think that's what she was talking about, Perry. Cool. And Railroaded in Alberta, Smith came out and she's banning mandates for masks, and all children have the right to be in person. So those are two big steps that Smith has now implemented in Alberta. And controversy, you know, people are happy, people are not happy. I'm certainly happy. I think children have the right to be in school. They shouldn't be asked not to be there for whatever reason. And masks, I think, are at this stage, as we're transitioning between the everyone should wear it, we're now at the personal choice stage. And then I think at some point in the future, we're going to reach the we all feel silly and it harms us more than good phase. So at some point, people will learn more about their choices and, you know, alter them or keep them. Yes, Prairie. And yeah, I think so. Okay, I'm going to look into that some more too, because yeah, I want to know what's going on there. So thank you for sharing that, Prairie and Anita, and we'll look into that. All right, folks. Got 10 more minutes to do some more chats. Azario, hope you're catching up on some of your work, and thank you again for last week. You did a great job. I think we're going to be doing a lot more together. I'm happy with that. And you had an idea about a weekly thing. Let's look into doing that. Maybe get you on for a week, once a week to do something. Yeah, let's look at that, buddy. All right. And I'm going to close this window and get myself ready to put that stream on. I'm excited, though, now that I heard some of it and what they're doing. It's Deliberations, a discussion panel. So we're going to sit there and listen to everybody. I saw that the commissioner's there and a bunch of people we don't know, which I'm sure we're going to be introduced to. Wow, 40 of you just showed up. Charlie's here, too. Wonderful, everybody. Thank you a bunch for coming. Go ahead and give me a like, subscribe, all that stuff. Give me a share. We'll keep this community going. It was a pleasure and an honor to do that 6 weeks with you. So let's keep going. Yeah. All right. So, folks, what I'm going to do now is I'm just going to get into it because I'm just too excited. I want to start watching this, and I'm sure you do too. We'll do it on single speed, but we will skip over any of the breaks. So I won't be taking breaks. We'll just do our best to get through this quickly and watch it together, okay? And Honk Army, looking forward to Convoy 2.0. So, Charlie, I got a little bit more information on this. This is the stuff that's coming in February is not related to Freedom Convoy. That's Canada United, and that's James Bauer, and that's going to be Bear Hug 3.0. So this is not a, I don't want to say official anything because it's all grassroots, but this is not associated with Freedom Corp or any of those people. But yeah, it's going in February as far as I know, Bear Hug 3.0. Okay. Okay, let's go ahead and cue it up. And I don't have audio. Oh, hold on. All right, so yeah, I don't have audio, so 1 second. Let me see what's going on here. Yeah, that's 1 moment. Put it in here. It may have started off with no audio is what happened there, because there is audio in that stream. All right, put it on here. So it looks like the source doesn't have audio at the very beginning. That's what we got here. But it does kick in. I went fast forward and it does kick in. All right, and let's throw this banner on. Now, I'm not going to do talk over of this. So we're going to be watching this together. And here comes the audio. Mr. Green, Ottawa. Hope so. Yeah, I saw him. Had a good time with Mr. Green. Had some dinner with him. He's a really, really, really nice guy. Very smart guy. Very articulate and very strong. I was home. One of the biggest. Yeah, Mr. Green is awesome. There, he's here. Mr. Green, you're here. Nice to see you, buddy.
The Public Order Emergency
Enjoy.
Commission is now in session. The Public Order Emergency Commission is now in session. La Commission sur l'état d'urgence.
Okay, bonjour, good morning. Bonjour, good bienvenue and welcome to this new phase of the public hearings.
Okay, I'm getting feedback echo, but that's the source. Okay, so we have to sit through some audio issues here and then find out what's going on, but it's not my side.
Over the last 6 weeks, I've heard from over 75 witnesses who testified about the circumstances that led to the declaration of a public order emergency and the use of powers under the Emergencies Act. And the use of these witnesses have provided these witnesses many perspectives on those events, including the views of public servants, including the police forces, protesters, servants, residents, and political officials. That evidence has been critical in allowing me to discharge the fact-finding portion of my mandate. Nous entamons aujourd'hui la deuxième phase des audiences publiques. Celle-ci concerne un volet différent de mon mandat. Lorsque j'ai été nommé commissaire, on ne m'a pas seulement demandé de faire de la lumière sur ce qui s'est déroulé en janvier et en février 2022. On m'a aussi confié la tâche de formuler des recommandations pour l'avenir. Ces recommandations doivent aborder une éventuelle modernisation de la loi sur les mesures d'urgence ainsi que d'autres enjeux qui méritent d'être étudiés. On m'a également demandé de tirer des conclusions concernant plusieurs domaines spécialisés, des plateformes de sociofinancement à la mésinformation sur les réseaux sociaux. For the next 5 days, the Commission will hear from a series of experts and expert roundtables, each one devoted to a different topic that is relevant to the Commission's policy mandate. These discussions will assist me in making the recommendations that will be contained in my final report. The organization of these roundtables was undertaken by the Commission's Research Council, which has provided the Commission with excellent support throughout the process, including the commissioning of papers. And in that regard, I just wish to note that some of the papers contain factual statements or factual assumptions that may not have been borne out in the evidence led at the hearings. Of necessity, of course, these papers were prepared in advance of the fact hearings, and those factual assumptions or statements will not be considered as evidence and will not be considered in reaching my conclusions. Obviously, I will reach conclusions based on the facts I have heard in the course of the hearings and in the documents contained that were filed. Now, parties with standing at the inquiry were consulted and provided valuable input on the topics to be addressed, the process that the roundtables should follow, and who should be invited to participate. As a result of that process, the Research Council prepared 9 roundtables involving approximately 50 expert participants. The experts include both academics and practitioners in such areas as such areas of the law as policing, intelligence, and government. For those who have been following our proceedings so far, the policy phase will look somewhat different, both physically and in how it's going to proceed. Rather than examinations by lawyers, the roundtables will start with a facilitated discussion led by a moderator. During this discussion, parties with standing at the policy phase will be submitting additional questions to Commission Counsel, who will then conduct their own questioning of the participants based on the input received. I too may have questions to ask the participants. Le Conseil de recherche, les modérateurs et les participants ont consacré de longues heures à la préparation des tables rondes qui se tiendront cette semaine. Je tiens à les remercier, tous et toutes, d'avoir fait preuve de générosité en acceptant d'appuyer la Commission dans ses travaux. Sur ceci, je cède la parole au doyen Robert Lackey, qui animera notre première séance sur les droits et libertés fondamentaux qui entrent en jeu lors de manifestations et leurs limites. Doyen Lackey, la parole est à vous.
Merci beaucoup, Monsieur le Commissaire. Donc, je suis Robert Lackey, le doyen de la faculté de droit de l'Université McGill. J'ai le plaisir de vous présenter les panélistes ce matin. Brian Bird, Assistant Professor, Peter A. Allard School of Law, University of British Columbia. Jamie Cameron, Professor Emerita, Osgoode Hall Law School, York University. Jean-François Gaudreau-Desbiens, Professeur, Faculté de droit et vice-recteur de la planification stratégique et de communication de l'Université de Montréal. Vanessa McDonnell, Associate Professor in the Common Law section of the Faculty of Law, University of Ottawa, also co-director of the U-Ottawa Public Law Centre. Carissima Mathen, full professor in the Common Law section of the Faculty of Law, University of Ottawa. And Richard Moon, full professor, Faculty of Law, University of Windsor. This roundtable aims to lay out the foundation and framework for the fundamental freedoms under the Canadian Charter of Rights and Freedoms. Rights to freedom of expression, assembly, and perhaps association. Protesters regularly exercise these democratic rights, and governments seek to justify limits on those rights. I think there will be consensus on the importance of these rights of democratic participation and the need for sound justifications for limiting them. Beyond that, Commissioner, it's possible that one takeaway will be that reasonable people disagree on the complex challenges of fleshing out and concretizing these rights in our free and democratic society. We have a lot to address this morning, and I remind participants of the need to keep their answers concise. We're going to kick off with a brief primer on the Canadian Charter of Rights and Freedoms, perhaps set against the history of rights protection in this country. Rights have not only been protected through entrenched bills of rights. And so we'll have a little introduction to that, including the notion of substantive rights, limitations on them. And we begin with Professor McDonnell.
Thank you, Dean Leckie. So in terms of setting the stage for today's discussion, it actually does make sense to go back a little bit further than 1982 when the Charter was enacted, and to just touch briefly on Canada's history of rights protection, because we do have a longer history of rights protection in this country. The common law has long protected rights in Canada. And Canada also has a history of statutory protection of rights, most notably at the federal level through the Canadian Bill of Rights, which is an ordinary statute which in the 1960s codified a set of rights and freedoms. Now, this pre-1982 history is certainly not an unblemished one. It's part of a broader history that includes notable failures in rights protection. And so that needs to be acknowledged as well in discussing Canada's pre-1982 history. So that brings us to 1982 and to the Charter, which formed part of a package of constitutional reforms that included the recognition of Aboriginal and treaty rights and a domestic amending formula. So the Charter creates a catalog of judicially enforceable rights and freedoms. Some of these rights and freedoms are a part of many constitutions around the world. So you'll hear us speak today about the right to to freedom of expression, to the right to equality, the right to vote, possibly. These are all core guarantees that are found in most bills of rights. There are other aspects of the Charter that are unique to Canada, and that would include, for example, the language rights provisions of the Charter. As Dean Leckie mentioned, the Charter is constitutionally entrenched. That means it's supreme law, and that laws that are enacted that are inconsistent with the Charter are of no force or effect. The Charter also prohibits state actors from violating rights. And so that means that state actors must conduct themselves in ways that are compliant with the Charter. And so that brings us to another important foundational point, which is that the Charter binds state actors. And what that means is that the state is bound to respect constitutional rights, but there aren't rights that are held as between private parties. Some of the rights and freedoms that you'll hear us talk about today include the fundamental freedoms, so freedom of expression, freedom of association, freedom of peaceful assembly. These are the core rights that are engaged in the context of a public protest. But there are also rights here that may not be immediately obvious, but which form an important part of the discussion. And so those include Section 7, which is the right to life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice, and Section 15, which is the right to equality. To the extent that arrests or detentions were made in connection with the protests, the rights of accused persons found in Sections 7 through 14 of the Charter are also relevant. So what do these rights mean? How have they been interpreted? Well, the meaning of the Charter and of individual Charter rights has developed over the last 40 years, largely through adjudication in the courts, but also through the involvement and interpretations of political actors. And I think it's fair to say that in complex situations like the ones that gave rise to the convoy, there are complex rights issues. And so in discussing how Charter rights were implicated as part of the convoy, it's important to surface all relevant rights. The rights that were potentially violated as a result of the state response, but also the rights that were protected by the state response. Because I think it's clear that the state, in response to public events like the ones that we experienced, have an obligation to respond in some way. And so I'm going to turn things over to my colleague, Professor Mathen, here in a moment, but perhaps I can sort of set things up a little bit by saying that Charter issues, when they're adjudicated, are adjudicated really in two stages. And so at the first stage, the question is, are rights engaged? Have rights been limited? And if there's no rights violation, that's more or less the end of the story. If a right has been violated, the second step in a Charter analysis is whether any limits on rights have been justified. And so I've really been speaking about that first stage of the analysis, and I'll turn things over to Professor Mathen to speak about the second stage.
Thank you, Professor McDonnell. Professor Mathen.
Thank you very much. Section 1 of the Charter states, the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Its purpose is to guarantee all the rights and freedoms in the Charter and to state that those rights are subject to reasonable limits. Now, the fact that rights would be subject to any limits might seem counterintuitive, but in fact, in most constitutions, there are very few absolute rights. A concern that might be raised about Section 1 in particular is that it appears to undermine the way that we understand something as a right because of its reference to democracy, which might suggest that rights can be reasonably limited if a large enough majority in society wants them to be. Sometimes we refer to this as the tyranny of the majority, the idea that in a democracy, minorities can be vulnerable if they lack political power or are very unpopular. Section 1 does not operate that way. For something to be a reasonable limit, it is not enough that a majority, even a supermajority, really wants that limit. This is because the reference to democracy is not to majority wishes alone, but to a broader conception. What does it mean to be a free and democratic society? Section 1 exists not as an exception to rights based on the wishes of a majority, but as a confirmation that rights are essential in a democracy. Like everything in the Charter, Section 1 is a legal tool. So it has a recognizable and routine framework in place for almost 40 years, whenever it arises in a legal case. The framework both draws on the actual language of Section 1 and how courts have interpreted that language. At the Section 1 stage, the burden of proof is on the state. So it is for the government to convince a court that any limit on a charter right is reasonable and demonstrably justified. Section 1 itself says that a reasonable limit is prescribed by law. This ensures that any limits on charter rights are traceable to an actual legal rule. That rule can be found in statute or regulation, or more rarely at common law. This ensures that limits on charter rights are consistent with the rule of law, which guarantees that all state power is itself authorized by law. Once you start to drill down into whether a limit on a right is reasonable, there are a number of factors that a state will have to address. That the limit on the right is for a pressing and substantial objective, that the limit is rationally connected to achieving that objective, that the limit minimally impairs the charter right in question, and that there is overall proportionality between the positive or salutary effects of the limit and the negative or deleterious effects on the individual whose charter rights have been infringed. While Section 1 is a legal tool designed to promote consistency in how the Charter applies, it's important to recognize that charter rights are implicated in extremely diverse situations of varying complexity. It's also useful to recognize that there is a sometimes delicate relationship between the courts and the state when assessing whether a Section 1 justification has been demonstrated. To that end, the courts have repeatedly stated that the analysis of Section 1 is contextual. It will look closely at the circumstances. While the state must prove its case under Section 1, courts also recognize that it is not always possible to do so to a particular degree of scientific or forensic certainty. This may be because the particular objective really isn't amenable to scientific proof, or because the state is operating in a situation where information is simply not yet available or is uncertain. While purely speculative arguments are likely to fail, the courts do tend to give the state a certain margin in which to establish justification under Section 1, again, depending on the context. The final point I would make here is that it's natural to see the state and individual or citizens in an oppositional, even antagonistic relationship. This is particularly true for some contexts like criminal law, where you have the immense power of the state being brought to bear against a single individual. But sometimes the state is in a different position. It may be trying to balance competing charter rights. It may be trying to protect the vulnerable. Or it may be trying to safeguard certain things or values that in themselves are essential to a free and democratic society. All of those factors may be important to the ultimate assessment of whether Section 1 has been made out.
Thank you very much, Professor Mathern. Does another panelist wish to add anything at this introductory level, our sort of charter primer, so to speak? Professor Moon?
Well, maybe is this on? I can't. Yes, it sounds like it's on. Just add, that was, terrific introduction. Just add one thing, because I'm struck that often individuals make claims. I have a right to something and make claims at large. And I think it's worth thinking about and noting what's in the Charter and what's not in the Charter. And the Charter, in a sense, performs two functions. One is a symbolic function, and it's meant to list what we understand to be the fundamental rights of members of the political or national community. but it also has a very practical function in the sense that there is an enforcement mechanism. That is to say, if someone feels their charter rights have been breached, they can make a claim for the courts. And that very much shapes what's in the charter and how particular charter rights are in fact interpreted. The limits of what a court can do and how a court can approach or interpret a right. And I just think that's worth noting, given the general language it often operates about, I have a right, statements made very much at large.
Thank you, Professor Moon. Okay. Commissioner, we're going to move on. And so a few minutes from now, we're going to drill down more specifically on two of the fundamental freedoms, freedom of peaceful assembly in paragraph 2C of the Charter and freedom of expression in paragraph 2B. Still in a somewhat introductory mode, we're going to speak a little bit about those rights of democratic participation together, perhaps connecting them to fundamental values of public engagement and participatory democracy. And we're going to continue now with Professor Bird.
Thank you very much, Dean Leckie. So the topic of democratic participation, how and when individuals who belong to a democratic society contribute to the democratic governance of that society, raises several complicated and nuanced considerations. Participation in a democracy can take many forms: voting, running for office, writing to your elected representative, starting or joining a political advocacy group, and so forth. But for today, our focus is on protest as a form of participation in a liberal democracy, the idea of a right to protest in such a society, and when that right can or should be limited. So in these brief remarks, I'll offer some reflections on the added value of protest in a liberal democracy, leaving the matter of a legally protected right to protest and how that right can be limited for a later stage of our discussions. So it seems rather uncontroversial to suggest that protest in the form of rallies, marches, demonstrations, sit-ins, etc., is part and parcel of democratic life. Protest may at times test certain commitments that are said to be hallmarks of a liberal democracy, but I think it would be difficult to find widespread support for the notion that peaceful, nonviolent protest is untethered to democracy, or that this activity should be done away with as a form of democratic participation. And in general, I think the occurrence of protest is a marker of a vibrant democracy in which citizens are invested in how they're being governed and how their society ought to change. Even where protests might be a response to a perceived departure from democracy, these protests are still a form of democratic participation as they aim to perhaps rescue or preserve democracy and democratic institutions. Citizens coming together to publicly manifest their support for or opposition to this or that cause, issue, law, court decision, or some other current issue of public interest is a normal feature of democratic life. So much so that it would be perhaps unsettling from the perspective of a society's democratic credentials if protest were to become an endangered species of democratic participation and even extinct. And that idea invites us to think more about the added value of protest to our society, to a democracy. It's one thing to say that protests are commonplace and accepted as normal in a democratic society, but how do they enhance the practice or project of democracy? And perhaps history and hindsight might help us here. It wouldn't take too much time to be able to create a list of protests or activities akin to protests that were either instrumental in effecting transformative change for a society, or significant from the perspective of raising within that society, and perhaps in other societies that take notice, of injustice, inequity, or violations of human dignity. So the civil rights movement in the United States, for example, comes quickly to mind. Now, scientific measurement of the effect of protests like these on the societies in which they occurred, as well as on the other societies that may have taken notice of those protests, is difficult to provide. But it seems fair to suggest that these and so many other protests over the course of history have accelerated the pace of change in hearts, minds, and laws alike. So the value of protest in the pursuit of a society that is more just, equitable, and protective of human dignity might be easier to perceive through the rearview mirror, so to speak, but we can choose to apply these lessons of the past to protests we witnessed during our lifetime. The protests we ourselves witness could be part of a longer arc of positive change that is not entirely perceptible to us at the time the protest is occurring. They may also turn out not to be part of that kind of change, but our inability to definitively know either way when the protest is underway suggests that we should perhaps err on the side of permitting protest. Still, some of us might say that instead of protesting, we should opt for less disruptive and disconcerting forms of democratic participation. Voting in elections, writing to your elected representative, publishing an opinion article in the newspaper, launching media campaigns for a cause, and so on. And one response to this proposal would be that protest, owing precisely to its uniquely disruptive and perhaps disconcerting characteristics, may in certain cases be far more effective than other methods of democratic participation. It may even be true that in certain cases, protest is the only method that stands any chance of sparking the change that is desired. It's hard to imagine, perhaps, the civil rights movement in the United States of having succeeded simply through writing letters to members of Congress. Protest, in other words, might be the only meaningful way for certain voices and the message they carry to be heard by individuals in the halls of power. Without protest, the desired change might take longer to come about, in the order of years, decades, and even longer, or the desired change might never come about. Much more could be said about the added value of protest to democracy, not to mention the value of protest to the human condition and spirit. But for the sake of time, I'll mention only one more now. It could be called the pressure cooker rationale, allowing citizens to come together to peacefully express discontent over how their society or other societies are governed, allows these citizens, and even those citizens who agree with the protest but can only watch on television or social media, to let off steam and be heard. Forbidding or unduly expressing this outlet for citizens might sooner or later cause the pressure cooker to explode. Just to close, perhaps the greatest obstacle to appreciating the democratic value of protest is our own personal opinions on the aim or cause of a particular protest. When we disagree with the viewpoint animating the protest of the day, our opinion of protest as a form of democratic participation may also diminish. And the reverse also might be true. When we agree with the complaints of the protesters, our affinity for protest itself may increase as well. And this dynamic seems to come to the surface when we opine on how long a given protest should be allowed to last, or the degree to which restrictions should be imposed on the time, manner, and place of the protest. I suspect we often afford more or less latitude on these points, depending on how sympathetic we are to the views animating the protest at issue. And to close, I would just note that it takes a major dose of even-handedness and tolerance to express support for peaceful protest, even when we vehemently disagree with the reason for this or that protest or the views that the members of the protest hold. And yet, in Canada, this ideal, this even-handedness and tolerance, seems to be our aim in a free and democratic society committed to maintaining a public square that is open to all its citizens and, apart from exceptional circumstances, the unhindered expression of their core convictions. So I hope these reflections will aid our conversation today as we explore how protest is and should be protected as well as limited under Canadian law. Thank you very much.
Thank you, Professor Bird. I wondered if any panelists wanted to comment on the particular contributions, if any particular protest in recent years, qu'il s'agisse du printemps d'érable ou quelque chose d'autre comme cela, at this stage. Does anyone want to jump in on a particular? I have another. After that, we'll move to the connection, perhaps, between a couple of the democratic rights of participation. Professor Cameron?
Yes, thank you, Dean Leckie. I would just draw attention to the pedigree and lineage of protest movements in history. So not expressly to answer your question, but just to point out, if we're looking at the United States, for example, we go back to the time before the Civil War and to the whole abolitionist movement, followed by the women's movements, and then up into the civil rights movement, which has been mentioned by Professor Bird, as well as Vietnam protest and any number of others. In our own country, just in recent years, we have seen Maple Spring, of course, the Occupy movement, Black Lives Matter, Idle No More, Pride movements, and all the Indigenous movements, which are too numerous to mention. But just to say that we have a very strong pedigree of protest movements in North America and including in Canada. And they're an important aspect, I agree with Professor Bird, very important aspect of participatory democracy.
Thank you, Professor Cameron. That makes a little more concrete Professor Bird's reminder that protests may not be simply something to be tolerated, but that they bring a distinctive value. Professor McDonnell?
I was just going to add that I think that you've both captured very well the sort of value of protest in a democratic society and the importance of nurturing it. My sense is that where the challenge lies is in, first defining the contours of a right to peaceful assembly, but then also sorting out how the state should respond when a protest implicates the rights of others. And so I think there is a wide degree of consensus on the value of protest in a democratic society. What becomes genuinely challenging is how the state responds in circumstances where parts or all of a protest become violent, where a protest interferes to some degree or to a substantial degree with the security and safety of others. And so I think the real challenge for decision makers, whether that's the state in the first instance or a court on judicial review or an inquiry reviewing these matters, is how do we do what Professor Mathin alluded to in her discussion of Section 1, which is how do we balance the competing rights and interests that are at stake in the context of a public protest. And to me, that's where the difficult work is.
Thank you, Professor McDonnell. Professor Moon?
Yeah, I think, and I know this, comes up in the various presentations, we have to recognize that any kind of protest is invariably disruptive. It will, to some extent, interfere with the ordinary use of spaces, people's ordinary lives. And so again, I agree, the challenge is to determine what is the outer limit of that? When does it become too disruptive? Either as a matter of how much space is taken up or how long it's going on or how confrontational it is. And there is no simple answer to that. I think that's the real problem. One can think of the Occupy movement, for example, which involved the establishment of encampments that were there for an indefinite period of time. At least that seemed to be the plan. Everybody accepted that it was an important protest and that there was a right to be located there for a period of time. But then the question became, well, how long is too long? And again, there's no simple answer to that question.
Thank you, Professor Moon. Part of the challenge of construing a Bill of Rights, such as the Canadian Charter, is seeking to identify the relationship between the different guarantees. And at times we see from the claims brought in court that there's a perception that multiple guarantees may be engaged by a similar set of facts. But nonetheless, conceptually, it can be helpful to try to distinguish the different guarantees. And in the discussion so far, we've been touching, I think, on peaceful assembly and perhaps freedom of expression. Does any panelist want to prepare us for the challenge of articulating or separating those two before we go into them one by one? Professor Cameron?
Well, I think that was part of what I had been planning to say. I can do it up front if that's preferable. So I guess I would say that the fundamental freedoms overlap and complement each other, and that you couldn't have a viable freedom of peaceful assembly without also respecting protections for freedom of expression, and I guess incidentally, freedom of association. So they work together and they have to all be protected. But I would also say that freedom of peaceful assembly is a distinct and independent guarantee that is not the same as freedom of expression. And so I can go into that in a tiny bit more detail. Freedom of peaceful assembly is a collective entitlement. It's an exercise of solidarity by a group of two or more individuals. The Supreme Court of Canada has acknowledged as much. It hasn't discussed Section 2C very much, but it has acknowledged that it is a group activity that is incapable of individual performance. So we tend to think of Section 2B, freedom of expression, as being an individual entitlement, and perhaps Section 2C is as well, but it's one that is exercised in collective, in a collective way as an embodiment. I think that also it's important to note about freedom of peaceful assembly that it has an embodiment and a presence that is usually spatial in nature. Not necessarily the case with freedom of expression. And then assembly is also, I'll use this word, it's performative in nature, in the sense that what you have with an assembly is more than verbal expression. And whether the assembly is passive, like forms of assembly can be completely passive, that can be the message. And assembly can also be active, and indeed very active. But what this tells us is that the act of assembling itself has a performative nature and a meaning that is not captured by Section 2B's freedom of expression. And therefore, it would be a mistake to collapse Section 2C and the right of peaceful assembly into Section 2B and treat assembly events as belonging under Section 2B rather than having their own independent entitlement. And so, from my point of view anyway, it's very important to separate Section 2C from Section 2B and begin the task of giving it definition and interpretation. So I don't know if others have comments on that. But.
Thank you. So you're, Professor Cameron, you're laying the groundwork for us to move in a moment to go a little deeper into looking at freedom of peaceful assembly, which, as you note, has been construed less by our courts than have others, freedom of religion, freedom of expression. At the level of the rights of democratic participation together, is there a final thought from anyone? Okay, so we're going to go back to Professor Cameron to pursue our reflections on freedom of peaceful assembly.
Don't worry, Dean Leckie, this is where it gets lively. Okay, so the Charter's guarantee of peaceful assembly has been mostly inert for the first 40 years of the Charter's interpretation. There's been very little in the jurisprudence, and apart from a mention by the Supreme Court that I noted a moment ago, has had very little interpretation or discussion at the Supreme Court level. And this might seem surprising, given what we've just heard from Professor Bird and others about the importance of public protests and public gatherings and their value as a form of participatory democracy. And I think it's clear that the Charter's fundamental freedoms and peaceful assembly do form a vital background to the Commission's work. So some may know that I did write a commission paper for the Commission on peaceful assembly. It's on the website. And the purpose of that paper, at least from my point of view, was to bring peaceful assembly into the conversation. And the paper, therefore, does not discuss the convoy or make any assessment of convoy activities, but its objective instead was to propose an approach to Section 2C. So here I think I'll quickly just make 2 or 3 points and then move the discussion back to colleagues who I know would like to weigh in on how we look at peaceful assembly. So I've already spoken about peaceful assembly as an independent guarantee of the Charter, and I've spoken about the importance of recognizing that entitlement and giving it its own place in the Charter. That was point number 1 in my presentation. So I'll move to the second point, and we heard about the structure of the Charter from Professors McDonnell and Mathen, and I think I'm going to start there because it's very important when we start to take a look at Section 2C. It's very important to have that structural framework in mind. And as Professor McDonnell told us, there are 2 steps in any Charter analysis. The first step is to look at the nature of the entitlement and to give that entitlement a definition or interpretation. And then the second task is under Section 1 is to determine what limits are reasonable, what limits on that charter entitlement are reasonable.
Professor Cameron, this is super valuable stuff. If you could slow down just a little bit, it would help the interpreters and the broadest audience you deserve for this.
My apologies. Should I go back over any of that?
But just
Okay.
tiny bit slower.
All right. So then looking at that structure reinforces the view that peaceful assembly, like the other fundamental freedoms under Section 2 of the Charter, should receive a generous interpretation. And so that means that questions about limits on peaceful assembly, for the most part, should be found and imposed under Section 1 rather than introduced into the preliminary definition of the entitlement. And in other words, peaceful assembly should be given broad coverage and limits to deal with disruption, disturbance, those kinds of issues should, for the most part, be reserved for Section 1. That's the setup and the nature and the concept of the Charter. So moving to Section 2C specifically, the central question under Section 2C, I think it's fair to say, is what is the meaning of peaceful assembly? What does it mean to say that an assembly is peaceful in nature? So what is peaceful under Section 2C and what is not? And I think there are going to be different views on this. And I'll just tell you a couple that I encountered in preparing the paper. And I'll say first that how you answer that question, how you decide what peaceful means for purposes of Section 2C will have dramatic consequences for the scope of the entitlement. So it's the critical issue under Section 2C. It is the critical issue for peaceful assembly, for that entitlement. So one approach to the question of what is peaceful equates peaceful assembly with nonviolent assembly. And under this view, assemblies are considered peaceful unless they engage in acts or threats of violence. It doesn't mean that limits can't be imposed under Section 1, but it means that an assembly has prima facie or preliminary status under the Charter as long as it does not engage in any violent activities. That's one view. It's not the only view. There's a different approach, sees it a different way, and would interpret the meaning of peaceful assembly quite differently. So under that view, an assembly is not peaceful or non-peaceful when it does any of the following, like cause a disturbance, engage in disruptive activity, engage in objectionable conduct, and even violate bylaws and other kinds of legal regulations. So on that view, an assembly would become non-peaceful when it reaches a sufficient threshold on any of these criteria. And under that view, it would mean that the assembly does not have any protection under the Charter. The difficulty with that view, in my opinion, is that it creates a risk of prematurely or preemptively shutting down public gatherings or demonstrations because they are considered or experienced as being objectionable in nature. And the risk is that the messages of the dissidents and vulnerable will be too quickly cut off. Now, we don't have a lot to go on in Canada. We do not have any Section 2B jurisprudence to speak of, much less a robust jurisprudence. But the international jurisprudence on these issues is quite striking, because under the international guarantees, peaceful assembly is protected up to the point of violence. And the issues about disturbance, disruption, commission of unlawful conduct, etc., are matters of limits under their version of Section 1 or proportionality, but not of initial entitlement. I'm going to mention a third approach, and I'm going to give a bit of a shout out to the City of Ottawa, who provided, the City of Ottawa presented a brief in response to my paper, and it's a thoughtful response. The City of Ottawa, as I understand their response, proposed a harm test for Section 2C. So the idea was that violence is at one end of the spectrum, disruption and considered still a form of peaceful assembly is at the other, and the city placed harm as a test sort of between the two. And the idea of it is that once a certain threshold of harm is reached in the activities of an assembly, that will forfeit the protection under Section 2C. So that was proposed as an alternative to these other two understandings of peaceful assembly. I guess I would say that it's difficult for me to agree with the City of Ottawa, although I think the proposal is certainly worth discussing. It's difficult for me to agree with that because harm is a very subjective and evidence-based concept, and it's better suited to the kind of analysis that is typically done in Section 2 cases under Section 1. So I would see a harm analysis under Section 2 as being out of keeping with the way Section 2 analysis is done generally in Section 2 cases. And again, a malleable concept of harm runs the risk of preempting assemblies that are engaged in participatory democracy. I'm coming to pretty much my last point about Section 2C, because I know we want to open the discussion up. And this is also a really important point, I think. We need to think about the relationship between the assembly per se and the individuals who are participating in the assembly. So I've mentioned that the assembly is conceptualized as a collective entity, but the collective entity, incorporates various numbers of individuals. The constituent participants in an assembly remain responsible for their actions. So, for instance, if members of a public demonstration or protest engage in unlawful conduct and even violate the criminal code, they are responsible in their individual right for their actions. They're responsible for any unlawful conduct they may commit. But generally speaking, and it's subject to evidence, of course, generally speaking, the acts of individuals do not taint or compromise an assembly, unless those acts become so pronounced or so pervasive that they come to define or characterize the assembly. At that point, they become the assembly, and that may change the status of the assembly under Section 2C. I think I've given us some things to think about. I'm going to make one final comment, and it is a little bit about this particular demonstration, but just to illustrate, I guess it would be my view that the Assembly in this instance began at the point when the convoy set out from British Columbia at the start of the convoy. Trucks were at that point integral to the Assembly, and it was for many days, it was a moving assembly. It was an assembly that moved across the highways in Canada before arriving in Ottawa. When it arrived in Ottawa, it became static and embedded. The trucks may still have been part of the assembly, but maybe their role changed. And maybe their presence in Ottawa changed and even escalated the nature and scale of the assembly. I think it would be fair to say, and I hope I'm not overreaching, Mr. Commissioner, I think it would be fair to say that the trucks compounded and intensified the disruption. But what I would say is that on a principled approach to the structure of the Charter, those issues inform the analysis under Section 1 rather than the scope of entitlement under Section 2C. And I have things to say about reasonable limits, but I think I've spoken enough and would love to hear from my colleagues.
Thank you very much, Professor Cameron. So just to situate your very helpful comments for the audience here, you were really focusing at defining peaceful assembly at the paragraph 2C level, basically bracketing for other discussion the question of reasonable limits on peaceful assembly under Section 1. And you were very helpfully, I think, focusing on the qualifying adjective peaceful, and it's 2C is distinctive in that the other fundamental freedoms don't have a qualifying adjective. So we have the right to freedom of religion with no adjective, freedom of expression, freedom of association without a qualifying adjective. So it's a real invitation to understand what that peaceful is doing there. And you've invited us to think about the three approaches there. I remember from our preliminary discussion with several panelists that there may also be questions about even what an assembly is and to what extent an assembly is focused on natural persons and appendages immediately within their control versus larger dimensions. But let's open things up. I think Professor Mathen, you had some thoughts to share on this one too.
I do, thank you. And I really enjoyed the policy paper prepared by Professor Cameron, and I just do have a few observations that build on the paper. So the first point is I entirely agree that we do need to recognize assembly as an important fundamental freedom in its own right, and particularly in the relationship with expression, while they overlap, they do reflect different components of a free and democratic society. To that end, though, when we think about assembly, as Dean Leckie has just noted, it does have this, what we call an internal limit, an internal qualifier, which is the word peaceful, which is not, we do not see that with the other fundamental freedoms, and so our analysis needs to take some account of that. In terms of looking at the right itself, while it often is associated with meaningful activity, I think we might want to be careful that we don't only see assembly as oriented towards conveying meaning, because it is a physical activity. It can be addressed towards some other goal that is not closely related to conveying meaning. For example, an assembly could be oriented towards protection of an individual or a place that is really its own goal, separate from any conveyance of meaning to other people. In terms of the word peaceful, I think here as well, it is important to recognize something that distinguishes assembly from the other fundamental freedoms, which is that it is commonly manifested in a physical way. So it is the coming together of people, and it is that physicality that historically, of course, has been seen as very important. But that also makes assembly different from the other fundamental freedoms. And so when we think of the limits on peaceful, I think that the borrowing from expression of the freedom of expression, but in addition, how we assess what the threat is, I think may require a slightly different vantage point, which is that I think it is useful to consider using an objective analysis of the threat posed by a particular assembly that may take it out of the protected sphere of being peaceful. So this is not dependent on proving the violent intentions of any one of a number of the members of the protest, which I think is first of all, can be extremely difficult to do, but also does not sufficiently engage with the nature of the protest as a whole. So this is not a numbers game. This is a very fact and context sensitive assessment of what the assembly is or is becoming. It might also be interesting to consider, just as there is a right against forced expression, is there a right against forced assembly? And again, because of the physical manifestation of assembly, are there circumstances in which people might be involuntarily brought into the context of the assembly? And this might particularly be the case where the nature of the assembly is such that it actually affects the person in their primary residence, so that in order to escape the effects of the assembly, they must leave their residence. Is there a question about whether you are in that context, perhaps dealing with involuntary or forced assembly? Dean Leckie noted the very interesting question of what the actual fundamental freedom includes in terms of whether it is just human bodies or other things. And that, I think, was very much brought out in the current situation that we're considering. And the one point I would make there is that, and this is not, I would think, as to whether the assembly is peaceful, but whether it is actually a protected exercise of assembly. We just want to be careful that we don't overread the right of assembly so that it privileges those who have more resources to effect an assembly that becomes more difficult to control. So I would just perhaps suggest that that might be something to think about. And then finally, when we get to the justification section under section 1, certainly the state should be cautious about simply dispersing an assembly. I believe in international law that is seen as a last resort. But in some contexts, dealing with the assembly more rapidly may actually create the space for maximum enjoyment of the right of assembly going forward, as opposed to, because of this very, I think, appropriate reluctance to interfere with the assembly, what you wind up producing is a situation of an entrenched assembly that then has to be dealt with in a much more intrusive way. So I'll stop there.
Comments from other panelists at this point? Professor Moon and then Professor Bird. Professor Moon.
Okay, thanks. Just a brief comment. Professor Cameron's paper is a terrific paper and really outlines a very strong argument. I want to take not exactly issue with it and some of what Professor Mathen has said, sorry, I almost got that wrong. And I want to kind of reassert that what I think is a significant overlap between the different rights. It's really important to remember when talking about freedom of religion, for example, it has a collective dimension. It protects religious rituals, manifestations of religious practice, often which occur in collective form. And so it does have a physical dimension to it in that sense. And the same could be said about freedom of expression. Expression occurs in a variety of ways. I'll say something more about that in a minute. But it's always physical, even in the most minimal sense of using one's vocal cord, but more often involves much more than that. So I want to re-emphasize that all of these rights have a physical dimension to them. All of them have a collective dimension to them as well.
Thank you, Professor Moon. Professor Bird.
Just a couple of quick comments. Thank you, Professor Mathen, Professor Cameron, for all the comments so far. In listening to more recent remarks, it does seem to me that this addition of this adjective of peaceful, I've so far drawn to this notion that perhaps the drafters are trying to point us to, in a way, what it doesn't protect. And in that, just thinking of the kind of natural antonym of peaceful being violent or violence, so it doesn't protect violent assembly. But I need to think more about this, and the comments are making me think more about that. One thing I would also note that this approach has been suggested by the City of Ottawa, perhaps using harm and as a kind of a way to assess whether the assembly is protected or not. It does seem to me that, at least just from an application perspective, that determining what's violent as opposed to non-violent seems to be a bit more manageable or easier to identify, perhaps, than harmful versus not harmful. So even from in addition to the kind of just the linguistic, the text, what it may be pointing us to what the protection does not cover. I'm also drawn to the notion that harm is just indeed has seemed to be a very difficult or can be a challenging concept to apply, whereas violent versus non-violent seems to be maybe a bit of a brighter line. But I just wanted to mention on the Section 1 standpoint, this idea of limiting peaceful assembly, just given what has been said so far about the value of assembly and protest to democratic participation, one of the lesser kind of interpreted phrases in Section 1 is this idea of a free and democratic society, this notion that all rights and freedoms in the Charter can be limited when those limits are prescribed by law, when they're reasonable limits, and then finally when they're demonstrably justified in a free and democratic society. Perhaps this discussion also invites us to think more about what that phrase, free and democratic society, especially the democratic part, means in terms of, does that somehow animate the threshold or the bar which the state needs to reach? And even the word free as well, given that that word points to, has a particular resonance with freedom in the fundamental freedom. So just maybe thinking a bit down the road of our discussion of Section 1, that phrase of free and democratic society seems to potentially have a lot of, may have much to say, or a lot to say in this context. I'll just pause there.
Professor McDonnell's next, and then we'll go to Professor Cameron. Professor McDonnell.
Just a short point on this question of reasonable limits on freedom of peaceful assembly. I think in thinking about reasonable limits, it will be helpful for us to try to move beyond what I think is a very common binary in our thinking about protests, which is you either allow the protest to continue or you shut the protest down. And one of the important components of the Section 1 analysis is to examine whether a limit on rights is minimally impairing, whether it impairs no more than is required to meet its objective. And it seems to me that there are, points on the spectrum that our discussion often fails to capture. And so you do see, if you look at the very little bit of case law that there is on freedom of peaceful assembly in Canada, that one option is to allow an assembly to continue during specified hours or under different conditions than the assembly, than the conditions that originally surrounded the assembly. And so to me, this sort of moves our discussion away from either full protection of this right or sort of full violation of this right to a space where we can consider, is there a way to still give meaningful effect to freedom of assembly while also recognizing that, as Professor Moon said, as time goes on, if there are elements that are potentially violent or, highly disruptive to the safety and security of others, are there options there that still allow for substantial preservation of the right?
That's very interesting, Professor McDonnell, given the Professor Cameron's point that dispersal is the absolute last resort, right, but it's not the first mode of intervention. Professor Cameron.
Yes, just thank you, Dean Leckie. Just a couple of follow-up points. On the issue of acts or threats of violence, I think that it's helpful to think about the nature and the level of the threats, to ask where they're coming from, who is making those threats, if any, and how pervasive they are. Because the threats will typically be made by individuals rather than the assembly. And, the entitlement belongs to the assembly. So we have to be careful not to treat levels of disruption as threats in and of themselves, because to do so risks excluding certain assemblies and gatherings from Section 2C and not granting them any charter protection at all. So I would always argue that those kinds of limits can be imposed under Section 1. So it's evidence-based, whether there are threats, whether they're sufficient to compromise assembly. A second point has to do with Dean Leckie's observation, and I guess a discussion we had at dinner last night, which is what exactly is the assembly and what kinds of props that may be used or by an assembly are included in the entitlement. And so we specifically had a question about trucks last night and whether they are part of the assembly. But there are other kinds of examples, of course, so that assemblies choose the way and means that their message can be effective. So they will typically, or they may use all different kinds of props, and they can be quite innocuous in nature, the props that are used by assemblies, but they can go all the way down to the use of weapons and so forth. So the question there is, to what extent does the right of peaceful assembly include the choice of means and the choice of props and structures, including not just camps and entitlement and tents and camps and so on, but things like trucks. And a final point just has to do with the relationship between Section 2C and Section 1. I think, you know, we may have reasonable disagreements about whether the work can be done under Section 2C or whether it should be reserved to Section 1. One of the reasons I support the Section 1 approach is that, for the reasons that were just mentioned, that it's not an all or nothing kind of a calculation. There may be ways for an assembly to continue in a proportional way with the imposition of limits that carefully balance the rights of the community. I think I'll stop there. Thank you.
Thank you. Professor Mathen.
Thank you very much. It's just a brief point to just to clarify perhaps the issue around threats of violence. And I just want to be clear that I am here talking about violence against the person. So the classic criminal understanding of violence against the person. So that is interference with people. Those are the kinds of threats I was talking about, not other forms of disruption. But there can be, on an objective basis, an assessment that the nature of an assembly creates a reasonable generalized threat to people who are within the immediate vicinity of that assembly. It will be very much fact specific.
Thank you. It's also interesting to grapple with the question, at what point do individual members of the assembly start to characterize the thing as a whole, such that we feel that the assembly itself is involved in conduct of that nature. One of the questions submitted in advance to us concerns specifically Canada's Indigenous peoples. And so I wondered if panelists had thoughts on whether the fundamental freedoms of Indigenous peoples differ from those of others, particularly when they involve social movements seeking to promote recognition and respect for traditional territories, lands, and resources. And a more specific form of that question, should the charter protections for assembly and protest be interpreted consistent with the rights of Indigenous peoples? And is Section 25 of the Charter any help in this regard, so that limits imposed on those fundamental freedoms do not restrict Indigenous peoples from obtaining redress for historic and ongoing violations and denial of their rights? Anyone wanting to take that one on?
I can just say a
Professor
few words.
gov't.
If we look at the case law of the Supreme Court, for example, on freedom of expression, we realize that when the court looks at Section 1 and at the justifications that are invoked to defend some measures, potentially restricting freedom of expression, it's a context-based analysis which takes into consideration particular situation. Example, the cases involving the Charter of French Language in Quebec. The analysis that was made by the Supreme Court was responsive to the particular context of the French language in the province of Quebec. So under Section 1, I don't see why cases involving the fundamental freedoms of Aboriginal people should not be treated in the same sensitive way. Canada is a very diverse country, and in many cases, the Supreme Court has clearly taken into consideration differences. For another case involving Quebec, where the particular regime of and history of labor relations in the province was taken into consideration, absent this consideration of the particular context of the province, would the decision have been the same? I don't know, but being context sensitive, as the court has been in its application, its interpretation of fundamental freedom, and the evaluation of their reasonable limitation, is part and parcel of our case law and of our constitutional law. So I don't see any fundamental problem in being context sensitive to the claims of Aboriginal people and their rights.
Thank you, Commissioner.
Yeah, I just want to, not on this last point, but go back to a point that Professor Mathen was raising, and that's about peaceful assembly and the question of whether it's a matter of violence or threatening. And I think threatening is very relevant if in this case, because we heard a lot of evidence about people who felt threatened by the fact that there was all this gas around and they were scared for their life, arguably. There were people who would not walk to work because they felt threatened. And there were businesses who closed because of the threat of mask removal and so on. So leaving aside whether those facts are established or not, which is a dispute, and leaving aside really whether that's a group of individuals or not that were causing it, I'm quite interested in exploring a little more of that concept, because whether that means it's a Section 1 or whether it's the assembly is peaceful. And I think the peaceful is if violence is the only thing that makes it non-peaceful, that's one thing. Although I don't think that's a big limitation, given that violence is illegal per se, and when is the assembly violent would be hard to define in any event. But so that would be helpful for me, and because I think that's part of the concept that is being developed.
Thank you, Commissioner. And just before we go back to the panelists, I would just add to that, if I might. I'm wondering if anyone else wishes to take up Professor Mathen's suggestion that at a certain moment, an assembly is actually conscripting other people into participating in it by being, in their neighborhood all the time or something like that. And so we know in other contexts that one is not allowed to impose one's religion on others, that one has a certain right not to be in an association. And so I'm wondering if anyone else finds it helpful as a distinct question from whether violence has occurred to say at a certain point, I have no choice but to be part of this assembly. And does that help us see a limit on the right to peaceful assembly? Now, Professor McDonnell was already on my list, and I see Professor Cameron will follow her.
I was on the list for a slightly different point, so perhaps I'll just cede my time to Professor Cameron.
Professor Cameron?
Okay, so just a couple of points, if I can read my writing. Thank you, Mr. Moderator. So I think there's a difference between threats of violence being made and the community's experience of feeling threatened by the presence of a gathering or a demonstration. And so again, in the spirit of not preempting a fundamental charter entitlement, I would say that that experience of feeling threatened can definitely be addressed. And there's nothing to say that it doesn't allow limits. But my view would be that that belongs under Section 1 rather than Section 2. I think also, again, with second point, I'm not sure this is responsive or not, but it's a messy situation, isn't it? Because you have an assembly that can be sort of inchoate, and you don't really know what is the who is the assembly, what is the assembly proper, and who are the interveners, and to what extent is the burden on the state and authorities to separate out those who have gone rogue or engaged in their own activities of unlawful conduct? I think that's a difficult question. Again, the concern would be not to preempt the entitlement needlessly unless the evidence permits a conclusion that the assembly has itself attained violent dimensions. And then a third point was about being conscripted, but I'm going to pass so that others can speak.
Professor Bird, then Professor Mathen.
Maybe just on the conscription point, or imposing one's assembly on another, it does seem to me that the built into the protection of the guarantee is this notion of kind of voluntary assembly, of you wanting to be your own free will and not under duress or not coerced or conscripted, being a member of that. So I think the notion of not imposing one's religion on another in terms of the freedom of religion context does seem to have a lot of purchase here as well. On the question of threats of violence, strikes me that if an assembly is occurring and it's public and the authorities are aware, of course, can monitor for prospects of violence. Is there a point at which the threats of violence have transformed into where the violence is inevitable? The authorities know that it's going to occur. Maybe they have intelligence that they know that it's going to occur on start at a certain date and time, or they have very strong evidence or objective grounds for that. You could arguably say at that point that maybe it is now no longer peaceful, such that it's no longer captured by the guarantee. Alternatively, it could be seen as still being peaceful because the violence hasn't yet started, and any kind of intervention, which might well be justifiable to avoid what is violence that is forecasted to start, would be indeed a limit on a still peaceful assembly, but one that would be considered under Section 1. So I'll just pause there.
Thank you. Professor Mathen.
Thank you. I think a really important point about freedom of peaceful assembly and I take Professor Moon's point that there are aspects that are common to all the fundamental freedoms, but linked to Professor Bird's discussion of democratic participation is the very important component of mutuality among citizens when they are confronting the kinds of issues that arise that will be the subject of some exercises of peaceful assembly. And so that mutuality, I think, is very important. And it's in that context as well that it becomes important to assess the overall nature of the assembly, which may be very messy, which may have inchoate or unknown leadership, which may have multiple assemblies. But from the objective point of view, that doesn't make it impossible or indeed remove the need to arrive at an assessment of what the assembly is and the potential risk of interference or level of interference with other citizens that, again, takes it out of that umbrella of being a peaceful assembly protected by the Charter, consistent with the underlying norms and purposes of the Charter that warrant this constitutional protection.
Thank you. Other thoughts from the panelists? Professor Cameron.
Just one tiny point, which is what Professor Mathen is speaking to, I think, is the coercive properties of demonstration in certain circumstances. And I guess I'm just thinking through, and I don't have anything further to say at the moment, but there may be a difference between something that is sort of a coercive presence versus a threatening presence. And, you know, it's a point to sort out.
Thank you. Professor McDonnell.
One small point just in making this, you know, sort of factual assessment of the nature of an assembly. I think that that social media makes this more difficult in some ways, because Professor Bird talked about, you know, what police intelligence might be available. Is there national security intelligence that's available? You know, I think there's also this question of how the protest is understood in the public, in the media. And on social media, there is the potential for a small number of leaders to really to be the face of a protest. And so I think one of the challenges in trying to make this objective determination is, you know, what matters? Is it what's happening on the ground? Is it what the, you know, the police information tells us? Is it what seems apparent on social media? And, you know, in many ways, democratization of social media has been very positive. I think it can also, though, perhaps like skew our assessment one way or the other, frankly, in terms of trying to characterize the assembly as a whole. And given that this plays an important role in determining the scope of constitutional protection, I think that that is something worth reflecting on.
Professor Bird, just building on Professor McDonnell's point, I think that's very important. The kind of social media face, or the media face of a assembly versus the true, that's potentially different kind of situation on the ground, or perhaps the skewing effect that you talked about seems a very important factor. And I just wanted to qualify my remarks a little bit before when I said that if threats of violence are risen to the level of now they're going to be inevitable, the violence is going to occur or is expected to occur, it may not be that it animates the entire assembly. Maybe that, you know, out of an assembly of 1,000 people, there is evidence that 5 people, whatever the number might be, a very small percentage themselves, are going to kind of go rogue, so to speak, and enter into violence, while the rest of the assembly has no interest in that whatsoever. So that's another part of the conclusion as well, is, you know, do you then have a more individual kind of focus and holding those individuals accountable and saying that the assembly still, by definition, is still peaceful? Or do you say that it's now become, in the grand scheme of things, unpeaceful or non-peaceful assembly across the board? So that's another consideration to bear in mind. Thank you.
Thank you. Commissioner, have we provided some help on the question you asked?
Yeah, some help, but it's still, I'm still troubled. I mean, to put it more dramatically, or more sort of black and white, at sort of 10 o'clock on the Saturday of this demonstration, certain people have said it's an occupation. And so my question is really directed at that, and leaving aside whether that's a fair characterization, but a neighborhood was occupied. The police, to a large degree, were not pressing any charges, were not pursuing any complaints by the citizens of that area, and arguably there was no real violence in those areas that was reported. Let's assume that. So that's really my question, is you have an occupation of a neighborhood as opposed to a park, and you have people who legitimately, let's assume, and they've testified they felt threatened. You can't point to any violence. Do you have to go to Section 1, a reasonable limit, i.e., which is, I think, what Professor Cameron says, or is there something about peaceful assembly? No, you can't. It's not a peaceful assembly to occupy a neighborhood and basically where police can't enforce because they'll be swarmed. Again, you might say it's a few individuals, which no doubt it is, but I think that's a factual finding I may have to find, but it's, when I look at peaceful assembly, is that something that is that is peaceful. But again, I thank you for the comments, but I wanted to point out really what is a critical element in this is that occupation, as it's been described, where it's been said it's a lawless neighborhood in which people live, and no suggestion, let's say, of violence.
Thank you. The occupation question is one challenging thing. Last night in the discussion some of us had, there was also disagreement indeed over whether honking at a certain point becomes an assault. And there is a physical dimension. Your body can experience noise if it's loud enough and sustained enough. And there are all kinds of norms around construction work and so on that recognize the impact on the person. Does that itself become unpeaceful at a certain moment? And I don't think of it as a political ideology, but whether you were in Ottawa last winter seems to affect a little bit how you approach some of these issues where conceptualizing and fact meet up. Professor McDonnell.
I was just going to add that one of the things that we have been discussing and will continue discussing in this conversation is the extent to which, because, as Professor Cameron points out, there is so little case law on freedom of peaceful assembly. When we're looking elsewhere for guidance, one of the places we tend to look is at the way that the court has addressed other fundamental freedoms. And here on this question of violence or threats of violence, the freedom of expression jurisprudence has moved from saying that, it's only physical violence that is sort of excluded from freedom of expression where there is communicative content, to including threats of violence. And so in terms of thinking about what the scope of peaceful assembly would be, my sense is that's a fairly strong authority for treating both threats of violence and actual violence as being not peaceful for the purpose of 2C. My sense is the question that comes out of some of the submissions of the parties and from some of the material that Professor Cameron canvasses in her paper is there something more than that beyond threats of violence? Is there something about disruption, inconvenience that also would take a protest outside of the scope of being peaceful? My impression, though, and perhaps this isn't shared by the panel, is that it would be surprising if a right to peaceful assembly did not take account of threats of violence, and that this standard for rendering a protest not peaceful is actual physical violence. I think that would be out of keeping with the kind of the freedom of expression jurisprudence and the direction it's taken for much the same reason, informed by much the same rationale as one would see in the context of peaceful assembly.
Colleagues, we're doing this collectively. We've spent longer on this issue than we'd expected, but I think it's valuable. So, Professor Moon, I'm happy to go to you next. We're all cognizant that this is shrinking a little bit freedom of expression, but I think this has been very fruitful so far.
I'll say very little.
Please continue.
I wanted to kind of work through the notion of occupying a neighborhood a little more closely, because if what we're talking about are public spaces, public properties, the streets, for example, as opposed to private properties, then it strikes me that there is at least initially a right to protest in those spaces. Obviously, the residential character of a particular neighborhood can certainly and should play a role in determining what's a reasonable on that. It's one thing to parade down a street in a residential neighborhood demonstrating. It's another to remain there for an extended period of time, to honk horns and whatever. And it strikes me that that's very much a question of what are the reasonable limits as opposed to something more basic.
Okay, so thank you very much for the exploration of freedom of peaceful assembly. We're going to turn now to freedom of expression, paragraph 2B of the Charter. We've already had the suggestion that there's continuity in the sense of potentially a collective and a physical dimension to this guarantee as well. But we're going to continue with Professor Moon.
All right, so I now have 2 minutes is what you're telling me.
No, you're good.
All right, well, thank you. I'm very pleased to be included in this. I almost feel like I should begin with an apology to the translators because I haven't often spoken to parliamentary committees, but on the few occasions I have, I've invariably been told to slow down. So I will at least try to begin. All right, so Section 2B of the Charter protects freedom of expression, but more fully, it protects freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. But I am going to simply speak about freedom of expression. It's generally understood that it matters, it's important as a fundamental right of freedom because it's necessary to the I know, it's, passion. It's necessary to the operation of a democratic form of government. It contributes significantly to the development of truth or the growth of individual or collective knowledge. And it's important to self-realization. I would add, though, I think it's important to keep in mind that freedom of expression doesn't just protect individual liberty in the sense of the individual's kind of personal, private space. It protects a social activity. It protects the right of an individual to speak to others and to hear what others may say. It's a social activity that invariably involves the use of collective resources, whether that be the parks, the streets, or the internet. And I think that's important to keep in mind. All right, the scope of freedom of expression. It protects communication, something along those lines. And what our courts have said, it protects any activity that is intended to convey meaning or a message to others. And I think it's worth noting that the court illustrates this with the example of parking against the rules. So ordinarily, if you park contrary to whatever the rules may be, presumably you do so because you don't want to pay, whatever might be the cost of doing so, or you can't find a convenient spot. But, says the court, if you park against the rules in order to protest in some way, then that counts as expression. Now, that suggests a fairly broad understanding of expression. In principle, any act can be an act of expression if performed with the intention of communicating a message. It also means that any law could, in theory, be a restriction on expression if it happens to restrict the way in which someone has chosen to express themselves. Now, the example given by the court refers to parking. Maybe it's convenient that we're thinking of cars, but we could, of course, think of other vehicles as well when thinking about acts of expression. As Professor McDonnell earlier referred to, the court, though, recognizing the potential breadth of the scope of this right, has said that it doesn't include acts of violence. That's what they said initially, and then subsequently said, and it doesn't include threats of violence as well. So if an act involves, doesn't exclude advocacy of violence. I mean, that can be dealt with under Section 1 potentially, but from the scope of Section 2B, it only excludes acts that have the form of violence. So a terrorist act, some kind of physical violence directed at another, and threats to do so. All right. So the court has said that picketing, advertising, hate speech, obscenity are all fall within the scope of Section 2B, but of course are subject to reasonable limits under Section 1 of the Charter. I won't say anything more about Section 1 because it's been very well covered already. But maybe one thing worth noting is the court said with regard to freedom of expression, when we move on to Section 1 and considering limits, although all these different forms of expression are protected, some have more weight or more value than others when we are considering limits. So, for example, political speech, it's core value speech, is closely, says the court, connected to the values that underlie our commitment to freedom of expression. And so it has a high value. It will be harder for the state to justify its restriction. On the other hand, hate speech, obscenity, commercial advertising are less directly connected to these values, and therefore it may be easier for the state to justify its restriction. Okay, I wanted to quickly talk about three issues, free speech issues that might be worth considering. One of them is hate speech. And in Canada, hate speech is restricted under certain human rights codes, not all of them, and at the moment, not under the Canada Human Rights Act, but that may change at some point. And it's restricted, of course, under the Criminal Code, under Section 319(2), which prohibits the willful promotion of hatred against the members of certain identifiable groups. There are two kinds of harms that we can connect to hate speech. One of them is the harm directly experienced by members of a target group. Threats, intimidation, harassment, for example. And most of the US cases are about that kind of harm. The other kind of harm is the spread of hateful views within the larger community. So that some in the community may be persuaded by others to take a particular view about members of the group, with the result that those who hear these views may adopt more hateful attitudes or may even take action against the members of targeted groups. And most of the Canadian cases have been concerned with that kind of harm, with hate speech laws directed at that kind of harm. And our courts, in a number of cases...
But 2 minutes left.
Okay, I'll get there. So our courts have been willing to uphold these restrictions on hate speech, focusing primarily on the fact that the laws are very narrow in their scope, focusing on speech that is extreme, that's understood as vilifying the members of particular groups. Okay, I'll say no more about that then. Another issue that seems relevant is the question of the right of individuals to access government-owned property in order to communicate. I wrote about this fairly extensively in my background paper, and so I'll just boil it down to this. Our courts have said that there are really two kinds of state-owned properties. There are what might be called public arenas or public forums, properties that by tradition or in practice are generally open to the public for communication, and individuals have a prima facie right to enter onto those properties in order to communicate. Obviously, their expression can be restricted for a variety of reasons, but those reasons are not simply that the state owns the property and can exclude someone from it. And then there are other properties to which individuals don't ordinarily have the right to enter onto and communicate, and they are described as paradoxically sometimes private forums or something like that. And the state doesn't have to justify the exclusion of expression from those properties. So we're talking about government offices, broadcast facilities, properties of that kind. And then I guess finally, I just wanted to say a little bit about social media and the changes that it has brought to our thinking about freedom of expression. I think one change is speech that previously was not considered harmful, at least to a degree that might justify its general restriction, we now may be viewing differently. For example, disinformation or deceit, of course, has been subject to very particular restrictions in the past, false advertising, defamation, and so forth. But it has become such a large problem, I think we are having to think increasingly about whether or not there need to be larger restrictions or interventions on this form of speech. And I think the same could be said about speech that's insulting or harassing. It takes on a different character online when so many people can pile on, or it can be persistent, or the insult or harassment can be widespread and endure in many ways. And then finally, I just want, my final remark is to say, of course, what social media also means is that the traditional legal responses to these harms are increasingly impractical. They're too slow, they're too cumbersome to really address these. And that's why there is much more thought being given to how social media can itself be engaged in taking this material down. And that brings a range of different challenges.
Thank you. Thank you. And social media, and disinformation will come back a little later this week. Professor Gautreau-Desbiens.
Yes, thank you very much. For the sake of time, I will speak directly to one issue that Professor Moon raised, which is that of disinformation, false news. And since I had written my notes in French, I will switch to French. Alors, je veux simplement rappeler. This has always been a challenge.
Avec vous.
Now, we must keep in mind that the very notion of fake news is ambiguous. It covers very different realities. We could be talking about hyped representations that are satires. It could be lies. It could be representations that are knowingly invented with a view to deceive. We know that in 1993, the Supreme Court invalidated a provision penalizing fake news, and the origins went back to the Middle Ages. At the time, the court said that the freedom of expression criteria often deal with opposition between the majority opinion about what is true or right and a minority and unpopular opinion. By putting into practice this relativism, which is behind liberalism, Judge McLaughlin at the time said that the freedom of expression is a guarantee that's intended to protect the minority's rights to express an opinion, even if it's an unpopular one, et cetera, et cetera. So she was seeing in justifying the invalidation of the criminalization of fake news a way of protecting minority opinion. So that's the law. Now, we have to understand that Canadian law does not impose any truthfulness obligations upstream to whoever is expressing themselves. And it's important to say that in the legal discourse here. It's only downstream, after the fact, that the law can deal with people who don't tell the truth in very prescribed circumstances and hold them responsible for their fake words, for example, reputational harm. Now, something that's very important to point out here, I think, is that the expressive ecosystem in which we have been developing for the last 20 years with the internet, with the rise of social media, this is no longer the same context as the one in which we lived for 150 years. And so that other ruling was made in the old world before the rise of the internet. And what a great French sociologist, Pierre Savala, said, the age of defiance versus the age of trust. So if we're going to continue to take seriously the Supreme Court's concerns regarding the complex nature of fake news, we must at the same time take cognizance of the fact, as Professor Moon said in his policy paper, that the framework is somewhat dated. This could be a bit of a Trojan horse, which would impede the truly complex apprehension of this new normative ecosystem. In fact, the ability to mobilize and take action with respect to disinformation strategy is now separated out so that any analysis of a demonstration such as what the Commission is looking at cannot really avoid making recommendations about what provokes upstream these sorts of demonstrations and what will provoke other protests. As my University of Montreal colleague Pierre Trudeau said, the various categories of fake news do not all give rise to the same interventions, but the ability to distinguish satire deals with promotion, comes from a strategy to promote the improvement of internet users' ability to read. But voluntary falsification of information could be dealt with by more stringent regulations. But we have to understand how social networks work through algorithms, which are protected by trade secrets. And these are the very basis for the business model of social media. And so we know that this creates bubbles, information bubbles, which do not create a shock of ideas as classic freedom of expression theory would want. They are instead making silos between information universes, which are different. So there should be a limit potentially on social media operators' transparency requirements. Constitutionally speaking, of course, the court would have to do this in due course. I think it's important to revisit the framework for dealing with fake news, perhaps through the recognition of special status for what Harvard Professor Vicki Jackson called knowledge institutions, such as universities, museums, government statistics agencies that deal with the government at arm's length, courts. So these are social actors whose main objective is to analyze or develop, depending on what their particular goal is, to make reliable information filtered according to proven and verifiable standards. And even if we say that the distinction between facts and values is no longer as separate as it has been in the past, we must think about these issues. Now, I am afraid of saying that our constitutional law in terms of freedom of expression needs to come into the 21st century because maybe we're not there yet. The world has changed. Perhaps we need to review, even if it's based on very solid foundations, perhaps we have to review this sort of angelism which inspired it and which made us believe that ultimately the truth would triumph or could triumph. I'll stop there for now. I had many other things to say about, hate propaganda, etc. Well, okay, I'll say something about it. 30 seconds. I'm sure that Dean will allow me. Criminalizing hate propaganda in Canada is done through identity variables, stigmatizing groups defined based on a particular identity, gender, sexual orientation, race, ethnic origin, etc. In our society, political polarization is exacerbated, and we see a lot of this traditional hateful propaganda. But there's always also the radical stigmatization, the virulent stigmatization of the people who are participating in the government activity, whether they're elected officials or whether they're part of the executive. These people are victims of virulent and often hateful attacks on social media because of their duties. And these are duties within democratic institutions. So there again, I think we have to question these issues. It's not the commission, but rather the framers of the legislation who are going to deal with these issues. But this expressive ecosystem is all upstream and is very different from what there has been in the past. And that is going to favor the emergence of social movements, which may sometimes be violent. They won't always be, but they will mobilize people. And sometimes they may lead these people to do things collectively that could ultimately subvert democracy. I'll stop there. Thank you very much. There is some intersectionality here, because if you're talking about women in public service who are more often victims of these sorts of attacks, yes, factually that's been proven, that members of racialized groups who are in public service or women have more violence against them. Thank you very much, Professor de Gaudeviens.
And we have one more topic still, the relationship between the Emergencies Act and the Charter. So if someone has literally 2 minutes or less further on freedom of expression, I would be delighted to take it. But we collectively spent longer on peaceful assembly. Freedom of expression, a final intervention.
Obviously, everything was said that needed to be said, clearly.
Okay, thank you very much.
Could I take a moment to say that what was raised by Professor Bird intersects what Professor Gaudreau-Desbiens is saying in terms of tolerance. of a protest? Do we have to consider the message that's being conveyed through the protest? And what about the consequences? Because we've heard in evidence that the message was encouraging threats, a lot of threats towards women and politicians. So I think that's a question. It would be useful to me if you have any other comments to make about that, or perhaps to do that later on. Is it legitimate to consider that if expression is disinformation?
Panelists, is there an answer? Short answer for the Commissioner? Professor Gautreau-Desbiens?
D'abord,
well, as I've already mentioned, in the current state of the law, disinformation is allowed, and it's protected by the Constitution. And this is what the legal framework has. So to stigmatize messages would be a source for contesting because if the Parliament were deciding to pass legislation, let's say, in its areas of jurisdiction for communications, let's say, to tighten the constraints, and if this would in fact lead to hierarchization of information to give demonstrably true facts to come through more than fake news and disinformation, well, that in and of itself would likely be challenged. My thesis is that ultimately the traditional approach of which courts have adopted all over the place, in other words, being neutral with respect to the content, that's something that I think we have to call into question. We're not there yet, but I have the impression that we're moving in that direction. The maintenance of democratic spaces, which are the very essence of our constitutional effort, also have to be considered. There's a quote that I very much like, which is a classic in American constitutional law from Judge Jackson in 1949 in Term in Yellow. This was about freedom of expression. He said,
and liberty, it is between liberty and order, with order, and anarchy without either. There is a danger that if the court does not temper its doctrinaire logic with a little practical wisdom, it will convert the Constitutional Bill of Rights into a suicide pact. Et d'une certaine façon, je pense qu'on doit réfléchir.
I think, in other words, we have to think about the perimeters of the constitutional guarantees of the Canadian Charter in light of the fundamental value, which is democracy, which leads to freedom of expression. It's one of the underlying values. So if we're looking at the institutional continuum of rights in the Charter that are guaranteed, there's also the right to vote. Elections, at least every 5 years. And then somebody was asking about occupation. What's the kind of message that we want to be sending? If there's a radical change in regime, well, that's politics. The Canadian Charter is only 40 years old, and already we're looking at how some of it seems to be outdated.
And we have literally 5 minutes. So Professor Bird will share perhaps a comment or two on the relationship between the Emergencies Act and the Charter. Professor Bird.
Thank you, Dean Leckie. So in these comments, I just want to kind of intensify or amplify the radar with respect to how the Charter and the Emergencies Act converts. And so most of the commentary on the federal government's use of the Emergencies Act this year has focused on whether the circumstances in Ottawa last February amounted to a public order emergency. In other words, whether the federal government was legally entitled to invoke the Act. And this is, of course, a very important question for this commission, but it's also not the end of the story. This inquiry is tasked with investigating the circumstances that led to the declaration being issued and the measures taken for dealing with the emergencies. So even if the invocation of the Act was lawful, what about the legality of the measures that followed? This question looks beyond the issue of whether the federal government either this moment or any other moment in history can lawfully invoke the act. It certainly engages a downstream issue of whether measures taken after invocation fall within the scope of powers granted by the text of the act. But the legality of these measures also implicates foundational considerations within the Canadian legal landscape. It invites us to think about how the Emergencies Act converses with the Canadian Constitution, and in particular, as we've been discussing today, the Canadian Charter of Rights and Freedoms. And so it could be perhaps tempting to think that the Act, given its substance and purpose and the stakes, transcends or somehow transcends the Charter. Put differently, if the federal government concludes that a given situation satisfies the criteria that permit recourse to the Act, its invocation, some citizens, maybe even the government itself, might slide into thinking that practically anything goes in responding to the emergency and that the Charter need not be consulted. But this way of thinking would be incorrect. The starting point is that every instance of state action in Canada must comply with the Constitution. To the extent that an instance of state action is inconsistent with the Constitution, the action is null and void. And this principle applies with equal force to the Emergencies Act, both in terms of the substance of the Act, its text, and decisions taken by government pursuant to it. The preamble to the Act actually refers to the Charter, noting that the federal government would be subject to the Charter when exercising powers granted by the Act. Now, to be clear, the Charter would still govern the use of the Act, even if the preamble did not mention the Charter. And as for why Parliament included this reference, perhaps it was intended to help us avoid that headspace described earlier, where the Act is somehow perceived as beyond the reach of the Charter. Now, it seems fair to say that in general, the substance of the Act does not unjustifiably limit Charter rights and freedoms. What I mean by that is that legislation that permits the state to take temporary but severe action to deal with extreme situations, insurrections, terrorism, and so forth, will certainly or almost certainly interfere with various charter guarantees like the ones we've been describing or discussing today. Even so, most, if not all of us, can agree that those interferences in those extreme situations would often be justifiable under Section 1 of the Charter. But matters become more complicated once the federal government actually invokes the Act and has recourse to the emergency powers at its disposal. Now, assuming for the moment that the circumstances on the ground satisfy the definition of a national emergency in the Act, it would be incorrect to suggest that each and every use of the powers in the Act that follow invocation will inevitably or automatically comply with the Charter. Even if an emergency as contemplated by the Act exists, each emergency is unique in nature. The federal government must therefore ensure that its use of emergency powers, depending on the features of the emergency at hand, limit charter rights and freedoms in ways that satisfy Section 1.
Thank you. Thank you very much. So we now have a little pause where we look at some questions, and then we'll come back for a final, much shorter session. Thank you very much, panelists.
The Commission is in recess for 30 minutes. La Commission est levée pour 30 minutes.
Hey folks, give me a second here. Wow, I just had an amazing phone call. Azario, other people that know what was going on in Burlington, things got real. I got a witness. The next renter, he's in Alberta. He's got pictures. It's over. I'll get to that another time. Okay, so that's an excellent start, right? I'm actually kind of glad that we're doing this now. There's another stage of roundtables, and there's a bunch of different topics that they're going through, and we're going to be hearing a bunch of different opinions. I saw somebody in the chat ask if they're under oath. No, I don't think so. They're not under oath, and that's okay. These are all just opinions. These are roundtables. This is to flesh out ideas and things like that. So I'm cool with what's going on. I'm hearing some things that don't make me happy. I'm hearing some things that make me happy. I don't like the idea of redefining violence in any way, or threats and then harm, these different stages of things. And they're trying to kind of maybe apply that under the broad definition. These kind of things might fit. But yeah, I'm not really concerned about what's happening, because these are all just opinions at this point. So that was the end of the first one, called Fundamental Rights and Freedoms at Stake in the Public Protest and Their Limits. This next one is the financial governance, policing, and intelligence. So it looks like what they're doing is a morning and afternoon roundtable, and there are various topics. And what we'll do is tomorrow, when we're doing the stream normal again, when I start at 9 a.m. Eastern time and then have the half an hour before it starts, I'll go over some more of this. Today is going to be a real condensed version, as we're just going to be jumping and skipping through the breaks so we can get caught up as quick as we can. So on that note, let me queue up the afternoon session and we'll get going.
The one we wanted to address most importantly, I think.
One moment, here we come. And we'll address all of the comments at the end. So I am starting a bunch of stuff, so we'll definitely get to things again like we normally do. But it will all be at the end. And then I got to get back to an email.
Canadian Charter of Rights and...
Okay, here we go. Bring it back in. Push play.
Freedoms prevented them from, say, stopping the movement of trucks into parts of the city. And so we're curious if there are thoughts on how the Charter, and this is combining, I think, Section 2 and Section 1, so the Charter as a whole. I mean, would police have been able to stop truckers from driving through zones that were zoned as no trucks? Would the Charter have allowed police to stop people parking their trucks? Might the Charter have been satisfied if people were told to, park here and we'll bus you over to a different zone where you could gather?
Rights of trucks.
Wondering if you have thoughts on those.
Go ahead.
Okay,
Professor Moon will start.
I'll attempt that. I mean, I guess I have to preface any answer to that question with really what I think came out in our discussion, and that is people have the right to protest. Protest invariably involves some disruption of ordinary property use, and the question always is, what are the appropriate limits? And it's accepted that municipalities, for example, can put in place different kinds of restrictions, even notice requirements. You're going to have a large protest to inform the police or municipality in advance that you intend to do that. So I think the short answer is, I think they probably could do those things. They could say, no trucks parked in this area, no trucks can enter into this area. But it has to notionally at least be justified as a reasonable restriction on the right to protest. And certainly it strikes me, this is easy to say in hindsight, that it could easily be understood as reasonable, given the amount of space, the pollution, the noise, and so forth that a truck could generate. So again, the real challenge, and I don't envy those who have to make decisions here around any of these questions, is that ultimately it is a very practical determination to decide how much disruption, how long, and so forth. And it would not, to my mind, be unreasonable to say trucks in a space like this is a significant disruption, and the protest can happen, but it's legitimate to exclude trucks from it.
Professor Moon, if I could just follow up. You were talking about reasonable limits and so on, which is evoking the idea of a limit prescribed by law and so on. Do you think like existing no truck zone bylaws or whatever form those rules take, would that have been enough as the legal basis for the police to interfere with what they perceived to be the exercise of the democratic rights?
Without kind of having a sense of what the array of existing rules are that could be drawn upon, I think the answer might be yes, but I don't know enough about what the bylaws would be.
You're hedging your bets a little bit.
I am, absolutely.
Yeah, thank you. Professor Mathen and then Professor Cameron.
So I think it's also fair to look to past practice, and it is true that in the past there were protests and assemblies that did involve trucks, but they did not stay. And that seems to have been part of the landscape in which law enforcement was operating, but there was also information indicating that they intended to stay. And so had they taken that to be a real statement of intent that would pose a different kind of enforcement problem, then I think that would be the basis on which you could absolutely seek to prevent that mode of assembly. Again, it comes down to what does the fundamental freedom actually entail, but certainly given the scale of the vehicles and the information that was widely circulating about what was the intent for those vehicles, at a minimum, yes, you could in that context reasonably restrict them from proceeding in the way that they wanted to the positions where they wanted to place those vehicles.
I'm wondering if Professor Cameron has a different point of view.
I'm not sure what my point of view is, but I would just observe that in Toronto, I believe I'm correct in saying that the trucks were stopped from coming into downtown Toronto. And so the same kind of situation never crystallized in Toronto. As for Ottawa, I would say there's a significant difference between a flow-through demonstration, so where the trucks flow through in a day or 2 days and the trucks stay, as to whether and when they could be stopped. I'm not really sure. I would worry a little bit about prior restraint kinds of concerns. Were all trucks to be stopped and never given any opportunity to come into the capital city and make any kind of demonstration? I would worry a little bit about that, but it's an awkward situation, obviously, because once the trucks are there and they come in, the enforcement issue arises very quickly.
Professor Bird.
Just very quickly, just zooming out a bit, just strikes me that often other protests, thinking of marches where people are walking in the streets, maybe even kind of stopping in a city square or an intersection, oftentimes protests will involve abnormal use of a space. Normally people don't walk down major boulevards in mass, usually it's cars, and usually they'd be on the sidewalks instead. Sometimes that, maybe even some cities, I don't know the array of bylaws, maybe even walking on streets, marching in streets might well also breach bylaws. So just to say that kind of abnormal use of public space for the purpose of protest seems to be quite common, but I agree with all the comments so far as well, very important.
So the factual question of whether there was prior notice of an intention to park might well be very significant as one thinks this through.
So, I mean, just to take this point to the next level, so there seems to be consensus that once trucks are parked illegally and are asked to leave and don't leave, would the assembly then become illegal, or is it an assembly that then is in violation of Section 1? Here they were allowed to park, so, and then they were asked essentially to leave and they didn't leave. So that's, I guess, that's the general view.
Well, so much to turn
Professor Moon.
as what the legal authorization would be to remove, and presumably there would be a variety of rules that would permit that. And then the question is whether that would be justified. And I think the consensus would be, particularly in this circumstance, it would be.
Professor Cameron?
Simply to add that on the question of reasonable limits, there are a number of variables. And as for the assembly itself, the general principle is that the assembly needs to be allowed to have an opportunity to present its message. So whatever that reasonable scope of time is, I'm not sure on the facts of this convoy, but then at a certain point in time, it becomes unreasonable for the vehicles to stay. So I think that's a fairly safe assessment.
Thank you, Professor McDonnell.
Just to say that I think this comment about the point, the moment in time is quite important, because actually the requirements of justification under Section 1 may well be shifting as the situation evolves, right? And so this is, my colleagues, Colleen Flood and Brian Thomas have done some very helpful work on, in an emergency, in a situation like this, what is the court's response, or what's the response, of the state it has to be connected to what's actually happening, what the facts are. And so that includes, like the situation and what's justifiable in the first 24 hours of the protest will be different than what's justifiable in week 1 and week 2, when you start layering in significant disruption and concerns about, the health and safety of others. Like this shifts the complexion of the justification analysis. And so actually that element of time is quite crucial and changes sort of what's permissible, right? And that, also changes the state's obligations, I think, right? So at the beginning, there's very little information about a fluid situation. The government has to make a call. They have to act, and they're entitled to act on the best information available to them. And they may not get it perfectly when they're trying to balance the interests of the community. And I think cases like Irwin Toy, which Professor Mathen you adverted to without naming the case, but it's also in Professor Moon's paper. They're very clear that in these complex situations, the government is entitled to act without full knowledge, sort of in good faith. But as time goes on and more information becomes available, then the situation can change. And sometimes the state is under an obligation to kind of adapt its initial assessment of the situation. And the situation can change, and sometimes the state is
The idea of this sort of changing situation, it's very interesting. It takes us a little bit off the initial question of the police, whether they were entitled to sort of stop the trucks before they came in. Commissioner, have you heard enough about the trucks?
No, I'll hear more about trucks over time.
We had another sort of specific question about the charter and what it requires of us. So the emergency measures regulations included a prohibition, as you'll know, on public assembly. A person must not participate in a public assembly that may reasonably be expected to lead to a breach of the peace by the support of the threat or use of acts of serious violence against persons or property. And it also said that a person must not travel to or within an area where such an assembly is taking place. So persons prohibited from entering the area where an assembly might, reasonably be expected to lead to a breach of the peace. Are there views over whether these rules in the regulations would appear to be, reasonable limits on charter rights? Professor McDonnell?
I mean, I'd be very curious to hear the thoughts of others, but it strikes me, at first blush that type of provision might well be might be overbroad, right? And so Section 7 of the Charter provides that individuals have a right to life, liberty, and security of the person, and a right not to be deprived thereof, except in accordance with the principles of fundamental justice. Now, to the extent that those provisions prohibit individuals from being in an area at all, they may, one of the principles of fundamental justice is that laws may not be overbroad, right? They shouldn't capture more people than the objectives of the provision are aimed at. And so it may well be that that's the kind of provision, that provision wasn't sort of sufficiently tailored. That's a possibility.
Thank you. We got Professor Mathen and then Professor Cameron and Professor Bird.
So I think in considering this question, which on its face, it does look to be overbroad, it is important to consider the very definite time limits in which the Emergencies Act operates, which is essential to its core feature. And that will factor into whether in the circumstance that kind of prohibition is in fact overbroad. I would also point out that with respect to the prohibition on travel, I believe it was accompanied by a series of exceptions.
Okay.
Yeah.
That
Exemptions, yes.
And were those criminal?
Exactly.
Were those criminal prohibitions?
Professor Mathen, just a second.
The exceptions?
There's exceptions, and we're asking whether those are criminal.
Yeah, they're offenses.
They're offenses under Section 10 of the regulation. Professor Mathen, did we cut you off? Did you finish?
No, I just wanted to say that there was some tailoring of the specific travel, the precise mobility restriction was also accompanied by exceptions. It doesn't obviate the fact that some people would have been prevented from travel, and that was indeed the very intention of the regulation.
Thank you. Professor Cameron?
Thank you. Just a discrete point, which has to do with the designation of protected places and the potential over-designation of protected places, in particular Section 6F that allows any other place to be designated as a protected place by the Minister of Public Safety and Emergency Preparedness. I just have some concerns about that provision and its consequences for public assembly and other charter rights, including freedom of association, those who might wish to associate with a valid, viable assembly. Thank you.
Thank you. Professor Bird?
I was just going to say that, thank you, that the constitutionality of those regulations might also be informed by just the nature of the emergency. They could be overbroad for the reasons stated by my colleagues on its face, but given the nature of the particular emergency in which they're being applied, it may not be, just depending on the actual application, just what's on the ground. And so maybe on its face, potentially some overbreadth issues, but depending on the nature of the emergency, it may end up not being perhaps an overbreadth issue at the end of the day once it's actually applied. Just a thought there.
Professor Bird, do you want to explain a little more? I mean, if someone were to bring a constitutional challenge to the enactment, they'd be challenging the written down rule.
Sure, no, absolutely. Thank you for that. I think that it may well be that a part of the analysis might be that given the nature of what's at stake in a potential invocation of the Emergencies Act, what the Act is meant to deal with, assuming that there's been a lawful invocation, public order emergency, public welfare emergency, et cetera, that might well inform whether the regulations that have been put to us are overbroad as well. So it's just the fact that we're dealing with an emergencies legislation, I think it also needs to be brought into the picture as to whether that overbreadth actually pans out. But I do also share the concerns of my colleagues that needs to be brought into the conversation too.
Thank you.
You can move on if you'd prefer.
Professor Moon, were you wanting to jump in?
I really just wanted to first reiterate what Professor Mathen said, I keep saying. And that obviously the temporary nature of it makes a difference. And secondly, I imagine a certain degree of deference is going to be given in a situation where rapid action is understood to be necessary. And obviously when we call it emergency response, then we would understand rapid action to be necessary. So it is obviously on the face very broad and would just in isolation be troubling. But I think those factors certainly would have to be taken into account.
Thank you. Okay, so we're going to move on. Is that okay to the next question?
Yeah, I guess we can. I guess one of the questions is, and maybe that's the overbroad that you commented on, but who makes the determination that it might lead to serious interference, et cetera? And because that's the it's not clear to me, but that may be the answer, as Professor Bird said, that it's by its nature, because it's temporary and it has to be broad.
But there's a potential rule of law issue in the sense that there's a rule: you must not participate in a public assembly that may reasonably be expected to lead to a breach of the peace. How do you know when a particular assembly has met that threshold such that you're prohibited from going there? There are real questions about that, right?
Yeah.
Professor McDonnell?
I don't want to drag on the discussion, but there are actually just two very small points that I think are relevant to this overall discussion. One is that violations of Section 7 are very rarely saved under Section 1 of the Charter. So once established, they're very rarely found to be justified. But to the extent that the courts have suggested that there's an opening for finding Section 7 violations to be justified, it's in an emergency situation. And so, one of the things to recognize might be that we may acknowledge that on the face these laws were overbroad, but this very important context that my colleagues have been speaking about is relevant under Section 1 in terms of understanding whether, a degree of overbreadth, which would normally not be permissible, might in a specific context where a declaration of emergency has been made in a time-limited way be found to be justified. And so that, I think, is important. The other quick thing, though, that is maybe in tension with this is, as my colleague Professor Bird pointed out, the Emergencies Act is pretty clear that the Charter continues to apply. And so there is a bit of a tension. All Charter analysis is contextual, does take its color from the circumstances, and here the emergency is part of the circumstances. But to my mind, that type of argument also has its limits because the Emergencies Act specifically keeps the Charter in play. And in fact, the model of emergency control that we have adopted incorporates the Charter as an important safeguard. And so to me, that means, I'm glad I'm not the one making the decision, because there's a tension in there.
Well, and that's why I raise it, is at the end of the day, when much of the concern is that the act is so broad and powerful, but on the other hand, it is Charter compliant by its very nature. So the answer to questions such as this one are important because it arguably affects the initial decision, because the degree of, or you could argue certainly that the degree of interference with the Charter should be taken into account in the initial determination of what the threshold for an emergency is. And I don't think they're detached, but I'm not sure, and that's why I'm curious about the response from you.
Other thoughts on this one? Professor Mathen?
Just because the question was raised, who's the decider, I just want to point out the interesting separation of powers issues that arises here, because initially you have an executive branch determination, but it is in very short order subject to legislative oversight and the opportunity in various ways to contest that. And so referring to what Professor Moon said, the zone for deference here to the decision being made in extremis, literally, is something that I think could be useful to consider.
Thank you. So we'll take a crack at another question. And counter protests are in the question here. So we're wondering, you've got someone protesting or an assembly is protesting, and then there's the prospect of a counter protest that could bring violent confrontation. And so we're wondering, does the kind of realistic prospect of a counter protest that will perhaps issue in violence, does that make the initial protest violent, or attach a threat of violence to it? Professor Cameron.
Thank you. In researching the paper, I encountered quite a bit of commentary on just this point in the international jurisprudence and so forth. And basically the position that's taken in that jurisprudence is that the authorities have an obligation and a duty to protect the primary assembly in those circumstances, so that where a counter protest presents itself and poses risks to the viability and the safety of the principal assembly, is the duty of authorities to deal with the counter protest and protect the assembly, which is an interesting point of view. We don't have much guidance in Canada, but that's what I found when I was researching the paper.
Thank you very much. Other colleagues on that one? Professor,
it's hard.
Well, I think that this position is quite sensible and reasonable, actually. The duty that is imposed upon the state to protect the first assembly, while not prohibiting counter-protesters to express themselves. So you can imagine a situation where police officers create a kind of corridor between the two, but it's a rather onerous burden. But still, both must have the ability to express their views while taking into consideration this duty to protect the first assembly.
And perhaps Professor Cameron, I mean, so I hear you saying what you're saying in the literature. If the initial protest is seriously harming or threatening the livelihood of the potential counter-protests, does that in any way change their position?
Well, if there are, if there are difficulties with, we'll call it the primary assembly, then those can, if that's what you mean, then those can, of course, be addressed.
The primary assembly is blocking a bridge that is shutting down the workplaces of the potential counter-protests, so like they're not just people expressing a different point of view. Does that change it?
Sorry, they both might be subject to regulation, so we wouldn't rule out the prospect of reasonable limits on the primary assembly, but the counter protest would still be subject to limits in so far as it is confronting and escalating the situation with the primary assembly. That would be my view.
Commissioner, anything?
No, I think to put it a little more directly in context, it's suggested, for example, in Windsor that the road should be opened up and people's livelihoods was affected by the road being closed. And let's assume that counter-protest wanted to open the road, to put it more concretely. And so they would be, in that case, the police would be preventing people from carrying out their legal right to proceed through the road, for example. It's a little more complicated, I think.
It's not, yeah, that's not exactly counter-protest, I guess, in the sense it's an attempt to exercise what are considered to be the right to move and drive. Because certainly the starting point is everybody has the right to protest, or counter-protest, and so forth. And then the challenge always is, if it looks like there'll be conflict, to what extent can the police manage that? And only in exceptional situations where it's just unmanageable, given their resources, could it be shut down. But the starting point always has to be both sides. But that's an interesting and challenging question about my right to exercise my ordinary mobility that is directly coming in conflict with what the protesters are attempting to do.
Thank you. We're out of time, so we're going to stop without moving on to the fascinating question of separating the acts of individuals from the Assembly as a whole, which we might otherwise have come back to. Thank you very, very much for your contributions.
Thank you. It's always fascinating to debate these subjects, and it's very useful for me to listen to the submissions and to hear what the questions of participants are. Thank you.
Commission is in recess until 2 o'clock. La commission est levée jusqu'à 14 heures.
Questions of
All right. Okay, let's go ahead and fast forward, folks. I'm about to have my lunch, and you guys can continue. And I hope you're enjoying. Here we go. What's this?
And although Canada's system appears quite robust, it is actually very...
All right, folks, it's a weird day. We're getting the hang of it, but here we go. 1 second. There we go. Thank you.
The commission is reconvened. La commission reprend.
Hello.
You're in charge. Thank you. Alors bonjour à toutes et à tous. Je m'appelle Patrick Leblond. Je suis le modérateur de cette séance. So I'll be moderating this session. Alors, je vais animer cette séance sur la gouvernance financière, les services policiers et le renseignement. Privileged today to have 5 experts, 4 in person, 1 person online. Premièrement, j'aimerais introduire Michel.
Let me introduce Michel Camin, who is a professor at the University of Laval Law Faculty,
who is president and principal consultant at Insight Threat Intelligence. She is also the president of the Canadian Association for Intelligence and Security Studies. Then Michel Galland, the Faculty of Law at the University of Manitoba. Then we have Gerard Kennedy, who is an assistant professor also at the Faculty of Law at the University of Manitoba. And finally, Christian Leuprecht, who is the class of 1965 Distinguished Professor at the Royal Military College of Canada. He is also the director of the Institute of Intergovernmental Relations in the School of Policy Studies at Queen's University. And he joins us online from Germany, if I'm correct. So, la façon que ça va fonctionner.
This is the way we're going to proceed. The expert panelists will make presentations, maximum 15 minutes, after which there will be a discussion, which I will be moderating. And after the break, we'll have another series of questions and answers.
I would like to start with, in terms of the order, Christian. Are you ready to go?
Merci de l'introduction. Vous m'entendez?
Thank you for the introduction. Can you hear me well? Very well, thank you. Thank you. I will be speaking in English, but I can take your questions in the 2 official languages.
Mission with a submission that figured prominently in the final report released in June 2022. Invoking the EA is symptomatic of deficiencies and shortcomings reported by the Cullen Commission. I also published a recent book on intelligence as democratic statecraft across the Five Eyes countries that includes substantial information on financial intelligence, and I have a forthcoming book on financial crime in Canada. So let's look at the typology here. This was not money laundering or tax evasion. The phenomenon that we have is probably closest to terrorist financing. There was an immediate use value to funds provided. The purpose for which those funds were provided was ambiguous. It wasn't clear whether they were being withdrawn for legal or illegal purposes. Small donations can have a relatively large impact, and in this case can also serve as a proxy for the extent of public support. So let's think about this. A G7 country with the world's 10th largest economy had to invoke the EA in part to get a handle on some crowdfunding that was in part sustaining some illegal activity. What does this tell us about the adequacy, effectiveness, and efficiency of Canada's financial regime? Within Canada, money laundering is currently governed by 15 different laws and regulatory instruments. At the federal level, Canada currently has 12 agencies tasked with AML enforcement and prosecution, while there are approximately 14 within each province. In February, this sizable financial crime policing apparatus was unable to achieve the necessary strategic effect without the EA. That casts a long shadow over the purported efficacy of laws, regulations, and agencies. And although Canada's system appears quite robust, it is actually very weak. So weak, in fact, that Transparency International has ranked Canada at the bottom of G20 countries. What are the implications? First, the inadequacy of legislation, regulations, and agencies. Key allies can achieve the same strategic effect without invoking emergency measures, because their legislation, regulations, and agencies are actually up to date and properly postured and funded. Second implication, the inadequacy of the posture of Canadian agencies. Expert federal agencies and their financial reporting entities couldn't get it done under existing rule of law powers. Third implication, at least a perception, if not a reality, of the unequal, inequitable, idiosyncratic application of the rule of law. That is, crowdfunding played a role in blockades of critical infrastructure and other environmental protests, for instance, that crossed into the line into civil disobedience, illegality, perhaps criminality, including disregard for court injunctions. But no extraordinary measures were taken to stem financial flows to these groups. So the impression, when the government is sympathetic to protesters and their cause, it goes easy on them. When the government is not, it will go to extraordinary lengths to shut them down. That impression, if not the reality, undermines the very premise of constitutional democracy, that the rule of law applies equally to all citizens, to thwart precisely what we're witnessing here, the tyranny of the majority. Fourth implication. In February, the Prime Minister wanted foreign money funding illegal protests in Canada to stop. Minister Mendocinos remarked about the number of contributions and their sheer size. But CSIS testified before this very inquiry that it found no foreign actors funding the protest and told the government that back in February. So, did the government engage in deliberate misinformation on foreign funding anyway? Implication 5. Compare the Prime Minister's preoccupation with foreign funding of a relatively small but tenacious protest in Ottawa with its government's inaction on Chinese foreign influence in Canadian elections and democratic institutions, Chinese police stations in Canada, and sanctions on Russia. Words in Canada speak louder than action. In the UK, 19 billion pounds in assets have been frozen. In Belgium, 52 billion euros. In Canada, 122 million Canadian dollars. It would appear that dirty Russian money in Canada is not a priority. But 20 million raised over 3 weeks entirely from Canadian sources for protest by Canadians warrants invoking the EA? There are two ways to read this. The threats to Canadian democracy are as real from within as they are from without, or that it's okay for US, Chinese, and Russian money to interfere with Canada's democratic processes and interests, just not for Canadians with Canadian money, especially if they're opposed to the federal government or its policies. 6 implications. Donors came from across Canadian society, including prairie farmers. They've now seen how the government is prepared to go after people and their assets should they fund a social movement that is opposed to the current government or its policies. The unintended consequence? They've restructured their assets to put them out of reach for government and moved support for controversial social movements online onto cryptocurrency, which makes these financial flows less visible and harder to track. So the EA has had perverse incentives of making work much more difficult for intelligence agencies. The conclusion, was it really worth to invoke the EA? So how did we get here? And what does it tell us? First, financial intelligence in this country is embarrassingly weak. FinTrack is an outlier among
Le CANAFE est marginal. Il n'a pas de capacité d'enquête, le droit de demander directement de diverses identités des renseignements financiers et le droit de geler des transactions douteuses. Le CANAF est un type de FIU passif parce qu'il vise les divulgations passives soumises par la police. Le Canada a un rapport de reddition de comptes qui est très coûteux pour les banques. On conclut que les organes d'application de la loi de la province ne peuvent pas compter sur le CANAF pour produire des renseignements en temps opportun. Et le renseignement criminel est la posture inadéquate des agences d'exécution de la loi. Il est impossible de suivre la responsabilité. En 2018, par exemple, la GRC a confessé publiquement qu'elle n'avait aucune expertise pour mener des enquêtes sophistiquées sur les entreprises. 86% des accusations portées entre 2012 et 2017 ne se sont jamais rendues devant les tribunaux parce qu'elles ont été retirées ou suspendues. Il y a eu de très bons exemples en la matière à Vancouver et à Toronto. En 2020, la GRC a dissous sa division en Ontario parce que les priorités ont changé. Ensuite, les lois faibles. Un exemple. Depuis au moins 2002, on a recommandé que le gouvernement adopte des lois
obtain and disclose information concerning client billings to government regulators. The step is thought to be necessary to guard against the use of lawyers as willing or unwilling dupes who are being paid with crooked dollars. In peer reviews, VADF has highlighted the ongoing non-compliance by 2 countries that refuse to abide by the disclosure recommendation: Canada and the United States. Fourth, weak penalties. For instance, KPMG, one of the world's big 4 accounting firms, had set up an aggressive tax plan that they marketed to high net worth individuals who lived mainly in British Columbia. In March 2016, the CBC published reports that indicated the CRA had entered into overly generous settlement agreements with taxpayers. One unhappy taxpayer went to the media with their complaints. But part of the controversy surrounded the fact that no sanctions were ever levied against the tax advisors, the accountants, and the lawyers who set up and then marketed the plan in the first place. What does this tell us? That Canadian national security, including financial intelligence, is not fit for purpose for the 21st century. What's the government's response? It announces seemingly ambitious but essentially unquantifiable and vague policy to root out corruption, increase regulatory oversight, tackle the opioid crisis, make housing more affordable for ordinary Canadians. Compare that to the government's determined commitment and response to counterterrorism. By contrast, the EA and Cullen are a measure of the government's inattention to financial crime. How then to explain the disconnect between the Canadian state's avert commitments and its failure to deliver on such commitments? Because there is no political or corporate will. The message is, don't ask, don't tell. Especially the Panama Papers and the Paradise Papers findings, as well as the 2020 Tax Justice Network figures, suggest that Canada is not unduly worried about the cleanliness of financial flows, whether from immigration or from investment. There's a mix of activities that are illicit, for example, capital flight and business investment, illicit, for example, white-collar crime and tax evasion, and on the fringes of legality, for instance, aggressive tax avoidance and trade-related malpractices. Having spent decades building a reputation as a haven and global shelter for illicit gains, the government does not have the intent to slaughter its golden goose. Invoking the EA sends a clear message. This is a one-off measure to contain a controversial social movement that is causing the federal government at the time political headaches. Purveyors of dirty foreign money and their enablers need not worry, because Canada isn't about to change its regime or its mantra. Canada is still open for dirty money. The Cullen Commission confirmed what we all already knew, that the Canadian financial regime works very well for criminals and the ultra-rich, to the detriment of the middle class and everyone else. The message in invoking the EA: if you're a criminal or ultra-rich, you need not worry. In short, the justification for invoking the EA, that instead of building a financial regime that's actually fit for purpose for the 21st century, temporarily invoking the EA was far more expedient. Merci.
Thank you.
Christian.
Thank you very much, Christian.
Now I would ask Jessica Davis, please. 15 minutes.
I'd like to begin by thanking the Commission for inviting me to be part of this roundtable. I believe that this inquiry has a critical role to play in making Canada safer and more just. Today, I'd like to share 4 main points with you. I want to first address the issue of foreign funding of the convoy and why that was so contentious for Canadians. I will then discuss the issue regarding regulating crowdfunding platforms and some of the costs and benefits of this approach. Third, I want to raise the issue of unintended consequences of the global anti-money laundering counter-terrorist financing regime and Canada's role in that. And then finally, I'll discuss the role of asset seizure in response to a protest. I'll conclude with a brief set of recommendations. Before I get too far into this, though, I do want to emphasize one point. During my comments, I'll be talking about money laundering and terrorist financing. This is the context of Canada's anti-money laundering counter-terrorist financing regime and changes to FINTRAC's legislation and regulations. I want to be clear, though, that the convoy protest financing falls outside of definitions of both money laundering and terrorist financing, which is part of why some of these amendments were made. So let's talk about foreign funding of the convoy. As we saw from this Commission's work, the majority of the convoy was not foreign funded. There were some foreign donations, particularly to the crowdfunding campaigns, but the majority of the money distributed to the convoy protesters came from Canada, either from the online campaigns or through email money transfers or through cash donations. The uproar around potential foreign funding began early, as soon as people began to see other people who self-identified as from outside Canada donating on those public platforms. These donations raised the issue of potential foreign influence, both overt and covert, relating both to the funding of the protests as well as potential artificial amplification of convoy-related messaging on social platforms. Many Canadians expressed surprise that this was permitted under Canadian law. The strong reaction from Canadians about foreign funding of the protest, real or imagined, is an opportunity for Canada. It tells us that Canadians are concerned about this, and that for many, the idea of foreign countries or foreign individuals being able to contribute funds to political causes in Canada is unacceptable. We should take this as an opportunity to scope and legislate limits to foreign funding in Canada, including potentially limits on contributions to political causes, limits to donations to politicians, even outside an election cycle, and the creation of a registry of foreign agents. This would go a long way towards assuaging the concerns of Canadians about foreign entities, clandestinely, deceptively, or even overtly seeking to influence Canadian politics. I now want to briefly touch on the issue of crowdfunding campaigns and their regulations. The inclusion of crowdfunding platforms as reporting entities under the Proceeds of Crime, Money Laundering, Terrorist Financing Act was a somewhat curious response to the convoy. It was curious for a number of reasons. Because one of the platforms had already taken action to remove one of the main campaigns due to potential breaches of terms of service rather, because many of the funds were already frozen, because much of the funding of the convoy wasn't even happening through those crowdfunding campaigns, but rather through those email money transfers and cash donations, as well as payments for expenses like hotel rooms from individuals not present in Ottawa. And finally, because the decision was also made to freeze those individual accounts at the same time. It remains unclear what the regulations were meant to do or how they helped bring about an end to the convoy protest. The regulation of crowdfunding campaign platforms created new reporting entities for FINTRAC. But I question whether it actually created a new source of financial intelligence that could be used to counter the protest or other potential threats to the security of Canada. Prior to the Emergencies Act, for example, some of the funds from the crowdfunding platforms would already have been reported to FINTRAC by entities already regulated under the Act, like banks, when those transactions reached reporting thresholds. Aside from those mandatory reporting thresholds, most of which have already been covered prior to the emergency measures, the new regulation of crowdfunding platforms requires these platforms to now file suspicious transaction reports. But in the context of a crowdfunding campaign, I struggle to see how these entities will report suspicious transactions, particularly when that reporting is limited to suspected money laundering or terrorist financing. As an aside, crowdfunding platforms are not widely used for either of these types of financial crimes. Instead, when we see crowdfunding platforms being used for this, or crowdfunding rather, it's primarily off-platform campaigns. So basically social media calls that are more widely used, which of course falls outside the scope of the regulations. And back to the issue of creating new reporting entities for FINTRAC, this means that FINTRAC now needs to ensure that they comply. Adding more reporting entities without significantly enhancing FINTRAC's ability to conduct compliance exams, for example, is a missed opportunity. Last year, the Centre completed 151 compliance exams, but there are tens of thousands, I believe 24,000 reporting entities. So this regulation might not have achieved much, further stretched FINTRAC's compliance function, and contributed to over and duplicative reporting to FINTRAC. And there's little point in creating more regulations without simultaneously enhancing FINTRAC's ability to ensure compliance. I'll move on to my third point, which is a little bit more about the unintended consequences and global implications of this. The international regulation of crowdfunding platforms. So since the convoy, there have been other calls for global standards to regulate these platforms as part of the global counter-terrorist anti-money laundering efforts. But these, again, are not based in much evidence of use of these platforms for illicit purposes, but instead represent something like low-hanging regulatory fruit. At a recent No Money for Terror ministerial conference, the host country, India, called for further regulation of the sector, something that Canada is now leading the way on internationally, for better or for worse. As countries and multilateral bodies continue to regulate more and more sectors under these global anti-money laundering counter-terrorist financing rules, it's important to keep in mind that there are plenty of unintended consequences of these efforts. For instance, authoritarian regimes often use these laws and regulations adopted to conform to these global norms to crack down on dissidents in their own countries. As my colleagues from the Royal United Services Institute recently noted, these laws are used for a number of things, including politically motivated pretrial detention, targeted audits, and asset freezes. Canada is now leading the way on regulating crowdfunding platforms, something that can easily be misused by authoritarian states, all under the guise of compliance with international norms. And that regulation has been adopted without consultation, public analysis of costs and benefits, or even an articulation of what it's meant to achieve. I'll move on now to the role of asset freezing, seizures as a response to the protest. This is probably the most contentious element of the emergency measures because it directly targeted Canadians and their financial well-being without judicial authorization. The freezing of accounts and financial assets in Canada is usually done with judicial authorization. This is no small measure. When accounts are frozen, there are serious efforts not only for individuals directly targeted by the asset freezes, but their family, employees, and business associates. There are serious implications for individuals who might not be able to pay mortgages, child support, rent, groceries, etc. At the same time, when these measures are used in a targeted manner, they can be highly effective at encouraging people to cease and desist illegal activity and can facilitate a peaceful resolution. However, the way these emergency measures were implemented raises a number of issues. The main issue was in the identification of individuals whose accounts should be frozen. While the RCMP provided a list of influencers to financial institutions were also enabled to use their own internal processes to identify individuals whose accounts should be frozen. When such extraordinary powers are used, there should be a clear list of individuals to whom these measures apply. Deputizing banks to make their own determinations about freezing of accounts created the possibility of mistakes, uneven application of measures between banks, and allowed the spreading of misinformation that further fueled anti-government sentiment. The emergency financial measures served as a lightning rod for the convoy protesters, enhancing their distrust in government and lacked sufficient guidance, oversight, and transparency. While the measures might have been a justified and proportional response to the Ottawa occupation and border blockade, something for this commission to consider, their implementation raises serious concerns. Let me now conclude by summarizing the recommendations that I've mentioned in this commentary. So there are a number of issues that I've raised here today that require legislative, regulatory, or other policy responses to make Canada safer and more just. So I recommend that we limit foreign funding of political activities in Canada, both overt and covert, through legislation, including a registry of foreign agents. I further recommend that the Government of Canada undertake consultations on crowdfunding regulations and any future expansion of the Proceeds of Crime, Money Laundering, Terrorist Financing Act, specifically with an eye towards unintended consequences and setting of international norms. These are powerful tools that are easily misused in the wrong hands. Canada should also enhance its ability to examine the compliance of reporting entities under the regime. Our compliance regime is already stretched, and adding more reporting entities does not improve this situation. And finally, any future use of the Emergencies Act and financial measures should include provisions to clearly specify the scope of financial targeting, enhancing transparency around that financial targeting and reporting, and direct financial institutions in a more concrete way. Such sweeping financial powers should not be left to individual financial institutions' judgment. Thank you very much for your time today, and I'm pleased to answer any questions you have or expand on any of the points I've made.
Merci beaucoup, Jessica.
Thank you so much, Jessica. So let's carry on. Now I would like Michelle to take over. Yes, thank you, Professor Leblanc. So I'm Michel Kamel. My expertise is mostly in the rules of private law applicable to crowdfunding, and indirectly, I'm also interested in the governance of online platforms offering crowdfunding services. My intervention will focus on the following three elements, which come from the expert report that I prepared at the request of the Commission on the Emergency Act, which is published on their website. Firstly, private law applicable to crowdfunding in the form of donations. Secondly, the political and sometimes subversive character of certain crowdfunding campaigns. And thirdly, the scope of new measures intended to subject crowdfunding platforms to the provisions of the terrorist activity financing legislation. Firstly, private law that is applicable to crowdfunding in the form of donations. Donation-based social crowdfunding actually creates relations between three categories of actors. First of all, those in charge of the project who launch the crowdfunding campaign and who often manage the funds. Secondly, the donors who contribute to the crowdfunding campaign. And finally, the beneficiaries to whom the donations are destined. The person in charge of the project could be a physical person, a corporate entity, or a more informal group that sometimes doesn't have a legal existence. For instance, I could create a group called Freedom 2022 and launch a crowdfunding campaign by saying crowdfunding 2022 as the project leader. As to the beneficiary of the project, it could be people who can be named and designated, or it could be a group of people more or less defined, or it could even be just a project or a cause. For instance, the group Freedom 2022 could launch a campaign intended to pay the expenses of Luc Tremblay, who was arrested during the trucking convoy. In that case, the beneficiary is a person who is named and designated, or the Freedom 2022 group could launch a campaign with the goal of financially supporting all the truckers who took part in the convoy. The beneficiaries would therefore belong to a more or less well-defined group. And finally, the third possibility, Freedom 2022 could launch a crowdfunding campaign with the goal of supporting the creation of a movie to report the convoy, in which case it would be funding a project. To these three categories of actors, that is the people in charge of the project, the donors, and the beneficiaries, we have to add the online platform that offers crowdfunding services, for instance, GoFundMe or GiveSendGo. These are two platforms that were involved in the convoy funding. These platforms do publish the regulations for the crowdfunding on their webpage and do submit the donations to the people in charge or the beneficiaries. And to deprive the platform or to process the donations, they do resort to PayPal and other services of that nature. The legal framework for crowdfunding in the form of donations is poorly defined in various provinces and territories in Canada. Private law should enable us to determine who owns the donations and who controls the donations and on what basis. In Quebec law, we wonder who is the person receiving the donation. Is it the beneficiary or the person in charge of the project? If it's the person in charge of the project, it means they own the money and they can do what they want with it. Donors and beneficiaries would therefore have little recourse if the donations weren't used according to the campaign objectives. It would therefore be preferable to consider that it's the beneficiaries who are the people that the donations are intended for. But we still have a problem given about the validity of the donation under Quebec law, because for donations to be valid, the recipient has to acknowledge receipt, and that often is not the case, especially if the campaign is intended to support a poorly defined group of beneficiaries or recipients, or a cause or a project. In the other provinces and territories of Canada, the concept of trust would be better, because the person in charge of the project or any other person responsible for managing and distributing the donations will be considered as a trustee of those amounts. This solution seems the most desirable because it does impose strict regulations on the person who is managing or receiving the donations, so that the donations are used for the stated purpose of the crowdfunding. But the application of trust law does raise issues in current Canadian law, because often we're talking about a non-charitable purpose trust. As such, the trust could fail because of the indeterminate nature of their objective. By the way, current law doesn't give us other solutions when the donations cannot be used for the purpose of the campaign, or if there is a residual amount left of these donations. That's why the Uniform Law Commission of Canada did design a uniform law on social crowdfunding in the form of donations to help resolve this difficulty. This uniform law recognizes that crowdfunding by donation does give rise to a trust, and therefore customizes trust legislation to govern relations between the parties. So standardizing this legislation across Canada would bring clarity and clarify legal relationships as far as these donations are concerned. Who owns the donations and who can control the donations? This question to me is fundamental, because attempts at regulating crowdfunding, like what we're discussing today, could depend on for their implementation on the issue of who owns the money and on what basis. By the way, another advantage of the uniform law is that it would help define the powers of crowdfunding platforms. Right now, the conditions for using these platforms gives them a lot of discretion, which enables them to interfere in the management and the disposal of the donations. The uniform law prescribes that anybody who does that duty becomes a trustee, and the strict rules governing trustees would apply to crowdfunding platforms once they interfere in the management and the disposal of the donations. The second point that I would like to raise is about the political and subversive aspect of some crowdfunding campaigns based on donations. Some crowdfunding campaigns have attracted attention in the last few years because of their political and even subversive nature. We realize their effectiveness in mobilizing and funding citizen-based movements, and sometimes movements that are challenging the state, that could shake up the state. We've seen that in the case of the 2019 protest in Hong Kong. Protesters were able to take advantage of the following features that characterize crowdfunding: its simplicity, its spontaneity, its informality, and its mobilizing and international characters, and its ability to actually trick the authorities. I think we find here some parallels with the use of crowdfunding during the convoy protest. The campaign We Fund the Wall is another interesting example of a crowdfunding campaign with a very political character. This campaign that helped raise over $25 million through the GoFundMe platform was intended to build part of the wall that President Donald Trump did promise to build on the border between the United States and Mexico. After the beginning of the campaign, and probably at the request of GoFundMe, the project launcher did create a not-for-profit organization to collect the donations. That didn't stop many individuals, including Steve Bannon, to divert part of the donation to their private use. And these people are currently being charged criminally for fraud. Many crowdfunding campaigns with political overtones have created scandals, leading some platforms to distance themselves to them and others to get more involved. This could lead to the politicization of these platforms themselves. I believe that we have to watch these phenomena and ensure that electoral legislation on party financing should allow for proper control of these situations. However, by the very fact that crowdfunding often has a political character, we should also ensure that freedom of expression and freedom of association aren't thwarted because of such controls. By the way, the few high-profile campaigns should not lead us to the belief that a lot of which we shouldn't lose sight of the fact that many of these campaigns are actually meant to help society and have had a beneficial effect on society. It would be unfortunate if we were to impose too heavy a framework on managing these platforms and therefore discourage the positive feedback that these projects often generate. The last points that I would like to raise are about the changes to the legislation concerning the proceeds of crime legislation passed on in April 2022 in order to subject these platforms to regulations. And here, my statements will actually be very close to those of Jessica Davis, with whom I agree most of the time. These changes can be considered as the continuation of the financial measures flowing from the emergency economic measures decrease. Crowdfunding platforms are hence considered as financial services platforms or foreign financial platforms. And when they are subjected to new regulations, including, for instance, meeting the requirements of properly knowing your client, including checking the identity of those involved and their identities for certain activities and operations, preserving certain documents, including documents relating to the operations and the identity of the clients, and declaring certain operations to CANAF. As many people pointed out, there is a need to review the usefulness of these measures because these platforms actually, in all the cases that I know, do leave the processing of the payments to intermediaries who are already targeted by the regulations. In my observations in response to the expert report, the Minister of Justice of Canada has emphasized the fact that social funding platforms have information or can implement mechanisms to gather information that monetary services institutions don't have. I think we should emphasize rather the nature of the additional information that only crowdfunding platforms can own. I would also like to know why this additional information is necessary or useful for the purposes of the law. By the way, I would like to emphasize that many people or groups resort to crowdfunding by creating a donation page from their own web page. These people or groups don't use the services of a crowdfunding platform, but they do use the services of a financial service institution. From my understanding of such crowdfunding campaigns, they would basically not be controlled by the new measures put in place to better supervise those activities. People who want to avoid the new information gathering mechanism that the crowdfunding platforms have to implement could basically avoid this by creating a donation page from their own website. If the goal of the changes introduced on the 5th of April 2022 is to ensure that crowdfunding platforms do check the identity of those who are launching projects or the donors and keep a trace of their activities, well, I find that concerning from the privacy standpoint.
Les plateformes de sociofinancement recueillent assez peu d'informations de cette nature. Les données que devraient collecter les plateformes à la demande de CANAF sont aussi des données dont elles pourraient faire un usage préjudiciable aux individus concernés. C'est la préoccupation que je voudrais formuler en vous remerciant beaucoup de votre attention.
Thank you very much for your attention. Thank you very much, Michel. Nous allons maintenant passer à Gérard Kennedy pour 15 minutes. Thank you very much for your invitation. I am Gérard Kennedy, and my expertise on procedural law is in administrative law, and
the procedural rights that individuals have regarding their property and how the invocation of the Emergencies Act would have affected that. In essence, I'm going to suggest that there were indeed common law procedural rights that individuals have concerning their property that were clearly affected by the events in February. However, because these are common law rights, they can be overridden by regulation or legislation. So insofar as the invocation of the act was lawful, taking away procedural rights that people have before being deprived of property was also lawful. And given that the Canadian Constitution doesn't protect property rights, the Constitution won't change anything in that analysis. The Canadian Bill of Rights might more plausibly have something to say, but it's uncertain. From a policy perspective, the legality of sending these procedural rights into abeyance is probably not desirable. And insofar as this commission has a policy role, I'll make some recommendations. But I don't think that affects the legality of what occurred in February. And insofar as procedural rights cannot be reconciled with the Act's invocation, I would suggest that that's a reason to not give the statutory prerequisites that justify invoking the Act a broad interpretation. In other words, an interpretation more consistent with the preservation of common law rights should be preferred. Starting with a few first principles, individuals have a right to enjoy their property. That's been recognized for centuries. And that can be limited in various ways. But generally speaking, that is adjudicated in the courts, either because there is an action to freeze the property or because individual A has commenced an action against individual B, asserting that their use of the property somehow impinges upon their rights. And in doing so, the rules of procedural fairness and civil procedure have got to be followed. These can look a little different in exigent circumstances, and I'll return to that, but generally that's the case. Moreover, before the executive branch of government deprives one of one's property, it has to follow the rules of natural justice, or to use the modern Canadian parlance, procedural fairness. Been recognized in England for centuries and certainly applicable in Canada. The content of this procedural fairness will vary according to the circumstances, but generally it's always going to include notice of the proposed seizure or freezing and some sort of opportunity to respond. I'd like to emphasize these are procedural rights to property. Doesn't mean that one's rights to property, that property can't be seized or frozen or forfeited or even destroyed. It does mean, however, that certain procedural hoops need to be jumped through before we go down that route. Moreover, the executive branch has no substantive power to take property unless authorized by a statute. So a statute needs to authorize the taking. So prima facie, without getting into the factual reads, in early February 2022, the members of the convoy had these protections that processes would be followed before their property rights were taken away. However, the Emergencies Act is a statute that clearly authorizes takings, and the emergency measures regulations and the economic measures orders make it quite clear that the procedural rights as well as the substantive rights were restricted in various ways, as we have already heard from my co-panelists. So to give an obvious example, entities such as banks had to cease making available any property for designated persons, among many other things. It made it very clear that no court order was necessary, and the entities were immune from any sort of liability from complying with the regulations, which probably resulted in erring of the sides of more seizures. Now, I will suggest that that does not fulfill the common law purpose of notice to persuade the decision maker that you should not be deprived of your property rights because you should not be a designated person, and there is no centralized authority to making someone a designated person. One could argue that determining individuals to be designated persons is an administrative decision and not a quasi-legislative decision, and that some sort of process should be contemplated there. Possibly, but that isn't spelled out in the orders, and it's also complicated by the fact that these decisions were generally made by non-state actors, which complicates somewhat the applicability of administrative law. I'll come back to this shortly in the policy discussion. Now, we don't live in a country of legislative supremacy entirely. The Constitution constrains government action in various ways, and you heard this morning and here later this week about a lot of other rights that were potentially impacted by the Act's invocation, where the Charter has a lot to say about matters. But property rights aren't in the Constitution. That was a deliberate choice in 1982. And it would be inappropriate to try to give them constitutional status at this stage. It doesn't mean they don't exist, but they're not constitutionalized, not even procedural protections to them, which again makes Canada a bit of an outlier around the world, but it is still very much the case of the Canadian Constitution. The Canadian Bill of Rights, on the other hand, does guarantee procedural rights regarding property. For instance, Section 1A guarantees a right to enjoyment of property and the right not to be deprived thereof except due process of law. This use of due process is fairly rare in Canadian law. It's somewhat of an American import where we've tended to use natural justice or fundamental justice or procedural fairness, but it has significant overlap to principles of procedural fairness. Moreover, Section 2E of the Bill of Rights holds that statutes shall not be construed to deprive a person of the right to a fair hearing in accordance with the principles of fundamental justice for the determination of rights and obligations. Though I'll note that that doesn't guarantee a particular process, but rather interference with processes already authorized at law. So there's nothing problematic from a Bill of Rights perspective with the mere fact that such a process was not prescribed in the orders. Moreover, the procedural protections for property have been interpreted quite narrowly, only to instances where there is discretion to deprive the person of their property. So if legislation takes away the right to property unambiguously, the Bill of Rights protections are inapplicable. Moreover, the specific due process rights protected by the Bill of Rights must have existed in 1960, as the Bill of Rights is a statute to be interpreted the way it would have been after it was passed. So, what does this mean about the Bill of Rights? Well, the enactment of the regulations themselves does not pose a Bill of Rights problem, because the Governor and Council enacted them in a quasi-legislative capacity. Having such a hearing before Cabinet clearly seems to have not been a right pre-1960. More plausibly, individual decisions about the particular individuals whose assets would be frozen could attract Bill of Rights due process protections because they are administrative rather than legislative acts. At the same time, while that's a plausible reading of the Bill of Rights, there's relatively little case law on it, despite it being over 60 years old. It's never been interpreted in circumstances such as this. There probably is a pre-1960 right to have notice or a hearing before property is frozen by the executive, but does it apply to the implementation of cabinet decisions? Does it matter that this is an emergency, if not statutorily, at least colloquially? Does it matter that private entities actually did the freezing? Does it matter that it's a very clear regulations? These complicating factors make the way in which the Bill of Rights could affect things somewhat uncertain. So I'm going to transition to my policy points, and in doing so, though, I will discuss what a hearing that preserves a measure of procedural protection, whether at the Bill of Rights or otherwise, could look like. Procedural law recognizes there are exigent circumstances where property has to be frozen soon. So for instance, Anton Pillar and Moreva orders in the civil litigation process allow searches of property or seizing of assets without notice if there's reason to believe that responding parties will hide assets or something similar. There has to be judicial authorization to be sure, but there are opportunities to challenge after the fact, and there will be significant consequences if a party was not forthcoming regarding how it obtained the order. And there are other circumstances, notably in the Money Laundering and Terrorist Financing Act, that give individuals post hoc ability to challenge asset seizure and get a resolution quickly, addressing the concern already identified that the freezing and lack of access to one's bank accounts can have really profound effects on one individual's lives, while still recognizing there are circumstances where it is absolutely necessary. But that was not, such a process wasn't apparent in the regulations. And I don't think that poses a legal problem, given the broad nature of the act. But I do think it may be a good idea to amend the Emergencies Act to prescribe a process to review the seizure of property analogous to what is seen in the Money Laundering or Terrorist Financing Act, particularly for emergencies that, or states of emergency that last quite some time. Because in this case, it lasted 9 days, but there's nothing inherent that that's necessarily going to be the case. And I'd like to also echo Jessica Davis's view that the designation of individuals should be named, if not by the governor and council, by some sort of designated central authority, both in terms of making it easier to determine the applicability of administrative law principles and to not have this kind of ad hoc situation where what kind of procedure, if any, would be necessary is very uncertain. So far, I've suggested that there are ways that we could improve the Emergencies Act and future orders in council to preserve more of a protection for property rights, recognizing there are exigent circumstances where property rights have to be suspended and traditional civil procedure is not going to work. But in light of that, I would suggest, because of the general principle of statutory interpretation, to read rights-limiting legislation strictly, I'd encourage this commission not to interpret the Emergencies Act broadly, given that it can deprive individuals not just of their substantive rights to property, but also any kind of procedural ability to protect it. It's a well-established principle of statutory interpretation that rights-restricting legislation, including property rights restricting legislation, is to be interpreted strictly. It's also a principle of statutory interpretation that legislation intends to be consistent with the common law to the extent possible. So in this case, if the commission finds that it's a gray zone, whether the statutory prerequisites for invoking the act were met, it should bear in mind these common law rights as a reason to not interpret it particularly broadly. That's not determinative. This commission should consider all canons of statutory interpretation that likely point in different directions. However, insofar as the legislation sends individuals due process or procedural fairness rights essentially into abeyance, we should be reasonably certain that Parliament intended for it to apply in these circumstances. That's not a condemnation that the government didn't act proportionately here. That will be up for this commission. I don't see evidence that it didn't. But given that a government is not legally obliged to do so, it should consider the long-term implications of that. Merci beaucoup.
Merci.
Thank you. Now I call on Michel Galland to take the floor.
Thank you to the commissioner. Thank you to the moderator, to fellow panelists, to everyone present, and those of you attending remotely for this opportunity to share some thoughts. It's a privilege to participate and maybe offer something of value. Funding is important to securing any aspirations. It doesn't matter if you're opening a restaurant, if you're starting an industry, if you're going to higher education, or to realize civil society ambitions. Funding enables. There aren't a lot of things that are accomplished without some kind of access to finance, to property, and to resources. So in participating today, I would like to simply survey 3 dimensions of funding and finance, very briefly funding and the charter, a little bit on foreign funding and civil society groups, and a little bit about the appropriateness of these particular financial measures. So let me begin by noting that it hasn't been fully canvassed by the courts at all, but in principle, the idea of fundraising to support a cause, right, or a social movement is protected by the charter freedom guarantees. There was a roundtable this morning. They did talk about constitutional freedoms, and I'm sort of drawing on some discussions with Professor Jamie Cameron, but suffice to underscore that funding animates those freedoms. So organizations do have the right to fundraise, and you can't impose a limit on what they use those funds for. That would fall within freedom of expression. Donating to organizations, lots of people donate. That donative act can constitute associational freedom. My association is by giving, right, by donating. And then again, that action is captured by the freedom of association. Broad human rights law also places the mobilization of resources amongst the activities that freedom of assembly protects. So there is a report, it's May 2022 from the United Nations Human Rights Council. And it's specifically about funding. It's actually specifically about foreign funding, but it specifically states that the right of associations to freely access human, material, and financial resources from domestic, foreign, and international sources is inherent in the right of freedom of association and essential to the existence and effective operations of any associations. So I know there are limits. Some of those were talked about this morning, but simply to underscore that that funding piece is part of those freedoms. And I would also note that the size of a particular funding campaign, so even if someone has surprising success in mobilizing, resources beyond your dreams, that is not ever without more grounds for a state interference. Simply a successful fundraising campaign, galvanizing lots of resources is not on its own any kind of a justification for some kind of state-based interference. So let me say a few things about foreign funding restraints and civil society organizations. As my colleague has commented, sort of democratic and non-democratic orders all resist foreign funding. It's not just a democratic order thing. All orders resist foreign funding. This idea that foreign influence, the meddling of the outsider in the internal affairs of another, it's long been controversial. Usually states, particularly sovereign states, democratic states, reserve unto themselves, no, we have the right to arrange our internal matters, and will resist and sort of shut off their boundaries to the kind of foreign influence, including foreign funding. That resistance, that sort of is sort of just based on this deal that, look, we're accountable as a state. I'm accountable to, particularly through elections, to the domestic populace, and I'm not accountable to an audience anywhere else in the globe. It might be said that the entire project of international law is simply devoted to deliberating upon what's the proper place of external influence on domestic affairs of state. And I have to underscore this too. Any money flowing across a border is foreign funding. So if I am a Mexican expat and I'm working here and I'm sending money home to fund my family in Mexico, that to the Mexican state is foreign funding. If I'm in the UK and I purchase a football team and I'm a Russian billionaire, to the United Kingdom, that is foreign funding. So any funding that crosses a border constitutes some kind of a foreign funding. But what I wanted to note today is that increasingly there has been this recognition recognition that states are imposing restraints on foreign funding. This is a new thing. It sort of started maybe in the last 20 years. It's intensified in, say, the last 10, this idea of individual states are going to restrain access to foreign funding. How do they do that? What are the strategies? Well, one strategy is simply requiring that civil society groups, if you're going to go and harvest foreign resources, you must register. So you have to seek the approval of the state before you can go elsewhere. Another one is simply, it's a little more covert, is the adding of different administrative burdens. So you're an organization and you'd like to secure foreign funding. It's the idea that if you want to go after foreign funding, you have to disclose that. You have to file a number of forms. So it impedes, it's harder to secure foreign funding than it is to secure domestic funding. I think one particularly alluded to maybe by both of my colleagues here was the idea of a state marginalizing or decrying as illegitimate, or in particular, labeling a domestic organization as a foreign agent as a reason to say no money is flowing here. So that's another strategy. And again, the idea too would be calling a civil society group as a political organization. So what do we have? So in Canada, so those are some of the restraints. In Canada, we do have some restraints on foreign funding, and most of those, I think, as my colleague Jessica Davis has canvassed, most of those connect to elections and the formal political process, basically injunctions against foreign support. So that's the place where we find these restraints on foreign funding. Do we actually see them anywhere else? Well, generally the idea would be, no, we don't generally have specific injunctions, prohibitions on access to foreign funding. However, what we have seen is we have seen some encumbering being imposed on, say, registered charities. So for example, now, this is the result of a few years ago now, if a registered charity, which is just a charity, it's governed under tax law. But if you are a registered charity, if you're a civil society organization that's organized in that way, you actually now have to disclose the presence of foreign funds. So it used to be charities had to disclose broadly how successful are your fundraising efforts, right? How much money did you raise? But now these particular ones in Canada now have to disclose the presence of foreign funding. So it's not a specific restraint, but it certainly is an exercise in opening up, in disclosing the presence of those, resources. So we've seen some of these. I think what's concerning about this to me was when I was originally looking at this, I thought this is going to be your usual suspects, where we're going to see this, maybe some states that sometimes, at least in Western society, tend to maybe think they're a little bit troublesome. But none of these foreign restraints they're applying in the United States, in Europe, and in Canada. So it's in your reasonably well-developed democratic states that are imposing these restraints. And I would be remiss in not pointing out, with respect to foreign funding, that in July 2021, it saw the completion of an Alberta report, and the Alberta report deals specifically with foreign funding and the energy campaign and energy campaigns in Alberta. And it was an inquiry that was called in that regard. So that inquiry, there might be all kinds of other parts of that inquiry you might be uncomfortable with. However, that inquiry in its forensic accounting, so it used an accountant, actually did identify an increase in the funding of our donative sector in Canada over the period of 10 years of foreign dollars. So I think the number it says, this is about 1.6 billion, an increase over that period flowing into Canada. It doesn't track where it's from. There's some sense that a lot of it's from the States, but it does track an increase in foreign funding. And I would be noting, since that inquiry was specifically about foreign funding, the first recommendation that commissioner made was actually that we need to increase the transparency of the financial sector, in particular in connection with registered charities. So I would just note, just sort of mention, in talking about these foreign funding restraints, anytime we introduce an element of disclosure, as you know, right, elements of disclosure, they irritate privacy. So when we seek to introduce, even if the restraints are about introducing and enhancing transparency, those transparency norms irritate privacy. And I say that because generally, the act of donating, which my colleague talked about donating to any kind of campaign, normally falls within the realm of financial privacy. It's not public. There's no public entitlement to know where I put my donation, my donative dollars. It privacy shelters that kind of freedom. Now, I just note that, sure, if I have no obligation to disclose and yet I freely choose to disclose in some public medium or tell someone what I've done, that's quite different. There I've decided that, look, I'm waiving my financial privacy, but there is always going to be that tension between disclosure and privacy. So let me in the few minutes I have left, let me say a few things about the appropriateness, like turning specifically to the appropriateness or necessity of the particular financial measures that were introduced. I think I would like to highlight here, and it's sort of along the lines with my colleague, my colleague Professor Kennedy, when you're talking about the appropriateness or necessity of the particular financial measures. And what I'd like to simply comment on is this idea that simply because we have an emergency a situation, once that's decided, that doesn't trump or abrogate the complete application of law. So there is space in which we have to determine and think about, were these particular things appropriate or not? Was these particular regulatory necessity or not? And in saying that, it's not sufficient to simply say they worked. The situation dissolved, we solved it. It is not sufficient, because that's to equate effectiveness sort of with appropriateness. And it means that appropriateness has no meaning. Absolutely no meaning. Doesn't matter. Anything is appropriate. So, the example would be, the sledgehammer killing the fly, but so would the fly swatter. And that would say that the sledgehammer is okay. And I'm not commenting on their appropriateness. I'm just outlining some of the things that we have to think about. We have to think about whether these particular measures were appropriate or not. So simply, in talking about whether the appropriateness of the financial regimes or the necessity of these particular financial regimes, let me simply say that the way in which we might be able to discern that would be to at least think broadly about some kind of a proportionality test. So if you're a lawyer, there's an Oakes test, and it's kind of what it is it's kind of a matrix of proportionality. And basically what would that mean? That would be, in a sense, okay, let's look at, we have a response, and that response ought to be sort of minimally impacts on individuals, right? So that would be on one side of the equation, while at the same time be designed to immediately lance a particular public order problem. So you have to think about, so this proportionality between the particular measures, right, and their impact on individuals, not as concerned about institutions, more concerned about individuals, and the immediate kind of dealing with the public order situation. And I'm going to end just by adding one more thing to that. So what would be some pieces that might be relevant to this proportionality analysis? Certainly foreign funding would be, it would jostle for some primacy. So if there was foreign funding, I'm not concluding that there was, it's been outlined that maybe there wasn't, but the idea of foreign influence, foreign funding would be pretty important in a proportionality analysis. Another thing that would be important, I think, is when people talk about the idea that these measures were temporary, the measures were temporary, but the impact of these financial measures on individuals may not be. And I would simply say this: the Privacy Commissioner has already warned that some information gathered under terrorist finance and suspicious transactions reporting norms that was wrongful or not clear, once it went into the final system, there needed to be a way to purge it, to get it out. So that kind of thing, there was a lingering consequence. So thank you.
Merci beaucoup, Michel.
Thank you very much, Michel.
Moderator, first I'd like to thank all the experts for their opening remarks presentation. We've covered a lot of ground, but there is more to be covered. Avant de poser des questions, j'aimerais...
Before going on to questions, I would like to give the chance to panelists if maybe they have questions or if they would like to make comments regarding what other panelists have said.
If there are some who have things to say about what the others said. Jessica Davis?
Yes, I just have one quick question, and it's actually from Michelle Gallant about the not-for-profit corporations and if they have any restrictions or reporting requirements for foreign funding as well. You talked about the charities, but they're different.
I'm not aware of any because generally not-for-profits, the regulation is much lighter and simply because they don't give tax deductible receipts, right? So I'm not aware of any. And I would also sort of just enjoy that. I'm not aware of any restrictions. So there's not-for-profits, there's charities, but also sort of ad hoc civil movements. I'm not sure where they would fit in this, right?
Patrick Leblanc ici. Anyone else would like to ask or say something, comment? Michel Galland?
Sure. One question I would have is sort of generally, sometimes when we talk about, fixing the financial system, and then we talk sometimes about combine that with this idea of, foreign influence. I guess I wonder myself, I have trouble sort of thinking about, well, how are we going to discern? So my example would be, if we're going to fix, there's the problems with the financial system and we're worried about foreign dollars. And I think of an example like, okay, we're building a church in Winnipeg and it's funded by dollars that are coming from the Vatican. That's foreign funding. And it could easily, so I wonder about how you think through, how do you legitimately identify, what are the gaps that need to be filled and what can be left alone?
Patrick Leblanc, I think that's a very good question. In fact, if I can ask and put it in different terms, because I was going to ask the panel to think about that. And in light of what you also said, Michel Galland, in your presentation, and that's maybe to the question of risk. Right? Michel Galland, you talked about, administrative registration, for instance, or disclosure, right? And especially with regards to foreign funding. So would a risk-based approach, I mean, we see it, already the anti-money laundering and terrorism financing is based on this notion of risk. What is the risk in a way for the state in terms of national security, which is why we have this. In terms of securities legislation is the same thing, right? There are restrictions, disclosure requirements when it comes to raising funding for financing companies. So in a way, how is that different than raising funding for building a church or for organizing a group, etc. So I'd like to hear the members of the panel, and Christian, please, raise your hand if you want to speak, in terms of what are the risks ultimately that we are talking about here, right? I mean, obviously, the fact that we are talking about foreign funding means that there is a risk. In terms of politics, as Jessica Davis mentioned, influence, undue influence over the political process is a risk, right? You don't want foreign states to influence, democratic results in one way or the other. That's why we have rules over funding, etc. But what are other risks that are applicable here? So I don't know if anyone wants to go first. Jessica?
Okay, so Jessica Davis. So I think you're right to argue that one of the risks is influence. I think another potential risk is compromise. So basically, the way that I see it is if an individual or an organization were to accept foreign funding that is probably intended to buy a certain level of influence with that individual or organization. But there's also the potential for the disclosure of that information to compromise their ability to do their job, or that they won't want that information compromised in the future, which in turn can also have another level of influence. But I think it's a good question. And I would also take a moment to talk about the foreign funding issue. I think, I don't want to be prescriptive here in terms of what should or shouldn't be in any kind of legislation about limits to foreign funding. I think that needs careful study. It's a very sensitive topic, but I think it is reasonable to start thinking about that in terms of limiting political activity. That might also have some limits to religious activity, because it's very difficult to separate these things out. I don't see that as necessarily a problem. I think that there could be a reasonable way of writing that kind of legislation to make that acceptable to Canada and Canadians, but it is a thing that it's something that we need to consider as we talk about that.
Quelqu'un d'autre? Christian? Ah, oui.
Anybody else?
So it's probably helpful to differentiate between risk and threat, right? So everything's a risk in one way or another. But a threat is capability and intent. And so I think we always need to ask then, if we have actors who are providing funding, what is their capability in terms of actually influencing democratic institutions or whatever it might be, and what is their intent? And if the intent is nefarious, if the intent is to support illegality, criminality, if there's an anti-democratic intent, I think that would be an important sort of element of distinction. And so that seems to be driving, for instance, these foreign agent registries, that there's a particular concern that certain state entities have fundamental hostile intent and have the capability to follow through on that intent. And so you have to manage the risk very differently than, for instance, some donor, wherever, who's just giving money because she or he or they sympathize with a particular cause.
Merci, Christian. Patrick Leblanc ici.
Thank you, Christian. Patrick Leblanc here. The intent is a major issue, but I will ask the question, how do you determine the intention? Do you simply ask what are the intentions of people? How do we determine? Would there be an agency saying that you have a good intent or a bad intent? How can we determine in advance the intent if we say that it's only in cases where there is a threat?
Decide on intent and who is responsible, because I guess there is a danger that it could be abused. Someone could say, oh no, you have bad intentions and therefore, we're not letting you get that foreign funding or even do anything. Je vois Michel Galland qui peut-être répond.
Yeah, see, Michel Galland would like to answer.
This came out of some of the comments that Professor Lauprecht made, was this the part about identifying the foreign funding is one thing, but one reason I think that Canada has some issues on the international stage, even though it hasn't been labeled, I'm not aware of it being labeled as a money laundering haven or a terrorist financing, but I stand to be corrected. But the criteria of both of those is usually financial secrecy is at least one, low tax rates can be one, but also pronounced very strong secrecy rules. So I guess I wonder, and like I said, I'm not that sure. I haven't sort of policed or looked into how strong kind of Canadian protection of the secrecy of transactions that cross the border, actually how that stands up along, say, different countries, which sort of have been labeled sort of, I guess, as secrecy havens. Some parts in the South, some parts in the very center of the United States, some places in the middle of Europe. But like I said, I wasn't aware that we were. But if we are, simply in terms of detecting that kind of foreign funding, the suggestion would be we actually have to enhance disclosure in some way, shape, or form. So to move up the Transparency International, index.
Okay. Merci beaucoup, Michel. Christian, would you?
Thank you very much, Michel.
Christian, would you like to say something about intent and how and who could decide this and how it would play in terms of focusing more on threats than risks?
I'll try to be brief. Look, intelligence is our first line of defense. And so this is why intelligence agencies are subject to different evidentiary threshold regime, for instance, than criminal intelligence. Now, let's look at how well we're actually doing when it comes to, for instance, figuring out intent in terms of financial intelligence. So in 2019 and 2020, FinTrack had 31.5 million individuals reports submitted to it. Now, the entire United States had 21.5 million. The United Kingdom had 500,000. So that's 12.5 times more reports in Canada as compared to the US, 96 times more reports compared to the UK. So that's an exceptional defensive regime that provides very high volume, very low quality outputs. In fact, in 2019-2020, FINTRAC made only 2,057 unique disclosures to law enforcement, and most of those disclosures were not particularly useful because they didn't, for instance, draw a broader network in terms of threats and so forth. So we need to actually have a much more robust posture for our intelligence agencies to actually be able, on the one hand, collect the information that they need to discern intent, and then to be able to action that type of intelligence. And when it comes to FINTRAC, for instance, if you read the chapter on FINTRAC in the Cowan Commission report, it is very clear that FINTRAC does not perform. Why does it not perform? Because it is a complete outlier in terms of financial intelligence agencies among Western democratic allies. So this just sort of as an example that we can have all the conversations about legal particularities that we like. If we have agencies that cannot perform for the purpose of the security, prosperity, and democracy of Canada, then all this is probably nugatory.
Thank you very much, Christian. Jessica?
Yes, I just want to come in a bit on the Cullen Commission information that Christian Leiprecht is presenting. So in my reading of the Cullen Commission, I found a number of factual errors and a number of errors of interpretation. So I think we should be cautious in citing that too closely and being too, using that information too carefully here. Because, you know, when we talk about 2,057 unique disclosures, that doesn't actually tell us anything because there can be hundreds, if not thousands, of individual transaction reports in each one of those disclosures. We don't know how many of the 30 million reports were actually disclosed to law enforcement or intelligence services in those reports. So there's some issues of interpretation around that. And I would also take issue with the idea that all of this FINTRAC intelligence is not useful. Law enforcement and security services have repeatedly told FINTRAC the opposite. In their annual report, they share that information. I worked at FINTRAC. I worked in the Canadian Security Intelligence Service. I've reviewed a number of FINTRAC disclosures. They vary in terms of their usefulness, but they are not universally not useful. And I just want to come in on financial intelligence and the issue of intent. The problem is when we're talking about financial intelligence, we're talking about financial transactions. They don't tell us anything about intent. It's literally just an information, a record of who's sending money to whom. You need an all-source intelligence picture to get that intent. But I also think that when we're looking at foreign donations, there is an implied intent behind that. It's to support the organization, political activity, or individual there. So it kind of makes the whole argument about whether it's threat or risk moot.
Patrick Leblanc, thank you, Jessica.
I do have to, if
Christian,
I may reply
yes?
to that very, very briefly, that what Ms. Davis outlines here is precisely the problem when it comes to effectiveness of government agencies, that there is insufficient transparency for outsiders to measure whether these agencies are actually effective. And what governments do in their own agencies, they will always say about each other that they're all effective. I've yet to find an RCMP report, for instance, that has ever said about any RCMP aspect that the RCMP is not effective at something that it does. So what this means is the state controls the narrative on how effective its own institutions actually are. And that's why inquiries such as this one are so important, because there's some of the very few opportunities to actually shed light and provide some transparency on what actually happens. And I think it is, while there may be some factual issues with the Cowan Commission's report, I think it is very dangerous to call into question the overall conclusions that the Cowan Commission draws, because it is the only measure of objective, independent sort of assessment of the entire regime in Canada and to what extent it actually does or does not serve the public purpose. And I think the Cowan Commission's conclusions on that are irrefutable.
Merci, Christian.
Thank you, Christian.
If anyone else would like to take on this issue of intent or not? Okay, Jessica?
I will come back on the issue of effectiveness and usefulness because Professor Leiprecht did move the bar on that. So we were initially talking about usefulness of FINTRAC disclosures. And then he talked about the usefulness of the effectiveness of the regime. I would agree that the regime has plenty of room for improvement. The regime as a whole is largely ineffective in terms of the measurements we would normally associate with that, things like prosecutions of money laundering and terrorist financing offenses. But that doesn't mean that FinTrack disclosures are not useful.
Okay, thank you very much, Jessica. Patrick Leblanc. Let's bring it back to foreign funding, which in a way is what I would like us to focus for now, and there are other issues. But in terms of the risks and the intent, and therefore the question of whether there should be disclosures, registration, as mentioned by Michelle Galland, and I guess putting it in terms of that she presented it in terms of appropriateness and is it necessary and when is it necessary and who should, and I'm going to use other examples. We know, for instance, when it comes to foreign direct investment, there's the Investment Canada Act, and that has been changed over time. The notion of national security was incorporated, and a lot of the focus has been on state-owned enterprises, for instance, that do invest. So I'm going to try to draw this parallel in terms of, I think, Jessica Davis mentioned, well, foreign funding says something about intent, but it only says about that you support something. It doesn't say in what way, for what purpose, you just support it. Would it make sense, and this is obviously open to all the panelists, to draw categories, say that state funding, for instance, from any state is illegal, or at least, and then obviously there is the issue of, well, the state could say, well, we're going to fund some private organization that is then going to fund something. So you would have to go back to the financial chain. Is there a way, or is there a logic to kind of having categories on saying, well, if it's individuals, it's okay. If it's corporations, well, then that goes another category. If it's states, it goes, like no states, for instance. In terms of maybe requiring the kinds of disclosures, and then who discloses? Is it the party that seeks funding? Or is it the party that brings in the funding? Where does this disclosure take, right? Donc, je ne sais pas si quelqu'un...
I wonder if somebody is ready to delve into this discussion about how we can approach this issue of transparency at the end of the day. Michel Galland?
I would say that generally there's certainly been a lot of work here in Canada, and sort of it's this global regime, both in a sort of a criminal context and a terrorist financial intent, but also in a tax context. Two separate global regimes, but they're both about increasing transparency. And it's not simply about, but it's largely about crossing borders. So the tax evasion or avoidance to which my colleague referred, a lot of that activity is because it's enabled by a border. So even the CRA can go as far as the border, but they can't look beyond them. They got to start asking questions. But there's been a lot of work, I think, and it has a long way to go in terms of transparency. So one example would be, it's been, I don't know how many years they've been asking us to create a corporate registry of beneficial ownership. And that's simply a place that, you find a corporation and you know who actually benefits from it. Right? It's been forever, and we're finally, BC's moving. So a lot of places. So that general work I think is happening. But as I said, it's been very slow. But related to that, and maybe I think somebody else can probably answer this, because the transparency piece is from the top down. I usually sort of work from the bottom up. So if I were looking at, I would start with proliferation. So I would know that, say there was a nuclear facility and money was destined for proliferation. And then I would look up from there to the regimes that governed or that allowed the transparency, or why didn't we see this? But one question I have in terms of that is, I can't get my head around, what is it about this particular, what was going on in Ottawa in January and February that would have triggered a financial response? So, when I think of financial reporting, I think of suspicious transactions reporting. So, $12,000 deposit from somebody who has, no resources, it might trigger a suspicious transaction report. But I guess I wonder generally, so in terms of transparency, if we had transparency, what is it about what was happening, as I said, in January and February, and sort of in Ottawa, but also across the country, that would have triggered some financial knowledge? Like I said, that's...
Merci, Michel.
Thank you, Michel.
If I can maybe go further, Michel, sorry, does it make sense to say, well, because if I understand, like, even if we had information on, you know, I guess whether it on these transactions, would it have changed anything, right? In the sense, I guess, and then this as it was raised, right, by if those crowdfunding platforms had, you know, been registered and they had collected information, would it have changed anything? Jessica?
Yeah, I just want to say that FINTRAC was in a position to collect a lot of that information. When those transactions hit the Canadian side of the transaction, anything over $10,000 or more would have been reported to FINTRAC. The gap is in the suspicious transaction reports, although institutions can absolutely file that as well. And I, you know, looking at this whole convoy finance issue, I think I've made no secret that I'm not a particular fan of how things went in Ottawa, being a resident here. But I don't see any way that enhancing these regulations in this way would have provided the government or FINTRAC or law enforcement or security agencies with any additional information that would have been particularly useful to countering the protest.
Thank you, Jessica. Patrick Leblanc. Anyone else who would like to add? Because
I think it's the point.
Michel Galland.
Sorry, I think it's the point Professor Michel Cumin made about that even if you regulate the crowdfunding platforms is one thing, but as I understand it, if I put a sign on the internet that says send me money and it's got my bank account, that it's regulated by the financial institution. It's an exercise in crowdfunding, but it doesn't touch any kind of crowdfunding. I think that's the point.
Yes. And I think you made that point as well.
Michel Cumin, yes.
Oh, sorry, Michel Cumin. Yes, that's right. It is possible to launch a crowdfunding campaign without using a crowdfunding platform. All you need to do is create a page on your website for people to give donations. And in that case, while you're using a money services provider, is that what they're called in English? A money services provider, and that would therefore be reported to FINTRAC. Is that correct? Yes. So I don't understand what the added value is of also getting reporting from the crowdfunding platforms themselves.
Merci, Michel Cumin.
Thank you, Michel Cumin.
Is it fair to say, at least from my perspective, going back to the what happened in Ottawa in last winter, that in a way the money issue kind of came in because the occupation, if we want to call it that, or the convoy, lasted for much longer than, you know, I guess everyone expected or hoped. And then it was seen as a way to put pressure on those who, you know, in a way overstayed their welcome. So originally, it seems, and many of you have talked about this, right? And I think Michel Galland and Michel Cumin made it quite clear that, well, you know, funding is good for democracy in a way, right? Funding protests is something that we should allow and potentially even encourage, right? That people have a right to demonstrate, they have a right to get together and say what they like or don't like. It seems that, well, it's when kind of this turn, then the money parts was seen as a way, well, if we cut the funding, then they won't be able to do what they want. I don't know if like, it seems that we're talking about two things here. And when is it that, you know, we flip into the other part? And where and would the registration, the disclosures, the transparency change anything to that? Like, ultimately, was it just to say, okay, now this is no longer just a protest, right? It's an occupation. We need to we've used, let's say, whatever means we couldn't do it. And we think that if we cut the funding to these people, and it's going to prevent new people from coming because we're going to threaten them. I have questions about that later. But would any of these disclosures, transparency change that? I don't know if I'm making myself clear, but it seems that there are two things. One is kind of what happens before the money kind of gets there, right? Like in a way, when we're talking about terrorism financing, we don't want them to get the money even before. We want the money we want to be able to track it so that we can prevent some attack. But in this case, would it have changed anything? Jessica, you're nodding. Maybe.
Yeah, so I'm trying to sort of pick out the pieces of your question there. So I think that there's two things, and I'll use a framework for this. So I see the way that the government sought to counter the financing of the protests and the occupation in two different ways. One was organizational. So by targeting the crowdfunding campaigns, which were drawing in those large sums of money, the foreign funding piece largely came from those crowdfunding campaigns. They were seeking to address that organizational piece because it was or the movement piece, I think is a better way to frame that. And the concern for Canadians really came from that movement level funding that was happening from people who are identifying as being outside of Canada. And I use that language very specifically because there was no identity verification being done on who was actually donating and where they were located. It was just what they were saying. So I think we need to be quite careful about that. So that was the first piece. The operational funding is what I would consider to be on the ground funding. And that's where we get into questions about the sort of the effectiveness of the measures. To my mind, telling people that you're going to freeze their bank accounts unless you leave Ottawa could facilitate a peaceful conclusion to a situation. And it indicates a level of seriousness on the part of the government. I'm leaving aside all questions about proportionality and whatnot there. And I think that that's quite a useful way to think about it. The thing that bothers me, though, about what I've heard from the Commission so far is the government's assertions about its effectiveness with no evidence. I've heard repeatedly from government officials saying that in public statements and at this Commission that these measures were effective, but we haven't seen any evidence about whether or not, why were they effective? Whose money was frozen that really spurred people to leave Ottawa, the process tracing of that activity. And I think that's what concerns me.
Oui, Michel Commune.
Michel Commune, je voudrais peut-être juste ajouter quelque chose.
I would just like to add one thing. To me, the moment when all this became illegitimate was when criminal acts started being committed by the protesters. And one of the measures taken, and I wonder if it was effective, but I'll raise it anyway, and I will emphasize it, that is the injunction against the blockade relating to the criminal code, which enables the freezing of funds if it's believed that these funds will be used to commit a serious criminal offense. I believe that this was an example of a measure that seems all the same effective. But to me, the time when this whole situation became illegitimate from a crowdfunding perspective is when we realized that these funds would be used to commit criminal acts. Thank you. Thank you so much, Michel.
I have a question, Patrick Leblanc. I have a question for Gerard, and this you talked about notice in the procedural fairness. That normally before someone's assets get seized or frozen, they should receive notice. And it was mentioned by the others that, and this is what happened, that in a way is like, okay, once the Emergencies Act was invoked, the regulations came in, and it was like, okay, now if you don't leave Ottawa, or if you come to Ottawa, you risk having your financial assets, your bank account frozen and all that. Would that be considered as notice in terms of procedural fairness? Like, in a way, you are warned. I just wonder what your opinion on that, Joe.
No, that's really interesting. And you could definitely make an argument that for everyone who is coming, it is notice. For people who are there, it kind of is, all right, it's a dispersal order that's not a dispersal order, so to speak. So it's kind of stretching the definition, I think, of notice. And it still doesn't really get around to determine whose assets get frozen. That remains a little bit of an uncertainty. And so that is where I think, from a procedural fairness perspective, it gets a little more complicated, unless you just view this as a quasi-legislative action, and then that's notice enough.
Patrick Leblond. Christian.
Christian Leprecht. I think this really gets at the heart of sort of the challenge that moving beyond the invocation of the act is simply a means to an end, and it somehow had the strategic effect that the public or the government was looking for. And I think so. These measures of notice then get us to, I think, 4 other sort of thresholds, which is, was it proportional? Was it necessary? Was it reasonable? And was it sort of and the efficacy, so efficacious, efficient. And so what does the sequencing look like in order to be able to then have on your matrix being able to check these off? And so I think the financial piece really came as a way to substitute for the relatively ineffectiveness of the initial law enforcement response, also on the financial side, because these financial investigations are some of the most complex investigations that you can possibly lead on a criminal enforcement, criminal intelligence side. And we're simply not postured with the people who can actually do these investigations. So we're having, I think, the conversation that we're having today as a way that the government substituted for the fact that we simply on the enforcement side didn't have the appropriate capacities and competencies if we had been able to leverage these the way other countries, Australia, the United States, France, Germany, leverage these in protests effectively. Then we don't have to resort to these extraordinary measures. And so I think they're trying to understand, how do we get ourselves to some benchmark measures as to under what circumstances it might be appropriate to then use these second order effects, such as the financial measures that we're talking about, and when these effects are proportional, necessary, reasonable, and efficacious. That's, I think, the heart of the matter.
Patrick Leblond, merci Christian.
Thank you, Christian.
Ça soulève une question pour moi.
So this raises a question for me, this notion of notification. So Gérard, you said that for people who were outside and who wanted to come back to Ottawa to have some fun and demonstrate, it could have been sufficient to say, well, if you come back, or if you come, your bank account could be frozen, or your credit cards. For people who were already there, maybe not. And then how do we do to identify them? But if we had said, listen, someone will be there to ask the names of the people in some perimeter, and then we would have the list of all the people present at such a date, and if they're still there 48 hours from now, we will give the order to financial institutions to block their assets or their bank account. Would that be acceptable, for example? Well, I will answer in English because I want to be as precise as possible.
Well, is it okay? Let's in times of crisis, traditional rules of procedural fairness can be modified. We have to accept that we can't always have gold-plated process going on here. So in that sense, to some extent, a hammer I'm not completely opposed to it. Where I think it becomes more problematic is how did the banks know whose accounts to freeze? And if they felt they made a mistake, like what sort of disincentive is there on the bank to not do it? How do they know the person didn't leave? The fact that there wasn't a centralized authority is a little bit of a problem as well here. And the fact that there was no challenge after the fact is a bit of a problem as well. Like going only for efficaciousness, this may very well have been efficacious, and therefore in some cases I'm I'm not going to argue that it wasn't efficacious or that it wasn't even justified in particular situations. I think the problem arises, as you noted, it was implicit in your question, that we don't know how the banks made this decision. We don't know if the banks did it with someone who actually got the message and left. And that's where the lack of any individual protection is a bit problematic. And look, in an emergency, some of this is someone's going to fall through the cracks, but the lack of any kind of ability to challenge, the lack of any kind of way to say, no, I left, I got the message, and the bank had no incentive to accept it. Like the person could go into their bank account in Toronto and say, look, I'm back, but the bank wasn't obliged or had no incentive to take it off per se. That's where I think it becomes slightly more problematic from a procedural perspective.
Merci, Gerard.
Thank you, Gerard. Michel Galland.
Just in terms of the notice piece, the idea of affecting sort of rights, and I think this has been mentioned before, would be, the financial measures touched the stuff of designated people, but the stuff of designated people, like most of us, a lot of that stuff is jointly owned or owned in common. So in thinking about just in thinking about whether it was proportionate, sure, you jointly own a house or you jointly own a bank account, and one of those people has nothing to do with, maybe they're even estranged and they still have an account sitting there. So I'm just adding that to sort of the discourse on the lack of any kind of sense of not only of notice, but of anything.
Thank you, Michel. Jessica?
Yes, I just want to come in on this question about how banks, if they're not told who the designated people are, very specifically how they identify them. And it comes through social media and media monitoring. So identifying people through that means, and then also through accounts. So if they're conducting transactions in Ottawa and they're not normally residents here, withdrawals, purchases, etc. So there's a couple of different ways that happens, which I think raises some issues in terms of whether or not outside the context of money laundering and terrorist financing, because we are talking outside of that context, whether that kind of surveillance of the population should be taking place. And then my next issue for us to consider, of course, is then what happens with that information? When banks have this information that individuals were designated people, or they've determined that they were designated people under the measures, they don't forget that. They remember, and that becomes part of their de-risking process. And banks are risk-averse institutions. So does this continue to impact the ability of these designated people to obtain financial services and financial products? I don't think that we've explored that in any real way. I don't think that there's been a lot of information about that, but I think that there's a real risk and very probable implications for the individuals who were designated.
Thank you, Jessica. Gerard.
Yeah, Gerard Kennedy, just to add a little bit on that, I realize we're outside of the terrorist financing context here, but many of the principles I think are analogous in terms of there are situations where you will want to freeze the account because it's really urgent. But as Professor Gallant noted, there are circumstances where it could be a joint account between someone who's genuinely engaged in terrorist financing and a completely innocent party, which is why there's a process to challenge that, which is why I think, and maybe it couldn't be exactly analogous, some sort of ability to challenge property seized under the Emergencies Act, analogous to under the Terrorist Financing Act, the Money Laundering and Terrorist Financing Act, is probably a good idea. And to Jessica's point that banks have the duty ultimately to do this, banks are not experienced in administrative law in the way that many aspects of the agents of the government are, which is why I suggest that the designation should probably be done by a centralized authority. I don't think that what affects the legality of what went on in February, or even whether it was necessary, reasonable, proportionate. It may have been all that thing, but I still think it would be better. Necessary, reasonable, proportionate. It may have been all that thing, but I still think it would be better policy to have it done by an entity that's learned in admin law principles. And yes, there might be some sort of brief period where someone's bank account is frozen unnecessarily, but I think it would mitigate it. And the incentive for the bank to do nothing is not quite the same as if there's an emergency regulator that has precisely this purpose.
Merci, Gerard. Patrick Leblond. Jessica, if I can go back to what you said, because I think this is an important point in terms of surveillance and what happens after, right? Once you've been designated either officially by some authority or unofficially by a bank, either officially by some authority or unofficially by a bank within the context of the regulations or something else, right? And you said that there's always the potential that banks don't forget, that they will use this in their risk assessment of customers, either existing ones or potential ones. And I don't know, and this is open to everyone, but should there be some kind of process, whether, obviously it's in a crisis situations like the one that we experienced last winter, or if there is something in a way more systematic put in place where people should have some kind of appeal mechanism or transparency where they could look at their risk profile, or I'm not even sure if it's possible, but because I'm wondering, for instance, what if someone, and we know, participates in a protest and they do so, in with good intentions, to go back to intent that Christian was talking about. They take part in a protest, maybe things get out of hand, they leave, they might get designated just because they were there, and then all of a sudden they have, a sort of black mark associated with their names. Do we know if that black mark stays forever? Does it disappear? Does it have an impact? Is there any way of finding out? I'm just wondering, because you raise an important issue, and obviously then there can be associations. It's like, oh, well, these kinds of people participate in those kinds of activities which potentially could be nefarious to the state or the economy or something like that. And so I'm just wondering, is there a danger? And then what remedies or safeguards should we put in place, even if to deal with the situation, but then what happens afterwards? I'm thinking young people who demonstrate and might be arrested, and then they have, some kind of record that affects the rest of their lives, even though, they might have changed their lives. So in this context, is there something similar, and what safeguards could we put in place to prevent abuse or discrimination in terms of the surveillance and even doing business? So I asked you, Jessica, but obviously this is open to the others as well.
Okay, if I may, I'll start, and then hopefully there's plenty of room for others to come in on this. My understanding of bank processes is that it's individual banks that are making those determinations about how much information they're keeping on their clients for any given time. The remedy is actually one of the critiques of our system, which is that there's strict privacy regulations around what banks can share with each other. So if an individual were to be debanked by one bank, that information could not be shared with another bank. So the individual in question could, in this example, go to another bank, and that bank wouldn't have the information about them having been designated, etc. So the remedy is actually in one of the critiques of the system.
Patrick Leblond, can I just maybe then go back to, okay, that's a very good point, but what if there is a list of designated individuals, which is shared across the financial system? So then you lose that privacy, right? Now you're on a list. You're blacklisted in a way for a particular situation. But is there a risk that then that particular situation then associates you as a risky individual for financial purposes going forward?
Jessica Davis here. So I think that's a question for the banks about how they handle that internal information and whether or not they'll be considering that going forward in their client decisions.
Thank you. Quelqu'un d'autre veut, Patrick Leblond? Quelqu'un d'autre?
Anybody else would like to add something? Christian?
Example here, right? So if you look at the fines that were leveled against Westpac and Combank, for instance, these are huge fines. And what that suggests is that the banks aren't actually terribly concerned about the risk that any one individual that's making hundreds or thousands of potentially quite dubious transactions poses. So the banking culture in Canada may be different, but the Australian example suggests that, well, I think this is an important point that you raise that affects, clearly affects, has potential serious impact on individuals. The Australian example suggests that we should be concerned about quite the opposite on the part of banks.
Merci, Christian. I see one hand, so Gerard, please.
I actually have a question that I'd like to ask my colleagues who are more substantive subject matter experts in this area for the earlier question, whether we have any questions. Many of the individuals financing the people in February may not have been here. And yet I don't think they fall within the definition of designated persons whose assets were frozen. So, and they may have been the people who actually may have been most efficacious to freeze bank accounts of. And does that affect your opinion about what policy should be going forward, how proportional things were of that nature?
Jessica?
Thank you for that.
You can also respond to Christian. I thought.
Yeah, so just on that, I think I'd have to go back to the regulations because I think that there was an interesting provision about financing of the protests, but so before I can't answer that without looking at those again. And then just on the example that Christian Leuprecht brought up, I just want to bring up the idea of profit motive for banks though as well. So, Westpac and some of these big organizations that have been fined these huge amounts, there's a significant profit motive for the banks in continuing that financial relationship that does not exist for individuals. So I think that the risk for individuals is far, far greater than for those kinds of, large entities.
Thank you. Michel Galland?
I would just say, as it's always difficult given jurisdiction to attach something. So it's the same reason, again, in the opening presentation, he talked about taxation. The reason you put your assets outside of Canada is a jurisdiction concern, right? It's more difficult to tax them. Not saying it's a crime, but it's more difficult when anything is offshore. It doesn't matter what it is, an asset in relation to tax or anything else. It's much more difficult for the Canadian state to do anything against that, particularly if you're not a Canadian. So if you had somebody, so anything, sort of any resource, the only place you can catch it is you can catch it at the border. But if it involves sort of a donor in Australia or in, Nigeria or in the United States, the reach of Canadian laws obviously doesn't cross that border. Now, I would say there are relationships amongst banks. So Canada's never done this, but the US has certainly seized this little thing. It's just called the correspondent accounts. But basically what they have done is if you don't follow what we want you to do, we will seize anything that's remotely related to your bank here. So say the Bank of Canada has what's called a correspondent account in New York. But as far as I know, we've never done that. But that whole question about jurisdiction is a difficult one. It's an absolutely difficult one.
Merci, Michel.
Thank you, Michel. So we'll take a break. Michel, I wonder if you want to add something. No, it's okay. Thank you. So I think we should take the break now, a 30-minute break, and then we'll be resuming at 4:30.
Okay, folks, we're going to fast forward out of that break so we can start catching up. It's interesting, though. I really like that guy that was on a remote call. I think you all liked him, too. He had some nice things to say. He's pretty aggressive about the narrative. But, yeah, here we go for the next little bit. This might be the end of it for the day. Here we go.
The commission is reconvened. La commission reprend.
Alors, nous sommes de retour. Patrick.
So we're back. This is Patrick Leblanc speaking. Christian is here. We have a few small questions, and after that, there are two issues of greater magnitude. The first question is, and this is probably a question for Jessica Davis. In a crisis context, when indeed one of the questions asked was the timelines, for instance, between the time when a transaction is identified and then the information is transmitted to CANAF and then analyzed by CANAF. Is that timeline important, or does it happen quickly? Jessica? Yes, generally, in a crisis, I would say that financial operations are submitted quickly to CANAF. Generally speaking, I would say the turnaround, when we have suspicious operations, the turnaround time is about 24 hours or less. And that's enough to decide if it's actionable? Yes, same thing. If there aren't many financial operations, the analysis doesn't require too much time to determine if it's actionable or if it should be transmitted to CSIS or any other agency. So I would say, yes, it's quick at CANAF. It could take a few hours or a few days, depending on the circumstances. In an emergency situation, it's a question we should be putting to CANAF as well. Of course, we're wondering. So indeed, the timelines are very short. Thank you, Jessica.
The second point that we had some discussions. One thing that was mentioned, and we talked about a lot of the potential longer-term unintended consequences for people who might be designated. One thing that was mentioned is the not only in terms of the banks, but what would happen, let's say, if someone's bank accounts or money assets were seized or frozen, and then they missed payments on their mortgage or on the couch that they bought or something, and then obviously their credit score was affected. Again, when we think about proportionality, should these things be taken into account, the longer term effect? Because then is there any redress? For instance, say, hey, yeah, I missed my payment because I didn't have access to my bank account because someone froze it, because I went to a protest, or I gave money to people who went to a protest. So I'm curious to hear whether such unintended consequences, potential unintended consequences, should be considered in the kind of proportionality tests when actually implementing or putting in place these kinds of measures. So I'm putting it open to everyone. So Michel Galland?
Sure. But certainly in thinking about the ruminating on proportionality, it would have been known. So when I referred to the privacy, or at least when I referred to the Privacy Commissioner has a report which simply talks about sort of stagnant financial information. So information, she's talking in the context of terrorist finance and suspicious transactions. So there's a little cloud on someone, and it's been investigated and dismissed. But the point she makes is there needs to be a mechanism for clearly purging that. So in the same, we don't have mechanisms. Somebody else wrote about this as something called the right to be forgotten, right? The right to have information actually purged and destroyed. But just in response to what you said, I don't think by any stretch it was unintentional, what intention means, but it would have been known, because it's always been like it's known that once something descends, right? As I said in her context, talking about once privacy and some information, it's there, right? So it would have been known that information was there. So this idea about was it temporary or not at the time, that piece that something might potentially linger would have been a piece that ought to, I think, have gone into, as you say, the analysis of whether this is proportionate or not. It's not temporary if you're, for some whose relationships or financial matters would have been disrupted, maybe not permanently. But as you say, even, the severity would be even something like, our bank account is closed and we live on the margins and, we've, the consequences there. But in this case, if you have one bank account and it goes beyond, then you're really in a difficulty. So,
Jessica?
Yes, I think that you're right to consider those things as some of the consequences of the asset freezing. The issue of there being a lack of redress, I think, is also well worth considering. How do you go to a credit agency and fix that? The only thing that I will say that on this is that the measures were in place for a short period of time. So I think that reduces some of those potential consequences, because 5 days is, in some cases, might make a difference for some people, but it's not a full pay cycle. It's not a full month. So I think that there's some considerations there as well.
Jart?
And just to build on that, I think that may be an argument that the measures were proportionate on the facts of what occurred in February, while also recognizing that insofar as this commission has a policy role and is recommending how to make sure that these more profound consequences are mitigated in the future, depending on whether or not it believes the threshold for invoking the act was met, there are recommendations that could be made to mitigate those concerns.
Mm-hmm.
Merci. Patrick Leblanc.
Thank you. Patrick Leblanc speaking. I would like to revisit the foreign financing issue, but in the context of the digital era.
Now, well, during the protest and then afterwards, crowdfunding platforms have to be registered or have to register with FinTrack. Before that, also, crypto exchanges, wallets operating in Canada have to do so. But I guess one of the questions, and I'd like to hear the panelists, is and Jessica mentioned obviously the compliance burden that it puts on an entity like FinTrack. But even beyond that, how does, or how can, I'm not sure, but if you have foreign entities, I assume if there is a crowdfunding platform somewhere in the world, or a crypto exchange, or a crypto wallet service, whatever they call themselves, you don't necessarily know or even care who's your clients, right? Especially if where you're physically located, at least legally, there is no requirement for, know your clients information. You may not know that, this person's from Canada. You may not even know that you have technically now that you have someone who has put money on your platform or donated money to your platform or is going to receive money from your platform, that you should be registered. So first of all, it's very difficult for an entity like FinTrack to actually scour the world to find out, okay, who's doing business in Canada, who's not. So that's the first thing. The second thing is, even if that were possible, say, hey, you're not registered. So now you have to register. And then, after, I guess, a certain time, you find out that the platform, crowdfunding, crypto, is not registered. Then what? What happens? Does FinTrack say, oh, you're not registered, you're not complying, we're going to shut you down? Well, that's not going to happen, especially if that platform is not in Canada. They can't really do that. Then can you block a website, like an actual IP address from this platform, say now Canadians no longer have access to that? Is that, and is that possible, or what is the process for doing that? And then even if you could do that, then what, isn't there this platform might just say, okay, well, now we're blocked here. We'll just create another IP address where people can go and do the same business they were doing before. And then you have to go through the whole process. And this kind of cat and mouse. So the big question is, even if we want to have this level of registration, disclosure, transparency, compliance, is it even possible, feasible? So I see Michel, who's now wants to say a lot of things. Michel Galland.
Sorry, yeah, I don't think it's possible, and I don't think it would be a good idea. So it's possible under a new technologically driven model, which my colleague referred to, whether you could have some kind of centralized system wherein Canadians were only allowed by law to use an electronic currency. You could have that. I think that's a very, very bad idea. It means that everything is capable of surveillance, regardless of what we've placed all the information in a central place. So I think that's bad. Not a good idea. I think facilitating exchanges is fine, but that particular model, which has come up recently, is not a great idea at all. And nor would I be, it's very, very delicate when the state starts blocking websites. So if we put this in the context of China and you talk about sort of, well, like when I'm there, I can't access these websites, what's going on, which to me are quite normal. That's a very, very delicate and a dangerous area. So whether it's to shut off funding or to shut off, access to my information, I mean, there are limits on the things maybe that we should have access to. But distaste or short of certain really extremes, the state's ability to sort of shut off, and I say that because we've seen that. We've seen that right now in the context of Russia. We've seen websites shut down, which reasonable people, I think, would completely disagree onto whether those websites they would have said that was my source of information and now it's shifted. So I'm just sort of responding to that. I'm really concerned. I would be very, very concerned about giving the state that kind of authority. Sorry.
Okay. Merci, Michel.
Thank you, Michel. Jessica.
It's a very complicated scenario that you painted for us. But I think that this points to one of my recommendations, which was that the government and FinTrack and Department of Finance as a policy setters should be conducting public consultations on these kinds of things, because this is the kind of scenario they should be test driving. How are we reasonably going to enforce these regulations? And then, just a little bit on the client issue, there is increasingly, crypto exchanges are increasingly regulated and there are know your customer requirements. Not all crypto exchanges are as good at that as others. And there's still, of course, the wallet-to-wallet issue that, unhosted wallets can conduct these transactions across borders, and attributing those wallets to any individual is exceptionally difficult unless you have quite good access to the individual's devices or other sources of intelligence. So I think that there's a lot of holes in this regulation, but not a lot of benefits necessarily.
But can I,
Michel Galland? Yes.
Sorry, Michel Galland. Yeah. I just because I think in something you wrote, you mentioned at some point in time, you talked about these things that are called, I think, Hawala networks or informal value transfer networks. So I'm simply asking you whether your idea is that actually, whether you see any value in this, in the fact that the state actually, so for these informal value transfer networks are outside of the formal banking system, and a lot of people have issues with them, but I wonder if you see any benefits with that kind of, because you mentioned cryptocurrency, so the idea of a decentralized system, the lack of state surveillance, the same, and I'm just drawing the parallel between the Hawala might have been an older version of a deregulator, the Mexico peso network might have been another. So I'm just wondering if you see any value in those kind of networks that aren't subject to intense regulation.
Jessica?
Yes. Most Hawalas are actually meant to be regulated under anti-money laundering legislation in different countries. They're meant to be money service businesses. A lot of them are not regulated because they don't register or they just operate outside of those regulated channels. The International Anti-Money Laundering Counter-Terrorist Financing Regime has been trying to address this.
It's an interruption on their part. We'll go fast forward. This is why we go fast forward. Or I think we're live now. I think that's what Railroad was talking about. All right, folks. Looks like we caught up to it. So let's go ahead and go to the live stream. Oh, it seems to be gone now. And I think one of my chats mentioned that too. Was it Dave? Yeah, the live stream's down. All right, folks. It looks like maybe something happened on their end because everybody has it down. Let's see. Let's go to live on this. Oh, we do have it coming back. Hold on. Just come back. There we go.
The commission is reconvened. La commission reprend.
Hello. Vous êtes...
You're in charge. Thank you.
Alors bonjour à toutes et à tous. Je m'appelle Patrick Leblond. Je suis le modérateur de cette séance. So I'll be moderating this session.
Alors, je vais animer ces séances sur la gouvernance financière, les services policiers et le renseignement.
Privileged today to have 5 experts, 4 in person, 1 person online. Premièrement, j'aimerais introduire Michel.
Let me introduce.
It appears they're replaying it though. Railroaded, are you there? Is that what's going on here? Or there's some sort of break and now they've replayed that session again? Because we're not going to replay it a second time. Give me a second. I'm still going to try and get the mainstream. It wasn't up. Let me see if it's up now. Yeah, no, it's down. Okay, so they're replaying because that's the beginning of the last one we just watched. All right, folks, something seems to be going on and we don't have a stream. So I'll do the questions, I'll do the comments, and we'll get that out of the way and maybe keep an eye on it. I'll do it without audio. And I'll keep an eye on this for you. And Railroad, if you have another link or something, I have no idea what's happening to. Okay, yeah, so we're all on the same page now. So we've all caught up, and they were starting to replay on that one channel. So let me go see what we got here. Yeah, they're just replaying it. So it might be a technical problem or something else is going on. And I don't have anybody there that I can text. Everybody went home over the weekend. But we'll go ahead and go through the start, and we'll see where we're at the end of that. All right, how about that? Hey, Terry, bud. Thank you for coming back. Interesting time frame. Exactly 4 decades since the signing of the 1982 Act. Yeah, I'm sure it's coincidence and stuff, Terry, but yeah, good note. You notice that. And then Mr. Green Thumbs, bud. Yeah, you're seeing that too. Just simple math, right? But coincidence, same date. I don't think it really means anything, but it just happened to fall on that date. Yeah, exactly, Alan. The smallest minority is the individual. And this is all about protecting minorities, and even the individual is a minority. We all need protection sometimes, especially from our government. Hey, Dave, many of us were caught by surprise. They sure didn't make it clear that there were more next week. In fact, I actually met the commissioner at the end, and I talked to him about what's coming up next week. And we only talked about submissions. He didn't mention anything because I would have been all over that. But, well, here we are. And what I found on the website is it did say it is for this entire week. And then we found the PDF on all the different people coming. And it looks like 2 sessions a day. And then Friday, there's 1 session. Could be just a morning. Then maybe another wrap up. And the stream just died on the other stream that we were looking at too. So there's something going on with the stream right now. Because even the backup one is no longer working. Maybe they upset the Bitcoin market, crypto market too much. Yeah, it's still down. They're fighting back. Some of the conversation wasn't bad at all, especially the one lady on the end and then the one guy from the video conference. It was excellent. We'll get to that. I want to see criminal lawyers on his panel or roundtable. For what, Green Thumb? To talk about criminal defense for people, to highlight what specifically. Want to try and define real violence or types of violence. What would you like to see a criminal lawyer do for you there, Green Thumb? I'm not saying we shouldn't, and I'm saying you're wrong or anything like that. I'm just curious more as to why and what value you think they'll add. Nothing on Brendan yet. And was okay, Terry. So I did talk to Keith exactly on this subject. Keith made a decision basically the minute before or so to put Eva up there. Now, his reasons that he told me, and then I pried a little bit later after, were she was softer spoken, she had a good demeanor to throw off Trudeau. They felt that Brendan has a very direct and strong demeanor, but Eva would have had a different approach. Nothing about the bilingualism, and it wasn't anything that Brendan couldn't do. It was a choice on the team for Brendan not to do the cross and not to do the close. It was originally planned to have Brendan do the close, but I don't know about JT himself. I wasn't clear on that part, but originally it was him to do the close, but Eva did it. I did ask whether or not Brendan was being stressed and under a lot of stress, especially with that lawsuit and other things, and the answer was yes, he was under a lot of stress, but that wasn't the decision making. It was all about who handles who in a certain way, and Keith made the call that Eva was going to do Trudeau. So it had nothing to do with being served. It had nothing to do with any of the actions or requests for documents and stuff, but the decision was made by Keith, and he's the one that told me that he made the decision, so I take his word for it. But I think it was still a very good closing. Like, if we go and watch her closing, the last thing she said was, "Is a good reason for Prime Minister to resign." So if that's how you feel, she was very vocal about that. Sagreen, welcome back. Hello. I believe that by the end of the week, we will understand why the EA was enacted. It has absolutely nothing to do with the events in February. Okay, I'm keeping an open mind, Staggering. We'll see what we get out of it. You might be right. We'll see what we get. Hey, Tina. Nice name. Williams, Miss Williams. National Citizen Inquiry. Yes, everybody, please share this link and go and fill out the survey. I did. It just asks you if you were harmed in any way, and you can leave your own note. No identifying information, just your postal code and province. But go ahead and sign it, and you can also check off you weren't affected. So this applies to everybody. Either you're affected by something with COVID-19 or not, and you can go ahead and fill out that survey. It will help. Hey, Tammy, welcome back. Nice to see you. It was a little surprise event that we had here, but now we're going to be here the rest of the week like we were all 6 weeks, starting at 9 o'clock. All right, I want to look at this. Section 132 of the Criminal Code for perjury, 14 years max. So let's go ahead and pull this up. I want to go see what this is all about. There's max, but no min is, I think, what you're applying here. Criminal Code 132. Okay, let's go pull it up. And see what we can find here. Criminal Code, we want 132. Everyone who commits perjury is guilty of indictable offense and liable to imprisonment of a term not exceeding 14 years. If it's indictable, let me go check if it's summary or indictable option. Indictable. So that means a minimum a year. Indictable, or 6 months, I think. 6 months is a minimum for indictable. Because anything 6 months or less is summary. And it doesn't look like this is an electable one, but let's make sure. I thought I read somewhere 2 years, but I think it'll be in sentencing. Minimum. I don't think there will be anything listed, but it says indictable, so that's 6 months and up for imprisonment. And if it's over a year, you're in prison, not just jail. Let's see what we got here. That's high treason, so we're off track now. But It's hard to get convictions. You got to prove it. Burden of proof will be on the person laying the charges. Remember, you're innocent until proven guilty, and these are criminal charges. So the burden is on the charger or the prosecutor. You can do private prosecutions or have the police do it. It'd be up to them whether or not to carry it forward to the Crown. But Phil, this is what we're doing. After this is all done, we're going to be going through looking for perjury and trying to prove it. And if we can do that, then we can go ahead and do private prosecution. But we'll get there. We'll get there. How do y'all work lunch over? I'm back. Work lunch over. Okay, welcome, Clay. There's that bear. Nice to see you, buddy. Oh, hold on. Something's going on with the stream. You just went black now. Something's going on. This is a policy committee. No one's under oath, I believe. Is pure government agenda to alter our rights. Staggering, a little cynical. Yeah, I know he's under oath. This is more for information for the commissioner, and he's getting all he can. He's going to be asking a lot of questions. These are considered to be experts. And so far, we're getting all sides and some pretty strong opinion that looks good and favorable to us. And also some of the questions from the commissioner is good so far. I'm not averse to what's going on here. Again, I'm all for information. So the more we get, the better. And Prairie, harm, physical or mental injury. Yeah, there's going to be harm. There's going to be assault. There's going to be violence. There's going to be threats. There's going to be a whole bunch of stuff in this broad definition that they're talking about. And yeah, there's going to be physical harm, mental injury. There's going to be a socioeconomic. There's going to be a bunch of different stuff. But that's what we're here for, right, Barry? To hear what they're talking about and see where it goes. And the layout for the entire week is actually kind of interesting, the way they broke it down to the various topics. I think it's going to be an interesting week. We'll learn a lot. And Railroad, you were talking about me doing some stuff about teaching the basics of law. Well, that first half was all about fundamental freedoms, right? It was a good start. We got some constitutional information in there. Hold on a second. I'm just going to look at the chat of this other one. Let's see if I have any information in there. It's back. It's saying it's back. I'm going to go see. 1 second, folks. I'm going to see if it is back. Nope. Not back for me at all. Let me know if any of you have it. Yeah, right at the crypto reference, eh, James? Yeah, that's why I said maybe, a little internet hiccup or something. Get rid of that. Hi, Justin, you are correct. However, it's not an act of war. Freeland herself described how she asked do economically retaliatory measures against the U.S. So is that to an attack? So we had a comment about attacking the economics of a country is also an attack on a country's national security, but that just can't be. Maybe if you say complete crippling of, or complete destruction of, or complete undermining of, so that there's none left, maybe. But what we're talking about here is some interruptions on the border and stuff like that. Now, Freeland herself talked to us about economic retaliatory measures against the U.S. For example, the battery rebates was something they were going to look at retaliatory measures for. So does that mean Freeland is declaring war in the U.S., according to Justin? I think his comment was very inflammatory. He was trying to make it seem like a little bit of economic stuff is national security, but when you look at it this way, then Freeland herself is levying national economic attacks on the U.S. The truth is economic retaliatory and economic impact is minimal, and that's why we have things like sanctions when there's wars and stuff, because that's what you're attacking. So I do agree that attacking economics is a type of attack. That's what sanctions are. But then them in themselves, and also the minor versions of it, don't make a national security issue. All right, it looks like, yeah, it looks like that other stream ended now. So they're not moving ahead. So it looks like, as far as they're concerned, it's done. And by the way, I cracked my lip, so I sound a little bit weird today. Gotta be careful, it's dry out there. All right. Oh, I'm gonna stop the screen. It's flashing on me. Okay, Terry, hey bud. I'm a little confused as to the choice of order of issues here. They don't seem to be chronological. I think you were talking about the talking at that time, but let me pull up that PDF and share it with you, and we'll go through it. So we'll see what's going on for the rest of the week here. Here we go. Okay, so today we had the fundamental rights and freedoms at stake in a public protest and their limits. That was a decent conversation, I thought, because we are talking about this throughout, that we thought some sort of recommendations would be in place and start to limit protest because it's only defined as peaceful. And we heard this many times as they were going through this. I'm not averse to trying to find ways to limit the impact on innocent bystander, whether that is a resident or business. Innocent bystander, I think, is where a lot of us can reasonably start drawing limits on where we would probably feel comfortable in agreeing that that's maybe where we can find ways to at least ahead of time know that this is not going to be good for the people that are innocent. But here's my big problem with everything I just said there. Limit in what way? Who's going to say what? Where are you going to draw the lines? What's going to be the definition? And will every single place except for a small square that they give us fall under that definition? So this is why I'm being super careful about saying I don't mind limits, okay, because I don't want them to be abused, and I know they will be. So this is my entire problem with even having any type of limit on protest is who defines that and what stops them from abusing that. And then Terry will go to the next part. And then, of course, we just watched the financial government's policy, policing, and intelligence, but only part of it. Something cut it off at some point. Coming up tomorrow, this is going to be a really interesting one. Misinformation, disinformation, and the role of social media. We're going to pay close attention to this one because who says what's different, misinformation and disinformation? Who gets to define that? And social media, this is how we're connected. So we're going to pay close attention to that one. And then tomorrow afternoon, the protections of flows of essential goods and services, critical infrastructure and trade corridors. Well, you see where we're going there. Interested on where they want to create. Like, are they going to put up walls? What are they going to do? How are they going to stop people from protesting or otherwise? So that'll be an interesting one. I think the misinformation, disinformation is going to be the big one, though, for tomorrow. Here we go. This is a big one for us as we define all this stuff and figure it out. National security and public order emergencies. That's why we're all here, right? So are we going to get into more conversation around what is a threat and C or 2C of the CSIS Act, etc.? Policing of public protests. I believe the residents are really going to be paying attention to this one because we found out that certain policing was called off and bylaw enforcement was called off. So this will be interesting. Thursday, police government relations. So there's supposed to be a separation. Government is not supposed to direct police. So this will be also interesting to see where lines are supposed to be, where they cross, what is the difference between directing the police officer and withholding resources or providing resources. Like, in what way is influencing the police? Could you be influencing police response by withholding resources, for example? Get into some more of that conversation. Interjurisdictional responses to protests and emergencies. This is going to be about whether or not provinces can help themselves and with partners. BC helped Alberta with some stuff. But I also think a main part of this conversation will be about how we define national emergency. Okay. It's been pretty clear that there's municipal and the provincial, but we're really trying to figure out what is the definition for national. Even if everything they said was true, as soon as COUS was closed or fixed up, it only became an Ontario issue at that point. And what level of emergency in either provinces or all provinces are necessary? Like, for example, did Alberta invoke their provincial emergency act? And I'm not sure. And did any other province other than Ontario do it? We'll look into that a lot more. And then Friday, there's just one. Thresholds. This is a big question. Did we reach the threshold of CSIS, etc.? Powers and accountability under Emergency Act. So we're going to have a whole panel. It could be an entire day because this is the most important issue, right? Did we cross any thresholds at all? And if so, what powers are available? And then what kind of accountability is available? It would be interesting to see. But that's what we have for the week. And then that's it. I really think that's it. The submissions I do know are written. I have had confirmed many times. I'm not going to go standing up there talking about them. They're submitting them by writing. So we'll keep an eye on that. Hope that helped, Terry. Hey, Brenda from Facebook. Welcome. We were seeing his colors now. It was nowhere near violent. Attendees had violence against them for sure. The little girl, 11 years old, a man ran after her to take her flag, and when her dad tried to stop it, the thief knocked him down. People walking by watched over the thief while the dad checked to see if the daughter was okay and called 911. I believe there's video of that, Brenda. I know there's video of a gentleman, a resident or counter-protester taking a flag or a sign from a young girl. And then that person himself kind of got chased down without being assaulted, slipped on some ice, and it looked like it broke his ankle. So karma took instant karma right there. And then the police were right there as well, taking that person away, not the other people. But what I would think you brought this up for, Brenda, was they were talking about violence at the protest and potential violence. One part that we do have to consider, because it is a source of violence, was the counter-protesters as well. And we are hearing more and more of that even though the protesters were nonviolent, the potential for the counter-protesters to get more and more violent was also there. And that is something that they'll have to consider, because violence of any kind has to be considered. What I think we definitely have to be careful of, though, is having a precedence where counter-protesters' violence gets transferred to protesters as violence, and then the protesters get treated as violent because there is violence involved, even though they're not the ones who brought it, right? So I can see how they're saying potential for violence didn't necessarily always mean the original protesters. It could have been counter-protesters as well. And frankly, I've heard a lot of that now, where they were worried about the counter-protesters and their ability and desire to increase the violence. And that would be something that the police would have to be aware of and try to avoid as well. So even though the main protesters are not being violent, it does bring violence. So this is what they're trying to address here as well. And I did get the impression that they're trying to find a way to not get innocent people wrapped up in that, because a few times they talked about proper peaceful protesters and they're not being violent. So let's see how they navigate that one. Hey, staggering. How is cryptocurrency relevant to the evocation of the EA? It isn't. Nevertheless, it is part of the government's second mandate of the inquiry. Yeah, there seems to be a lot of power grabs here, things that they're going to try and get out of it. New definition of peaceful, new definition of violent, new definition of national security, maybe a central command, a lot more financial tools, especially around crypto and credit unions. As we're hearing, fintech was doing a lot of work already, and some of it they don't seem to think it needs any changing, which we'll get to, because some of that stuff was good. But to answer your question, though, staggering, they're trying to use it as a source of unregulated and uncontrollable funding for the insurgents is kind of where they're going with that. So the foe or whoever's coming against the government, if they can't choke off the funding, they find that to be a problem. And that's why this is coming up. But I do agree with some of the panelists who said, no, don't do this. We have tools with fintech already. We won't get any more information. But there's certainly one or two people that are pushing for a little bit more access into crypto to understand who's got what, because it is so anonymous. So they use this term called get to know your customer. You've heard that a couple times now. That's a requirement for crypto in Canada, because I had to provide ID to get an account. But that's not a requirement around the world. So this might be where they're going with it. And I've done all my crypto through Canadian registered companies. Because quite frankly, I want to be able to sue and have some protection too. Crypto market is very dangerous. If something happens, you get robbed or something like that, like digitally robbed or something. It's very difficult. But I did keep mine in-house. Not much though, by un petit, little tiny bit. Just enough to say I have some. Eleanor, how can we be having this discussion when the facts aren't presented, redacted and privileged? I know. Ugh. Keith and I spent like an hour on that topic, Eleanor. The redactions, how to get them, the fact that we proved some of them were wrong, shouldn't have been done. Does that mean all of them have to be reviewed? The answer is yes. And there was a lot of work going on behind the scenes behind getting that stuff done. Of course, the government is not going to be super keen on assisting as fast as they can. They created the problem to begin with. But when pushed on certain documents, and I believe part of the process might be somebody other than the government gets to see it. It could be the commissioner himself gets to see the unredacted one and then decide on the relevancy of it. Because somehow they are able to identify which documents they want and get them redacted. And that's going to be because it's targeted and specifically asked for, because they're not doing a blanket unredaction. But Eleanor, I feel you're paying 100% on this one. And for years, data is still going to be coming out. The Kennedy assassination, right? There's still information coming out from time to time. It's always going to be that way. What we got to work with is what we have now and keep fighting for more. So access to information requests, Eleanor, and other injunctions or motions, or other tools that are available to us as well to fill in these gaps and find these holes. Now, the good news, Eleanor, is in big, black, bold lettering or blocks, they showed us what we need to focus on, okay? Because wherever they did that, that's where I'm really, really keen on focusing on. So when it comes to access to information requests and stuff, we can point to documents and point to irrelevant and make arguments to have it opened. But I feel you're paying, Eleanor. We don't have that transparent government that Trudeau ran on, claimed he was going to give us. We don't have that. But we have some information that we're working through right now. Crypto is relevant as a banking laws encompass it, i.e. FinTrack has the ability to seize private crypto wallets now. Does it, James? Does it? It would have to be only ones in Canada that are regulated. So the ones that I use, I'm not going to mention them. That's just asking for headaches. But yeah, those ones maybe, for sure. Can be seized, locked, accessed along those lines, possibly, for sure. I think so. But nothing outside of Canada, nothing that's running at elsewhere, exchanges as well. And yeah, they talked about that as well, that how, of course, outside our border, Canada has like no power to influence or direct anybody to do anything. Doesn't mean they won't try, though. Hey, Terry, there it is. Unknown leadership again. See the day Freedom Corp incorporated with a bank, a board, accountants, and lawyers. They were people to talk to and an issue. Vaccines, mandates, frustrating. Yeah, and I spoke to Keith about that too. He was very adamant that he was frustrated that they keep using that narrative that there was no place to go for a large portion of it. They had the name. They're incorporated federally too. So under Canadian government, federal government incorporation laws. Here, sorry, Eleanor. Yeah, I just addressed this. You have to keep moving forward with what we got, but keep pushing for more. Hallie. Could it be that the mainstream media had Canadian citizens in downtown Ottawa scared? Yeah. We have some interviews, Hallie, on our stream. I'll be breaking them out at some point with residents from Ottawa. Had no problems. Lived downtown, had the honking the first night, had no problems. But they didn't sit there and watch the news. They went out and looked for themselves. Anybody who did that went to go look for themselves, came back with the same message. This is not a hateful group, and they're not there to harm. They're there to voice their opinion, voice their message. Yeah, Jordan Peterson would be great. But I'm not sure where he would fit on this. He's not a constitutional guy. He's more of a, like, he does the pronoun stuff. He talks about that, a lot of intellectual stuff around God, around morality. I think just him in general would be a great person just to hear from. But when it comes to the vocation of the EA, I'm not sure where his expertise and specialties would come in. He would be compelling to listen to, for sure, and it would be cool to see that happen. But as it relates to the material requirement of this inquiry, although being very good voice for the Canadian people, and maybe that's the answer, he's not there on expertise of anything else other than the representation of the Canadian voice. Other than that, I'm not sure what value he would add. Hey, Dave. It's so funny how all of these people drop the mask all of a sudden, huh? Dave, I'm not sure if you met, I saw it, but I interviewed Paul Champ, Mr. Mask himself, Taxer Rich. He came over and dropped his mask completely down under his chin and had an interview with me about as far as where this microphone is. Yep. And if he was speaking moistly or I was speaking moistly, we would have been sharing fluid. He was that close with no mask. So I guess COVID doesn't pass anywhere near when you're like inches away from another human being, stranger's face. But while you have the mask on, while you're away from them, you're protected. It was kind of comical. He had some cool, interesting things to say, but the whole picture of him pulling the mask down to do the interview caught us all off guard, and it was kind of comical to some of us. And I'm sure my husband, oh yeah, so Ellen was saying here that she loved that guy and would marry him or something like that. And she was sure her husband wouldn't mind. Freedom for all. You're awesome, Helen. Take it for the team, right? Keep them everybody happy. But no, that is a really, there you go. I want to marry him. That is some really cool testimony that came out of him, or not testimony, opinions and statements that came out of him. The truckers deserve that money for traveling so far in trucks to stand for freedom and body autonomy. The government stopped it because they are dirty and greedy and mean. Dirty, yeah. Greedy, yeah. Mean. That's an emotion. It's an emotion. The results of their actions can be deemed mean. The prosecutions of people can be deemed mean, like tomorrow. So yeah, you're not wrong. I don't think there, Julie. And then the truckers deserving of that money. It's a strong word, deserving. I think their expenses should be covered. That was the original purpose, but that money was also refunded. So not sure about deserving, but it was a way to cause problems and headaches by interfering with that money for sure. And I don't want to see this to become a precedent. I hope that this is where we stop that from happening again. Foreign funding like Freeland borrowing $500 billion from the U.S. of A. Yep, Patricia. By the way, lots of great chats out of you, Patricia, on Facebook. So thank you so much for being there. But 100% foreign funding, the way they described it is anything that went across the border. So if you order Amazon and it happens to be a purchase from the States, that's foreign funding. If you do a donation to UNICEF, that's foreign funding. Everything becomes foreign funding that happens outside of the border. What they're doing, though, is they're trying to just tie the word foreign funding into maybe possibly some of the definition of the thesis. Political funding, too. I think the Supreme Court has already addressed that, though. Great point. EO was temporary, but consequences were not. Terry, we still have the consequences today, even for the donation. And some people said in the chat that bank accounts were still frozen to today. I'm going to challenge that one only because EA invoked bank accounts were unfrozen like all at the same time. Other accounts are still frozen. Could be under litigation, like Pat King. And you prompt me to go ask real Andy Lee, and she hasn't got back to me. So I don't know if her bank account was closed or not. I've asked her. So when I get an answer from her, I'll report it. Okay. And then John, you're right. This is paving the roadway to UBI and social credit by the IMF, WF. Canada is a test case. That is currently behind schedule. John, it's Australia, New Zealand, Canada, France, and US is the Big Apple. Okay. Now, they're working them all, and there's even a couple little ones, but they're working them all to see which one produces what they're looking for. Like a very good experiment, you don't do one. Okay, John? So Canada is one of, not the only one, in my opinion. We're seeing this experiment happen all over the place. So I really think just like incubating and variants, you want many of them doing it until you can get the one you're looking for. So I think Canada has been selected as one. Any one of them ones that had global leaders part of that program is the ones you got to be looking at. So Australia, New Zealand, UK, France, Canada, and there's others in the US. All right. We'll hit the chat for a bit, and then we'll call it a day because the stream's done. All right. What do you got here, Patricia? You got a lot of good stuff. So I'd like to know why they are talking about how to take away bank accounts in crypto while they're supposed to be deciding whether or not Trudeau had the right to invoke the War Measures Act on his own citizens. Patricia, because I think what they're trying to establish or disprove is that the financial measures that were taken in the EA were necessary. So that was part of the EA, was freezing bank accounts and going after crypto. And then it also became permanent after the fact. So I think it's very, very relevant that they're talking about it now. Because if it turns out that under the EA, they should never have been used and it wasn't appropriate, we had other means. For example, one of the arguments that we heard, Patricia, was there's no direct target. It impacts other people, joint bank accounts, business bank accounts, employees. So they were talking about how that's a problem. And I hope what we get out of this, Patricia, is a recommendation to never do that again. And then we can maybe use that recommendation to start unwinding the permanent stuff that they did. Because again, it's not laws. They just put regulations in. So we can undo them as quickly as they put them in. Hey, Adam. So they got rid of it for that reason. So they will get rid of it for that reason. I'm sorry, I lost the context on that one. Trudeau would be too scared of Brendan to be able to answer questions. He would probably run to the car as soon as Brendan says who he is. Maybe. I would have liked to have seen it. Really, I really would have liked to have seen it. I did like Brendan's style. I did like what he was doing. He was getting aggressive and rude at the end by walking away all the time now. But maybe that was something they were trying to avoid, is that too? But yeah, I would have preferred Brendan. I think Eva did a great job. I'm not talking about Eva's performance at all. If Brendan didn't exist in the world, Eva's the one. But we watched Brendan for so long. We grew to love him. We liked his mannerisms. We liked his way he dealt with it. And it was kind of disappointing to get all the way to the end with Brendan and then not cross the line with him. So I'm still pretty happy with what they're doing, but looking into it, I would have preferred Brendan. Crypto is worth nothing. It is digital currency. Yeah, Diane, nothing wrong. Crypto is only in the value that's people are willing to pay for it. It's not tangible. So you're not wrong. And I know it's controversial what I'm about to say next, but unless you're a software engineer and you've looked into the blockchain and how crypto and specifically Bitcoin works, I do believe it's meant to collapse. There's a purpose to it. And that collapse will destabilize the confidence in crypto and yada, yada, yada. And then they'll usher in one single one that everybody can trust. At least they tell you you'll be able to. POC 22 original. That's a video file, what you're showing there. So is it back up? Are you saying it's back up? Because I've been looking into downloading all the videos, and that's what it looked like. I'll check, but the other stream stopped. Stopped completely. Nope. Still nothing, Eleanor. Sorry. Searching for the stream. Yeah, no, it's down. Sorry, I just checked it again. Maybe they'll have to address it tomorrow. Could be technology. Have we been consumed by technology? Someone pinch me. Are we still live? Well, we are, but the stream's down. I'm still going to keep an eye on it, but the other one we were using Railroaded to catch up on, they've shut their stream down, so they decided it's done. Facts, Jason Levine. Are you sure it was Champ that was Pat? Yes, I am. Eleanor, absolutely I am. They spoke about it when Pat was on the stand. If you want to see it, rewind Pat, go to the Champ interview, the very beginning. It goes along these lines. Hello, Mr. King. Do you remember me? Yeah, you're the guy who froze my bank account. And then Chump responds, yeah, you mean the ATB one? And then Mr. King responds with, yeah, and that's the one with my children's school fund or something like that. And then Chump's response was like braggadocious about, yeah, I found your account and I froze it. So to me, coming from Champ and Pat King, talking about it under oath for Pat King, It's pretty clear, Eleanor, that yes, Paul Champ froze his bank account at ATB in Alberta. And that's the only account we heard about through the whole testimony that's still frozen. It's been frozen for the entire 9 months. But that's wrapped up in litigation, I assure you on that one. It's not the EA. Oh, Gabriel's back. His accounts are passed out. Yes, Rosario, and we're glad. I did see him there. I didn't get to chat with him, but I did see him there a couple times. And yeah, he seemed fine. The inquiry is still all one-sided. Diane, I'm not seeing all one-sided, especially some of the testimony we just heard before it got cut off. It seemed to be very anti-regulation and anti-getting the government to get involved in it, adding more to FinTrack. It was sounding pretty decent to me. That was awesome, Karma. Yeah. Exactly. Mr. Greenthime's cool, buddy. Maybe they should have froze the counter-protesters' account, then seeing them as they were violent ones. Don't disagree with that. I don't disagree with that. And how do you know that none were? We don't know the 288. We just know there's 288. I think it's highly likely that there's only trucker-related protesters that had their accounts touched. But not everybody. Like, I know that Keith Wilson did not have his account touched. Tom Marazzo did. Is that right there? Did I get that right this time, Rosario? Marazzo? He did have his account frozen. But not everybody. I don't think Eva either. So maybe none of the lawyers did. From what I heard, Coots was done. Windsor was done. He brought it in on downtown Ottawa. Listen to 24th of November Special Joint Committee on EA. It's worth listening to. The compliments in this conversation were only because of the convoy blockades disrupted trade. Okay. But Senator Mr. Larry Brock brought everyone back down to earth and made them all aware why they are protesting mandates facts. Yeah, I think what we might even do is when this is all done, we'll go and play some of those committees as well to try and get all the information out, because some of it overlapped on the videos and the time. So we have to go back, Roxanne, and check in some of that as well. But thank you for bringing that up. Yes, Canadian exchanges. Yeah, anything to do with Canadian exchanges, they want access to. And I do play in the Canadian exchanges. Good distinction, my bad. Cool. Hey, Terry, looks like a decent-sized protest outside the Chinese embassy in Toronto happening right now. Wow. I say wow to that because JT is so proud of and he admires the Chinese system. So if they decide or they collapse, maybe he will maybe he will take away and stop being so proud of it. I don't know, but this is good news. And Brazil, too, keep an eye on them. It's on the POC website. The mask is strongly recommended. Yeah, it is. It is. It's always been there. But 5% of people there had them. The security had them more than like most people. Not all security had them. The main security guy didn't have it. The main security guy is a really cool guy, by the way. He's very stern and very strong, and he's a very good security guy. But I had to butter up. I had to be nice to him. I had to, charm him, because the main security guy is the guy who's going to get you through when you need it, and he did. He got me through later when I needed it. So I recommend being nice to everybody. It helps. Jason Levine, regarding perjury, okay. If we can access documents submitted by David Vino and see he was talking with Freeland on the 11th, perjury? Who's Dave? Yeah, who's Dave? I think that would be perjury, yeah, because she didn't say, I don't think it was him. I think her actual comments was, it's definitely not him, but I don't know who. And just like Trudeau with the name calling one, they word stepped it so well that Trudeau's comment that he didn't name call unvaxxed isn't perjury. Unfortunately, we looked into it that night. The group of us went out for dinner, looked into that one that night, Friday. And his comments before were those more related to those that didn't like vaccines or didn't trust them, along those lines in French, which didn't mean necessarily the unvaxxed. So these are politicians, and he knows what he's doing. He used certain words a certain way in order to skirt responsibility later. The unfortunate part was that question needed a second question after it, which wasn't asked. The first question was, did you call unvaccinated names, and he said, I did not call unvaccinated names. We all gasped in the crowd, and then they went on. But the next question should have been, well, then who did you call names? Define the group that you called those names to. He didn't get that question asked to him. Had he done that one, then he would have been forced to, A, admit that he called people names, which is exactly the whole point of that question, was that's not a unifying thing for Prime Minister to do. But he would have had to admit that he did call people names. And then B, more articulate and clearly define exactly what group were you talking about. Unfortunately, that question wasn't asked. Those are the questions you need to ask after you don't get the answer you're looking for, but it wasn't. So I do think after looking at it with some people, he squirted through just enough that it's not perjury, unfortunately. But the good news is, because we identify perjury properly, and we're going to work hard and making sure we do it properly, when we do find it, it's going to be a lot stronger and it's going to stick, okay? So I know that we want a lot of things to be perjury, but there is a standard and you got to be able to prove it. So can't prove that one statement because he was on the line, not over. But the Freeland Dave one, yeah, absolutely. If it is him, that was a full out lie then, because you said not him. I know it's not him. What other Dave would you have the power to designate? We all know the truth here, Leachy, don't we? We know the truth. And yes, if we can get information to find out who it was, maybe look at his documents and maybe we'll find the ties there. But that was a bad lie. And I'm pretty sure it was. Unless it was just somebody else in his office, just a different Dave. Yes, we're catching up now. The rest of us are live again. There we go. There we go, Railroad. What a day, hey peeps. Yeah, sorry, Railroad. It wasn't perfect. It didn't flow like all our other days, but we'll roll with the punches. It doesn't have to be perfect. You got it. Railroaded. You're awesome. Diane, we the people need to get united so we become stronger and go against this government. Yes, Diane, and this is what we're doing here. We'll keep doing these. We'll find a way to keep talking, find a way to keep sharing, get the information out. And it's growing. I think our side is definitely trending up now. We are gaining supporters as time goes on here. Hey, Dave, the government are going to end up shooting themselves in the foot with regulations overfunding. Possibly, yeah. And more regulations and more problems. Smaller government's the right way to go, I think. And some of these people who are talking like this, they may not be talking like that later when it's their bank accounts or their cryptos or their financial savings or their insert name of financial tool here is impacted. Hey, Charlie, are they done? Sorry, just got back getting my horse fixed. Horse fixed? Stop. Okay. Hopefully you can ride your horse again. Something happened to the stream, Charlie. It shut off. Shut off a while ago. We've been keeping an eye on it. I'm checking it again. It looks like it's been several hours to shut off. If anybody has any news on Twitter, because it's shut off midstream. It wasn't even like a goodbye. We were talking about crypto at the time. She said that absolutely not. Yeah, exactly. Yeah, more than once. Yep. In her testimony, yep. So that one is going to be easier to show perjury if we can make that connection, because she was definitively certain. Doesn't know what David was, but it's not Vigneault. So if it is Vigneault, we got you. My tweet about this is on point. No one cares about the names. It was all a take up space, and do we tolerate them? Yeah, okay, James. Yeah, so if that's the different reference about taking up space and tolerating them, then that would also fall outside of the name calling question. The name calling question was about the specific name calling. But in either case, I think we're going to be analyzing this for quite some time. My quick analysis of it Friday night after that happened with the people that were at the inquiry and at the dinner, we felt that he was able to weasel his way through that one just enough that he is not perjury. But that's still an opinion, right? That's just an opinion. But he said, I didn't call unvaccinated names. Correct. But what he also said, Alan, was he called the conspiracy theorists the names. That's what he was referring to there. Again, I'm not trying to defend him at all. But he did separate unvaccinated from those that don't like vaccines in general, anti-vaxxers. I think it was closer to what he said, not the unvaccinated. Now, we know he meant one and the same. We know exactly who he's talking about. He could have just said basically Alberta, and we know exactly who he's talking about. But when it comes to perjury, it can't be, it has to be more than that. It can't be what we assume or what we believe. It has to be more than that. And as much as it sucks sometimes because we're not getting that last little leap that we want, you'll appreciate that that limit is high if you're ever on that side and you ever have to deal with that. I do want him to be caught, but I do believe not only was he prepared for that question for a while now, even when he said it back then, it was carefully worded in such a way that he can get away with an answer like this. I don't like it, but we're also got to be fair. We can't take an extra step that isn't there. Trudeau said he never called anyone names or fringe. I understand. Railroaded. Yeah. I was like physically there. I understand. It was very upsetting to a whole lot of people there, and me too, immediately. That's why we went through the video after, to go back and to see exactly what he was saying there. And I'm going to hold on that one, Railroaded, at this point. It was just enough to skate through. Charlie, yes, and over the day, Jay's catching up to the chat. Almost there. Yeah, I'm catching up. Yeah, I'm getting to the bottom here. He used race, in his campaign. No, separate from the French TV interview. I think, I'm not sure. I don't want to say yes. I know the French interview that he did on the TV shows where a majority of his comments came out of. I think fringe and unacceptable views and stuff also came out several times after that. But racist, and let's be careful, just like the Yahtzee flag. Let's not make more incidences that actually happen. Like there was one Yahtzee flag, questionable who had it, questionable who took the picture, but then they ran with the narrative that there's multiple. So let's not do the same problem. If it was only said once, let's make sure we're only talking about once. But I definitely know that he did fringe and unacceptable several times after that. And even some questions in the House, I think he was asked around that. So I only looked at the one Fringe TV interview one, because that's the most famous one that we're all aware of. So if there's more staggering, then there may be other reasons to show that that was perjury than just that one French interview. Thank you for all doing to inform the public. Hey, Diane, happy to have you here. And the chat's also very good at this too. So maybe you're speaking to the chat about that. Thank you. But in either case, we're a team here. We're doing our best to get the information out. We do talk and interview other people. And it's been a lot of fun. We went to the inquiry, interviewed people there, saw some of it in person. You'll see this hat and this jacket all over the video for those 2 days. But thank you, Diane. If that was meant for us and the team, we appreciate that. That's what we're here for. Thanks, team. There you go. Railroaded, yeah. Rest well. We'll check in tomorrow and see what's happening. Lord willing, the crooks, there's no rise. I wish I still had somebody there, but I know they're all back home now. We'll find out, Railroaded, but it'll be 9. I'll start early, just like every other time, and we'll do a half an hour chat before and look into maybe more of what's gone into the stream. He denied it while under oath as well, but under oath he said unvaccinated. Problem is he still calls somebody. Exactly, Ellen. And that's why I would have done that second question. That first question, he was able to skirt it, but I would have had him on the second question. The second question was, in who did you call names? Because then he would have had to be more clear on who he was talking to, and that would have caused him to be stuck with those definitions at that time too. That question didn't get asked, though, unfortunately. And it would have been inappropriate for me to yell it out. Believe me, there was a couple times I thought, I can make a statement here, and I won't get in trouble, but I'll be, make a nice statement. Make sure that Canada has heard of something, but that's not the place. It would have been fun though. Does it really matter who? Well, if you're talking about perjury, then it would matter, Ellen. But if we're talking about being a jerk, no, it doesn't matter at all. And that's what we were saying. Like, it really doesn't. It's not material to the division that he created, and we all know who he was talking about, and we all know who he was trying to provoke. But the question around perjury, whether or not we can prove perjury, and then it does start to matter there, Ellen, because that's how we figure out if he's lying or not. Creek, don't rise, crook. If we're talking Trudeau, Justin gone Trudeau, just gone Trudeau. I like these hashtags you guys have. We're going to keep an eye on them. I don't feel like the Liberal Party is happy with him. The white paper movement. White papers for all these panels and stuff now. White papers have been around for a long time. It's how we share knowledge. I'm sorry, I may be wrong, but the question was, why did you call Canadians names? No, I don't think that was a question, though, Ellen. In fact, we go to the testimony. It was along the lines like you were being divisive. A prime minister is supposed to unify, and that's how it went into the question. And it was along the lines like, why did you call? Maybe you're right, Ellen. Maybe the question was, why did you call Canadians names? And then he defined it to, I didn't call the unvaccinated names. So maybe he's the one that did the signaling to the group, which would have meant all the more reason why the second question should have been asked, because he successfully skirted that. So you could be right, Ellen. I have a decent memory, but not a flawless one. And I'm going through the question again in my head, and you could be right, but his answer put it onto the unvaccinated, and then the second follow-up should have been, if it wasn't the unvaccinated, then who was it? But that second one wasn't asked. And it could have been not asked because a crowd distracted Eva, because the crowd responded, and there had to be an interruption to be quiet at that point. And that could have thrown her off her game and stuff like that. So it doesn't matter how he treads it. Well, only for the perjury part, Ellen. Not for the damage to Canada, you're 100% right. For damage to Canada, you're 100% right. But if we're going to be able to prove perjury, we need a little bit more. Yep, 100%. Those are all Canadians. So I think we're on the same page here, Ellen, because I think you and I agree that was disgusting what he did. Like, full stop. But again, it was just about the perjury conversation. Yeah, he called us names. Yep, more than once. Yep, French, English. In the House, he didn't deny it, decry it, apologize. Yep, 100%. I got research that says he's a liar. Great. Not a lawyer, so won't argue perjury at inquiry. Well, no, but here's the thing, Railroad. That's where we will share that information on Discord. And yeah, look, my goal is to find charges that stick. Okay, that last part is important part, because we can put a lot of effort into it and get dismissed. I want to do our best to find stuff that will stick. And that would mean sometimes, Railroaded, that even ones that we have a lot of evidence for still doesn't make it to our prosecution package, because we're looking for the ones with the most likelihood of sticking. You can always amend charges, okay? Look, you can always amend charges. And once someone's arrested, they might even squeal and talk and be investigated, interrogated. So there's always more you can tack on later. Like, we may have something that gets... we got about 80% confidence in, press charges or something else, more information comes out, we're now up to 100% on the other one too. And then that can be tacked right on. I suspect we're going to have a lot of perjury charges that we can show that are far stronger than even this one we're talking about here. Okay, because we actually had contradictions in witnesses themselves. So obviously their story can't jive. We just have to figure out which one it is. He is very clear that he doesn't like any dissenters. Yeah, that's another one too, Eleanor. So anyone that's against his opinion, and that's pretty common amongst tyrants. Okay, like, good government does not mind dissenting opinion. A good leader seeks out critiques, especially if they're constructive, for many reasons. Harmony, in order to have a good team, to everybody jives well. To know what's going on so you can address it, to be preemptive, to be reactory. A good leader wants to hear all of it, not just the bad stuff. And, I think anybody that says, oh, here's a group I just simply won't engage in because of their rhetoric or their speech or their opinions, I think that's a definite indicator of a closed-minded person and not a true leader. Well, we got people on the ground there. Jay, you're so funny. We had people on the ground there. Like, we had Tom that was there for the whole week. Tom, not Marazzo, but is that right? Marazzo? Oh man, I keep messing it up. No, I know Keith is gone. I know Brendan's gone. Even Tom Curry's gone. These are all people that we had contact with. So, and they're all gone. But I can't even ask them, hey, what's going on? Railroaded. Yeah. I didn't get connected with any of the council for the committee. I did meet the commissioner, but that was the end of that. I didn't swap information. But I did joke with him because I asked him if he would do an interview. And he says, I don't want to be on any videos right now for any sides. So I guess he identified me as a side, even though I didn't. I'm just public. But I said, okay, well, then I'll chat with you in March then, right? And he said, oh, okay, yeah, we'll do that. Because they should be all done by March. Maybe we'll be able to follow up on that. I don't know. I'll send him the pitch and say, remember when you told me we'll chat in March? Here's the picture. Maybe we'll have an interview at some point. That'll be wonderful. Dave, you stopped the money before they got to Ottawa, so you criminalized them before they got there, before you even tried to say it was illegal. Okay, so Dave, yeah, and this is something that annoys me a lot because they talk about the $10 million like it was cashed in and used. Like they keep talking about it like a well-funded group. Not true at all. What happened was because of the funds were raised, there was expectation for fuel costs to be covered and other things that didn't end up actually happening. And that itself caused a bunch of problems. So the fact that they froze that money caused problems on the convoy side, which is part of the reason why they did that. But they keep pointing to the money as some sort of benefit to the convoy when it wasn't. It didn't end up being a benefit, and it ended up actually hurting them a bit in that more people showed up expecting to have their fuel covered than they could pay for. So in either case, the raising of the money, although it was a great representation of how many people were supporting them, and then to do it a second time in record time, it didn't actually get to them, but they keep using it as if they're a well-funded group. Yeah, Green is funny. I really enjoyed our time together, Green. That was a great time. I really can't wait to see you again. And I'm sorry I did cut it. Well, it wasn't short. I didn't cut it short. We were into the next day, Green. We went past midnight, so I had to get some sleep. Mr. Green, yeah, you're a fun guy. Charge! Not with your credit cards. I'm going to take those away. If those people think they're getting on a plane beside our children's speech. Oh, yeah, I had no problem flying, so I guess what we're doing so far hasn't put us on the list. Railroaded, I'm winning the guillotine. Oh, you don't have one of those, do you? Jay, the white paper movement is regarding the Chinese protest. Good. Okay. Thanks, Eleanor. I didn't know if white paper meant intellectual documents, so as we're doing this round table thing. So thank you. Using blank sheets because they know what it would say, yet no foul. Oh, that's clever. So they're protesting with blank paper because they can't put anything on it, but that in itself is the protest. That's clever. I like that a lot. I like that a lot. Now, if you are looking at protesting, follow this kind of example because this is really a good message. It was almost like replaying Trudeau's own words in the next protest, the stuff that was bad that he shouldn't be saying, just replaying that over and over because you can't really stop the Prime Minister's message, right? So the Chinese here are using blank papers, and that's a great message. I like that a lot. You've been silenced to the point of protesting with silence. That's pretty cool. I like that. Calling us unvaxxed is calling us names too. Calling us unvaxxed is calling us names too. If those people think that they're getting on a plane beside a children's speech, here's another one. No. You're right. You're right. But even saying things like those people, like Mr. Green, I really want to get to definitive. Okay, we got to prove it definitive. We know what he meant. He was definitely othering us, right? Othering us completely. And then name called us and then degraded us and had Canadians turn on us. You're not wrong. But if we're focusing just strictly on that sentence of the testimony as being perjury, because that's the only one that can be perjury, that's under oath. Everything else he says everywhere else isn't under oath. So we got to focus in on what was under oath and whether or not that statement verbatim was perjury. I say we're headed in that direction, but the initial response, initial review was Keep digging, Green. You might have some more. You might have some more. Keep digging, please. Yeah, exactly. Keep digging, please. There may be more that I'm not aware of, too. The problem is the government should never be able to steal your money. You're using the word steal because the answer will be, of course not. I agree with you 100%. They should never be able to steal. Seize, freeze, confiscate. Well, in some circumstances, I do agree with it, Dave, especially in the proceeds of a crime. Especially in the proceeds of crime. So I believe that criminal will feel like it was stolen from them, but on our side of the law, we'll feel like a criminal was stopped with the proceeds of his crime. Again, due diligence, due process has to be proven, innocent until proven guilty. It's your money until otherwise proven, for sure, all the way. But once it passes all that, I wouldn't call it stealing. But your statement would stand. Of course they shouldn't steal. Yeah, Marazzo. Marazzo or Marazzo. I keep getting them backwards. Marazzo or Marazzo? Marazzo. He doesn't care. I've called him both of them. He doesn't care. He's not even correcting me on it. But Marazzo? Marazzo? Okay. Would it be considered hate speech saying that the vax shouldn't have to sit beside the unvax on a bus, train, or plane? The funny thing about this one, Patricia, is I believe this is going to happen in the future, but the other way, because I believe the vax will be sick. So, Patricia, even though that this statement stands opposite our freedom, or it's pointed to us, I believe this statement is going to become true again in the future, just the other way. Us unvaxxed and the ones that didn't get sick from the vax are going to want to distance themselves from the ones who are sick from the vax. Just putting it out there that even though we went through all of this as the recipients, it is likely that at some point it's going to change because, let's put it this way. I don't think we're going to be to the point where we almost sit beside somebody, but we won't procreate and marry. That will be the issue. That will be a barrier between marriage and procreation. There'll be the decision to not cross procreate because of the complications created by the children and offspring of those with the mRNA vaccine. So I believe that prejudice is going to happen. And that's sad. And there's a lot of people involved on that. But hopefully we find out that maybe the Johnson & Johnson people are fine because they didn't get the mRNA one. But other people have issues. Maybe if you had 3 or 4, then we still have a lot of data to crunch. So we have to wait on some of that. But Patricia, I want to be careful on that because I believe that comment might get reversed the other way. Alex Mazzaro left Ottawa yesterday. Check his SMS here. Yesterday, yeah, he was there Friday for sure. Saturday, Sunday probably. Yeah. I know Brendan left Saturday, and then Keith left Sunday. I left Sunday. Marazzo also lives in Ontario, so he probably just drove home. He didn't have to fly, I guess. If you went for money, you were there for the wrong reasons. Hey, Frank. Oh, yeah, right, for the truckers. For sure. And that's not what I meant there, Frank. What I mean there, though, is they didn't go there for the money, but I assure you there were truck drivers who said, oh, okay, because they're covering it with that will be the last factor in the decision, okay? I don't think they went there for a tank of gas. I think they would have been absolutely pleased to have some gas covered. But I do think at one point more vehicles started to come in because they thought that would be covered. So I agree with you. Don't go there for that purpose. But because some people did go there expecting some gas to be covered, not even 100%, just some, and it wasn't, that in itself also caused some challenges for the convoy side of things, whereas it didn't create a benefit. So the government saying, hey, that $10 million was a benefit to them, and nor was it not a benefit because they didn't get it. It actually also caused problems. So more people were looking to have their gas tanks filled in. But I don't think, Frank, anybody actually got into the vehicle and said, I'm going to get a free tank of gas out of this, and then drove there. But some of them did go there believing that part of that $10 million was going to make it into the gas tank. Don't know if they would have gone otherwise, but that's where there would have been some more frustrations and confusion. Now, I'm pretty sure that once someone realized, hey, they didn't release the money and it's not Convoy's fault, they weren't pushy for it at all. They understood. But it certainly would have caused some problems. It wasn't short of you are freezing. It was a great first meeting. That was our second meeting, wasn't it? The first meeting was at the POC itself. You sat with me in the room for a bit, and you just couldn't stand Freeland. I don't blame you. You couldn't stand Freeland, so you took off green. Then you were going to try and come back Friday. Couldn't make it happen, and then we got together Friday night. Was it Friday night or Saturday? No, Saturday. We got together on Saturday. So I didn't see you Friday, but I saw you Saturday. Jay will catch up by morning, you think? We're going to get jet lagged till Wednesday. I'll recover. I'll recover. Yeah, the plane was late. The luggage was late. And it was an hour drive from Edmonton to home. And anyways, I'm alive. I'm alive. I'm a trooper. If I can't do that railroaded, I shouldn't be doing this at all. Lots of love to you two there. So when you go into the airport, is it all digital now? No. No, there's still people, Diane. A lot of people ask me on my Twitter if I needed to prove vax or anything like that to fly. No, I'm not vaxxed. And I flew, nobody asked. One of the also weirdest things is that the POEC itself, my ID never left my wallet. I didn't have to identify myself to a single soul. And I sat right, 30 feet from the Prime Minister. So overall, I thought it was a pretty pleasant experience for me. I had no troubles. The only place I'd show ID at all was the airport, not even the Via train. So look, get out there, travel, enjoy Canada right now before anything else gets into place. If you got family, you go see. And if you're not sure if Air Canada or whether airlines handle or will let you on, call them. And I'm saying all of that because a lot of people reach out to me asking me all those questions. I answer them the best I can, but you can also call the airline. I had zero problems. Yep, it's a real job to stay informed. And the thing here, Eleanor, is I want to stay informed. There's so much. I still haven't watched that movie, The Sudden, that movie. I haven't watched that yet. I am desperately trying to catch up on content, that's for sure. But keep it all coming. I want to get through it all. I'm doing my best. And I have excellent people like Railroad and you, Eleanor, and Ellen and other people just reminding me of stuff and correcting me on stuff and helping me pronounce things, right, Ellen? Seriously, what is unvaccinated anyways? Yeah, well, there's two definitions. There's pre-COVID and post-COVID, okay? And there's also two definitions of vaccines now, pre-COVID and post-COVID, because vaccine has changed in definition, right? It used to mean something very different before COVID. So 100% Ellen, I'm all confused on what means what too. What does unvaccinated mean? But for me, it means I didn't get the COVID-19 vaccine, any one of them. People have been vaccinated all their lives for most stuff. Yeah, smallpox and other things. Yeah, I got those. My kids got those. We weren't we're being blamed. They're being called anti-vaxxers now because we chose not to do the COVID one. But I'm not anti-vax at all. I'm not even anti-COVID vax. I think for certain people, a certain age, for certain medical, and if their doctor requires it and suggests it, go for it. I think for some people, it's fine. For some people, I don't think it's necessary. And for some people, I think it's harmful. Okay, I think all of those are true. So, and my original position on the COVID one was, we'll wait and see. You're rolling it out to the older people, wait and see. And then as things started to come out, I was like, I'm not comfortable with that. The effectiveness isn't high enough for it to be worth the risk. So, I did my simple math, carried the one, and said no. And one day in the future, it might be so proven and technical and perfect and all this kind of stuff that maybe it is something that's of benefit. But at this point, I'll wait till the experiment is over. My mom refused all shots for me as a kid. She told me when I am mature, I can decide. Cool. But that's an extreme end too. Okay. There are some that were good, proven safe, not harming people. But yeah, you're an adult now. You can make your decisions. You seem to be, healthy. You kept up to us. You're lots of energy. So Mr. Green, yeah, you're a good dude. It's not No, it's not. You lie. The information is shared by credit agencies. You lie. What's this about? Dave, I'm not sure who you're talking to about this. No, it's not. You liar. The information is shared by credit agencies. Maybe you can fill in some context there, Dave. Don't know what you're referring to. Unvaxxed mobs, he said. Oh. In French, we'll double check that. We checked that night of. We had some French people at the table, and they themselves were disappointed in hearing it the way it was said because they were hoping it was going the other way. So I sat at a table with a couple people who realized what he actually said and had to accept disappointment because it wasn't perjury. But again, like I said, though, staggering. There may be other comments. We only checked the French one from that video that we're all familiar with. There might be other comments that he said which will help with the perjury. I just want to make sure that you understand. We're only talking about that one, the famous video that we reviewed. Mr. Green, well, you are the very few that Trudeau claims he didn't call names in. And I believe that Green's got some really good stories. He was very, very good at dealing with judges, and sometimes he has to go in there and ask the judges for some stuff, and he's very good at getting it. So, hey, Green, I'm very impressed with you, bud. Eleanor, you know what? James, are you hate speech? Did you mention that JT paraphrasing? Who's that? The final. Did he really? Did you really, James? We've seen that, I think, a few times with even Freeland, where she was quoting something and it had its roots in some pretty hardcore history. And that final solution stuff has come up a couple times from Twitter people. Point was, just not getting the COVID vaccine does not make somebody the dreaded unvaxxed. Sure. Your point was, yeah, somebody the dreaded unvaxxed. Point was, I think I understand what you're saying here, Ellen. I'm pretty sure I don't disagree with you. Jay, check the link for Marazzo, please. It's about 3 minutes. I don't think I have the link. Let me go check. Where did you send the link? Railroaded. Are you talking about the one at the Parliament, where he's done that Parliament with the TikTok one? Because if you are talking about that one, I'm not going to play it. Because to me, that's a bit of propaganda on his part. If that's what you're talking about. Because he's a lot more pessimistic, and he's got some hopelessness in him right now. I'd rather not play if that's the one you're talking about. But if it's something else about traveling and being done, I'll play that one. But if it's a TikTok one, I watched it. I sent him a message about it. He knows how I feel. He responded. But I think he needs a little bit more hope. Share it. You'll see what he has to say on his way out of Ottawa. That might be it. I'll keep an eye on that Railroaded. But if it is the TikTok one where he's standing in front of the Parliament at the fire, he's got some music playing. If that's the one, I encourage everybody to take a watch. But I don't fully agree with his tone. I know it's my title. I don't like competition. I'm supposed to be unique. You're actually a really cool dude, Green. Okay, Alex, you're a really cool dude. Thanks for Diane. No problem. They want to control our money, but they don't want us seeing theirs. Good for the goose, good for the gander, right? If you're going to do it to us, got to do it to you. I would be for, even though it would mean I would have to do it, I would be for full financial disclosure for any, let's say, elected, then you have to disclose. And then if anything comes from it, like criminal, you become disqualified. But I don't know if I would need it on a candidate level, because we'll be disclosing like 5 or 6 people's financials per riding and only one of them wins. But I would definitely be for the winner. So once elected, full disclosure. And if you're not prepared to do that, you don't run. Simple as that. I would be prepared to. It's embarrassing, whatever. But I would do it. I have nothing to hide. How unique, all right, Mr. Green. He is. If you ever get a chance to meet Mr. Green, he's awesome. And I got some pictures I can try and share. I'll put it on my Twitter tonight. A couple shots from Mr. Green. Unique is the only way. Absolutely. I don't want to be like everybody else. I want to be an individual. I am who I am. I'm not trying to be 100% to anybody, and I'm not trying to find anybody who's 100% for me. My wife is as close as I found, and even that's a strong 80%. Okay. We're still unique, very different people. I love her to death, though. Yeah. Hey, in Mr. Green Thumb, I have a little PTSD with these smiley faces. I've gotten thousands of those from the other side the last couple of days because of my tomorrow picture. Thousands of those. Oh my gosh. If you haven't seen it yet, it's my pinned tweet. Go through the thread. Oh, we got some work to do on fixing this division that Mr. Trudeau caused, and I'm calling him caused it because these are all name callers. They're all name callers, okay? That's all they're doing. They're name calling. So they took after the great leader, supreme leader. Lots of love here. Some Diane's loving it here too. Yes, but those vaccines were derived from live viruses. Now they are synthetic. You talking about the J&J one? I don't think any of them were any good. J&J was attempt to be one, but yeah, we won't go into too deep there, Prairie, but we're dealing with something very different this time around, right? It's got a made in, and we just don't know where that made in is, and it might have been Winnipeg, you know. Anywho, we're dealing with something very different here. Smart man, is that Green? If it is, you're right, Diane. He is a smart man. I couldn't hear him at some point, some parts over the music. Oh, Morazzo. I didn't, yeah, I wasn't a huge fan. I thought it was powerful. I reached out and let him know that, but I'm not as pessimistic as he is on that message. I think there's, especially some signs recently where I think we have some hope here. I think Canada is still unique. Look at how we are inspired the planet when we took a stand. They noticed. Yeah. But he was losing hope. He was losing hope. I can feel that in that message there. The past. What does that mean? What does that mean? I have to look it up. Papier. Pasta paper. Picure. I'm not sure, but I can. I like you. You bet Canada is still unique, and we got a long way from done the fight and fighting this fight, without doubt. Yeah, and we win this fight too, guys. Good over evil. We win this fight. It's gonna be quite the battle. Chase, sorry, I'm terrible for not tagging in sometimes. You're anything but terrible, Railroaded. You're anything but terrible. I don't even know how you keep up with the chat. Like, even for me, that's difficult. I'm also got to juggle emails and some other things, but I also am preparing to go out there again. So yeah, anyways. Oh yeah, I had an excellent phone call. The guy in Red Deer. Oh my gosh. I am dying to make a series about what I had to go through. We'll just call it the Burlington matter. I am being very delicate on what I talk about live because I'm dealing with some pretty insane people. But as soon as we're done, those floodgates are going to open, and it's a heck of a story. Sorry, I just clicked your name, Diane. I didn't read it. I will not take anything as experimental. Well, here's the thing, Diane. That's your choice. And I believe the international law says it's your choice, but you cannot be forced to. And maybe one day you will take something experimental, but you get to choose what it is and when it is in my books. And this is one I'm not interested in. In English, unvaxxed mob, he said in French. They're taking up space. Okay, thanks, Segreen. Okay, so unvaxxed mob, and they're taking up space. None of those are name calling, right? We got to tie the name calling to the unvaxxed to call it perjury. So if we find a comment where he specifically says the unvaxxed are and then insert name, then we'll be closer to the perjury. Hey, Chase. Some people are too dark. You're right. I'm very much an optimist who feels that we've got a mental change ahead of us. Yep. But also give Morazzo, we're just going to call him Tom M for now on. Also give him some empathy. He just went 6 weeks in Ottawa, limited visiting with his family. He loves his kids a lot. This guy loves his kids a lot. And he also had to go through stuff that he can't tell us about, more around the struggles behind the scenes during the inquiry. So he definitely has, I can see why he has his perspective. But I want to spend some more time with him and to talk with him to get him to understand there's still room for optimism. And we're starting to see some of the signs. Some of the things are actually starting to sway my way or our way. Let's not forget that too. We're making progress on some agendas. So let's not forget that. Chase, I feel a bit gloomy too, but you have to imagine how he feels after. Yeah, exactly. Railroaded. Exactly. You're one of the more empathetic people I know as well, Railroaded. So it's not very difficult for you to put your head into your feet into their shoes a bit. It was a tough 6 weeks. It'll be a tough 6 weeks. But I think he'll come around. Okay, I think he'll come around. And also, he's not too far gone. Like I just wanted to just be clear, if you haven't seen the video, there's just a hint of hopelessness. Just a hint. But I'm sensitive to that. So, Railroad, I really don't know a lot about Tom. He's really focused on things within my control and macro issues that are beyond my ability. He's a nice guy. If you ever get a chance to talk to him. Hey, Chase, and at some point, well, I had you on my stream, and I was trying to get Tom on, and then a few days later, I got Tom on, but you weren't around. At some point, you both will be around at the same time, and you'll be able to say hi. I know you had a couple of questions for him that you wanted to get to him. I'm still trying to get that going for you, Chase. I didn't forget about that. What about the words we heard earlier? Canadian regime. What is that? Yeah, we heard that a lot, didn't we? Regime, regime, regime. These people were talking on a global level, weren't they? I'm going to be honest with you, Mr. Green. I had about 60% of my ear on it. Okay. I'll go back, but they did say regime a lot. PP. You go to the bathroom there, Patrick? Our jobs as Canadians is to help one another not lose hope. There you go. Come together in unity and love. 100%. 100%. This is the best part of Canada. Our hockey teams can lose, and we'll still have a beer after. It's the same story for World Cup fans, but my gosh. But no, absolutely. It's also there to help remind each other about hope and help build hope as well. There's a couple different ways to get hope into your life. You can recognize it, but you can also help develop it. We can do all of that here. Excuse me. There you go. Boom. Hey, Chase. And Chase, you're a Bitcoiner, right? You're into crypto. You have to have a certain level of optimism in you by default. So that's cool. Yeah, and that is the answer. We can totally get through anything if we unify. There'll be like nothing that we can't get through if we unify. That's kind of a paraphrase and a quote there from Reagan, right? How quickly would we unify if an alien force attacked us? Instantly. We won't lose Canada. Call your corrupt leaders out. Corrupt leaders resign. Yep, we got this, folks. Even the stuff that I'm getting on Twitter right now, the hate I'm getting on Twitter is filling me up with more optimism that we're heading in the right direction. We are being attacked only because they're afraid. That's it. You don't attack something that you think is weak and unimportant. So keep it up, folks. I'll take those hits. I don't need a human shield. We'll just do this ourselves. Okay, it's moved now, so I'll be good for a bit, guys. We'll keep fighting for them from our grave. How many can we fight freedom? There was somebody who was just being abrasive. And my parting comment to them was, well, I'm glad you got to say what you wanted to say, because that's the freedom you get to enjoy that others gave to you. And it's even before us. And it will require some of us to still stand up and continue the fight to ensure that going forward, those freedoms are returned and never again touched. Municipal, provincial, federal, make it matter. And school board. Okay, and school board. And there's another one in between municipal, provincial, and that's regional. They're your county level. County councilors. So yeah, school boards, municipal, county, provincial, federal, all five. Get on them. Get on them in some capacity. JT said he leaned on the health officials. That can't be good for him, right? Not at all, Slayer. Yes, and by the way, thanks for hooking up on Twitter there. Yes, no, Slayer. His job isn't to know everything, right? He's not supposed to be a medical expert. So he has to rely upon. Now, his choice of words here, lean on versus rely upon or work with or collaborate with. Lean on feels like you're pushing them. You're guiding them. You're getting them to where you want them to be. So if he's being precise in his speech, Slayer, I think what you identified there is his actual thinking was to provide the guidance, but they do the words. Because that's what I think of when I say lean on. Maybe it's just a reliance, like you lean on your parents. I find that he doesn't know everything and he has to use other people for decisions, but if he's getting them to do something, like leaning, maybe it's not so good. Green, here's my white paper protest. That's awesome. White flags. That's amazing. I do like that message with the white paper. That's a nice message. It's so unthreatening. Like, how would that be threatening in Canada? A bunch of signs of blank paper? Right? Like, are you going to turn it into a racial thing? Are they going to turn it into a racial thing? If it starts in Asia, can it become a racial thing if it moves here? Believe me, they'll try. But that's not a bad message. I don't mind that message at all. FAFO, I've seen it a few times. Counties, armies, some places railroaded. So Eastern Ontario, we had 6 municipalities that we handled in one county. So we were the United Counties of SDNG, and S meant North and South Stormont. D was North and South Dundas, and G was North and South Glengarry. So 6 municipalities, all independent, one counseling board for all 6. And it was called United Counties, so 6 of them. So there is, and that's a tier 2. So tier 1 is municipal. Yeah, it was a tier 2 was a county. Now, here's the thing, railroaded. Other places, there might just be one. So it might be one municipality inside that county. Therefore, you really only have the one. But like I said, with Eastern Ontario, there was 6 inside of one. Speaking of school boards, so good that Neely's mask instantly failed in Ottawa. Way too close to a vote, though. See, yeah, we're making headway, though, Ellen. We're making headway. Pretty soon it won't be close, and pretty soon the agenda will fall. Right after you heard the stories, he almost cried. There you go, Alex. Couldn't find that flag, but the unredacted version of mine is younger. That's cool. I like that one too, railroaded. LOL, screen you like that. Redacted. And end of chat. All right, folks, this was an ad hoc day. Started late. We got in as much of the test or the panels as they provided, and they cut off. I'll do a quick refresh again, but it is now 7 o'clock over there, so I'm pretty sure that they've wrapped up. But it would be interesting to know what happened there. Maybe just a tech issue. We got one more from Railroaded here. We'll help you see what Alberta's rules are, MGA. Maybe they differ from Ontario, not sure, but a municipal is okay. Otherwise, it's intermunicipal planning. Okay, yeah, and also, as you know, railroaded municipal acts are provincial. Okay, the municipality acts are provincial. So 100% right. And you also have reeves out here. We didn't have reeves out in Ontario, but we had wardens. But no, railroad, that's probably the case. So what we're saying is really the same thing. It just, if we're going to say coast to coast, there could be up to 5 levels then. Okay. I think that might be a fair way to put it. Up to five levels. No end of chat. No end of chat, Alan. Nope. You're going to stick one in there. Thanks, Jay. Good night, folks. Okay, cool. Thanks a lot, Clay. But Alan, if you got a couple more questions, throw them in there. Let me see what the wife is reaching out for. It's going to take some care of some tasks. Oh, hold on. I got a response from Andy Lee. Okay, hold on a second. So my question was, hi, Andy, quick question. Did you have a bank account frozen under EA? If so, was it released? And then she sent me a screenshot of a message. I'll just go to hers. Not frozen anymore. E-transfers were disabled for 3 months completely until I threatened to pull my funding. Even my private bankers don't know what happened exactly. And it looks like here's a text message with her bank. Okay, let me just read it. I don't want to paraphrase it because it could be private. So let me read it. Okay. Did FinTrack flag my account? Seriously, what happened? The bank says they don't know. Have to make some inquiries, get you answers. Wish I had access to the banking and be able to tell you. Okay. Why would they disable? So I went to Ottawa? No idea. So she is claiming, okay, so I think it was Prairie who said, didn't real Andy Lee? And the answer is, yeah, she just said for 3 months her Interact transfers didn't work. Okay, so, and again, even with the message that Andy just said there and provided to me, she didn't know if it was related to the EA itself. So it could have been, it may have been, it might have been, maybe not have been, could have been because she was traveling and they were flagging, like, okay. But she did get back to us. Wow. Thanks for flag or spamming me there, buddy. Yeah, you've been blocked. All right, night folks, night folks. Nah, just yanking your leg. Alan, you're awesome. I like you. Where are you? Okay, you're in, were you the Barrie one or is that, yeah, you might be Barrie. You offered me an apple pie if I came to visit you. Maybe. I'll be back in Burlington next couple weeks. Trudy's speaking of CPAC, and that's why they stopped the stream. You think so? I doubt it. What's he talking about? Apologizing for the EA? I thought he was talking about some... what did somebody say? Someone put it in the chat what he was talking about. I know she did. I know... Yeah, it still did. I don't know if it still did. Nope, was me. Okay. Still am. What's this, Marnie? Jason, do you mind doing a recap of the upcoming scheduled events in regards to the inquiry, or let me know where I can find it? I joined late. Okay, so Marnie, what I did do that. So if you just rewind a little bit on this stream, you'll see a web page though. It's on the main part, and I go through it. But what I'll do is I'll also give you the PDF itself, so you can go through that as well. Where did I put it? Where did I put it? Let me get you that, Marnie. Here it is. So Marnie, just for you, here you go. Click that link, and that's a PDF of the week, who we're going to see, what topics they are, and yeah, how they broke that down. Hope that helps you out. Toodaloo, Ozario. Cheers, buddy. Nope, closer to... Why didn't we get together for coffee then, Ellen? I was there for like 3 days. Why didn't we get together for coffee? I'd have bought your coffee. Ask Alex. I bought him coffee. I would have bought your coffee, Ellen. Maybe next time. Yes, I have it on the other windows. Good. Good. There's a document for Marnie. You're welcome. You're the best. Thanks. Ooh, who's second best then, Marnie? Who's second best? See who I'm up against. Strong. Why does BJ Dealer hate Tom so much? Do you want my true answer, Chase? Just give me a thumbs up in the chat there if you want my true answer, Chase. They'll give it to you. Thumbs up before you go. Yeah, give me likes as well, guys. That helps the algorithm. It was really appreciative of how many of you showed up last minute like that. That was great. Protest in Toronto, the China one. That's good news. Hoping next time takes a bit to battle down the farm. Oh, right. Okay, sure. For the visit. Yeah, Ellen, that would have been cool. It would have been cool, but that's okay. We'll catch you next time. And maybe I can come see you. Yeah, I'm not sure if we're doing the February convoy thing because it's it's bear hug, it's kind of united, and it's the middle of winter, so it'll be difficult again for us. Like, you have a farm, we have a farm too. Spring and on, it's far easier for us to go. But we have family out there, Ellen, so we got to come out there again sometime. Didn't the judge say that he had all the info he needed to make a decision when he wrapped on Friday? Yeah, so what he's doing now, Martin, is this is the recommendation stage, I think, really. They're talking about kind of the recommendations going forward and settle some other questions. But he said, I have all the evidence I believe I need in order to make a decision. So even that was not a definitive. He says, I believe I need. And he might have been looking at that as the fact portion, because that was a fact portion of the inquiry. This is now the panel discussion portion where you get opinions. None of this is fact and none of this is evidence, just opinion. And I think you'll hear a lot more about recommendations than trying to put in more evidence. I know BJ can come across in a way that puts people off, but I never caught him in a lie, Chase. And then you're saying yes. Chase, my opinion on BJ was he was at best, at least at the end, at best, the best definition I can give for him was an agitator. Worst, an agent. And that's where I'm at with BJ. Okay. I watched his testimony, paid close attention to it. He did some things I'm a fan of. He was a board member and he went against the board. He admitted to claiming he had the right to use the Twitter of Tamara to send out anti-board related messages, at least one. That act alone makes me distrust him. And that was his testimony. He explained it. I'm going based on what he told us. I wasn't pleased with that. His book was premature, and his book was rude. That's another part I want to point to. And he had some protection. He was notified in a way that nobody else was notified to leave, and he had no consequences. So at best, an agitator, because he caused problems. Maybe he was just arrogant, or maybe he was just thought that was a better message. Maybe he thought he was doing the right job. Whatever his motivator, only he will know. But he did agitate the situation. So at best, he agitated. At worst, he's an agent. That's where I'm at with BJ. May shake his hand one day, but I'm pretty sure. I'll just leave it there. May shake his hand one day. I got to get to know more. But from his testimony, that's where I'm at, Chase. Strikes me as a good... at best, I think he was an agitator. At worst, he's an agent. I totally get that. He is a self-promoter for sure. But like I said, I've never caught him in a lie. And I remember Tamara went to bat for him on the bench too. Yeah, sure. And Tamara's also a good person. And yeah, but she wasn't pleased with that. Okay, Chase, I just want to highlight how important that counter message to the city deal was. Like how important that was to messing all of this up. It is the pivotal moment that the government keeps pointing to as definitive proof on their side that there was no way to move forward with the convoy as was. Okay, Chase, they keep pointing directly to that counter protester, the counter message that came out of the convoy as proof that there was no ability to work with them. Because it's such a pivotal moment, and BJ was the one that made it the worst, because when BJ did it, it caused a whole bunch of people to question Tamara's, because it came out of Tamara's Twitter. And when Tamara, which is the official, when it was the official response from her, went out and that got questioned, it caused Jeremy McKenzie to question it. It caused Pat King to question it. It even caused Bridget to question it. So it caused lots of people to really go, what the heck's going on here? Don't trust it. It's fake news. Because of that incident happened, initiated by BJ, that is the moment that the government's pointing to as the key moment when, in their mind, there was no way to go forward unless they did it themselves with the EA. Unfortunately, it's BJ who attached himself to it. He said he had the right to send that message because he felt it was the right message, and he was a social media person. Those were his excuses and his reasoning for it. And as a board member, those are not valid. They're not valid. That's an immature board member. He should have been fired a long time ago, released from the board a long time ago, because that's not how you act on a board. You're supposed to do what the board requires of you. He went rogue, and now the government's pointing to that precise moment as the evidence that the group fell apart. Because of that, Chase, at best, he's an agitator. At worst, he's an agent. Changed my mind. Happy to chat with you more, but changed my mind. Not catching him in a lie could just be a reflection on your ability to catch people in a lie, not his ability to be truthful. Consider that as well there, bud. A desperate attempt to mask obsessed trustee Dr. Neely to mandate masks in Ottawa schools failed this week after many parents and students spoke out against the controversial measures. I heard an interview with her. Just started. She's abrasive, a rude person. That means she's also very passionate in what she believes in. Doesn't make it true. It just means she's very passionate in it. That could be rooted in a bunch of different things. Hey, okay, that makes sense. Thanks. Cool, Marty. True North has got some stuff. COVID crazies. Thank you very much, Railroaded. I'll go click that. Tamara was supportive of BJ in her testimony. I think you're being selective there, Chase. She was not supportive of that text message. Listen, and what Tamara was being truthful the entire time. And what I'm being with you as well, Chase, is truthful the entire time. If not but for that message, I don't think there would be a debate about BJ. But because of that message, here we are, Chase. He could have been perfect all the entire time, but he pushed send using her account, countering the message that caused all the confusion. What his motives were, well, let's just use a word that they use, mischief. We can call that mischief. We'll give him a little bit more benefit, but mischief can get you a Canada-wide warrant now. So it's a pretty big crime now in Canada. But he pushed send on a message he felt he had the right to do, but it was counter the message that was already sent out by the board. And immediately they revoked his access and got rid of him. So they didn't appreciate what he did at that time. I think what you're reading into this, Chase, is up until that point, and I think Tamara's actual testimony was, up until that point, we had no reason to believe he would do anything like that. Okay? At that point, everything changed. It's like pulling the trigger of a gun. You could have been a completely peaceful person your entire time, but for one split second, you fire a gun and hurt somebody. Now, from that point on, you're somebody that shoots somebody. Doesn't matter how nice you were before. For me, BJ, he pushed that send button, which really confused the situation in the wrong direction. And it also could just be ignorance to Chase, but that would still fall under agitator or mischief, because you should be a lot more cautious in what you're doing, at least get permission. You may know better, Chase, but he is definitely arrogant. That's just, his personality, because he has some sort of social media, and yeah, he's got the big head syndrome. And even when he was being rude, here's something, Chase. He was being rude to Pat King on the stand, calling out Pat King's social media numbers. And I believe BJ was wrong on those numbers. He said several thousand when there were hundreds of thousands or tens of thousands. So if you're looking to impeach BJ in his testimony, you can start right there. I think you were spot on when you said he doesn't know the difference between morals and ethics. I said that about BJ because on a board, you have to know the difference between the two of those. And on a board, you can't use your morals. You're supposed to use your ethics. And they are different. I wonder if BJ was an agent a few months ago. It's just a small suspicion about him not. Now we know, Chase, 288 people had their bank accounts frozen, including a gentleman who was in Windsor. Okay, so there were a lot of people that made that list. And for BJ not to make the list when he was on the board, right? He's on the board. He's one of the 6 or 7 people listed on the board of Freedom Corp. But then again, no. Tamara got hit. Chris got hit. Tom, I don't think Tom's on the board. But anyways, he definitely would have been identified there, Chase, as at least a person of influence, at least at that level, someone that had influence. He was handling the social media or open source information. I agree, Jason. His actions were very damaging, and the yeah, 100%. If that wasn't the straw, Ellen, like if they didn't point to that as a straw that broke the camel's back so much about their decision that the convoy couldn't cooperate, because that's the point where they said we had no faith that they could fulfill anything they said anymore because of this confusion. If it wasn't for that straw, I don't think we'd be talking about this. It's not right in the head. Yeah. Yeah. You're talking about that doctor again. Yeah, I heard that interview on the... Who was I listening to? Oh, Clyde do something. Hey, Jeremy, anybody else that watches him, I think there's a future for Clyde and I to collaborate a lot more. I've listened to some more of his stuff recently, and he definitely needs, because he's asking for, and he says he doesn't have the legal side of things, and he really could inject a lot more of that in there. This guy can help with that. And I also noticed that he's doing segments throughout the day. So what I might be able to do is something similar, but just time it after and before him or type of thing. So there's no overlap. So maybe we can share the crowd in some capacity. But I really liked what he was doing. I like the interviews he's doing. I like what he's saying. I like how he talks. But I have noticed that he likes to have a little bit more legal, or would prefer to have a little bit more legal injection in there. And I think I can help him with that. Jason's being kind. The woman is insane. Yeah. Well, no, look, she may be insane, absolutely, but she still has a motivator behind that insanity and passion. And that insanity can be driving her passion because it's just insane. I'm certainly not saying she doesn't need mental health services or anything like that. But I'm also the type of person that tries to find out what's pushing them. Is it fear? Is it money? Is it power, prestige, likes? I think for her, it's a little bit of crazy passion. She really believes her Kool-Aid. She's really drank it, and she's got the passion behind it. So in other words, I don't think she's paid to do that. I think she believes it, as insane as it is. Now on CPAC, Trudeau is getting support from the Cree community right now. Right, that's what I was told. He's doing some announcement with that community. Chase, cool. Very true. I watched what he says about Bitcoin because he can't lie to me about that. Cool. Yeah, I used that to gauge him. The same with Pierre. He hasn't slipped that up yet. Yeah, that's a neat way to do it. I see what you're doing there. So you challenge somebody's ability to be truthful based on what they say on subject matters that you do know. Here's a little thing that I think is hilarious around this. Have you ever picked up a newspaper or read like CBC or something like that, and I'm pretty sure the answer is going to be yes, on a subject matter that you know, and for your case here, Bitcoin or some other subject, and you see that there's errors. They're just factually incorrect, or they don't understand, or they're misusing terms or anything along those lines. And you'll go, oh, that's silly. They just don't know enough about that subject. But then what's the very next thing most people will do? They flip the page and then believe the next damn page. Like all of a sudden this newspaper could get everything else right, but the stuff you know. The truth is, from cover to cover, it's full of close to their understanding of, their version of, and in some cases, Chase, is just off. But it's a kind of cool little thing. If there's a subject matter that you know and you have someone talk, and then you can find out the credibility. For example, we were sitting after dinner having a drink at the bar with Keith, and this bartender comes up and tells a story how he was he said he was charged for assaulting Chrétien at the G8 summit 22 years ago. And he said what he did was he accidentally spilled some cold soup on him, and it was Chrétien's fault. And up to that point in the story, I'm like, okay, I can see that. Yeah, sure. I can buy your story. But this is where the fantasy took over completely after that. He talked about being pulled in the back by the RCMP. They threw handcuffs on him, roughed him up a little bit. And then he stood up and said, you guys, if you don't take these off me, I'm going to have your job, and I'm going to do this, and I'm going to do that with the press. And then the part that really blew his story away is, and he said, and I would throw it all over social media. Okay. 22 years ago would have been 2000. Social media back then would have been Geospace. Geospace, right before MySpace, way before Facebook, well before Twitter. So he's lying. He's lying. He's embellishing that story forever. Now, I believe that maybe he was at the event as a waiter, but that would have been the extent of the truthfulness of that. And Chase, he might have been able to get away with that story for everybody except for me, because 2000 was early days of the internet. Geospace, GeoCities was around at the time. MySpace, very fresh. But I certainly assure you, at that time that he's telling the story in the timeline, the RCMP would have cared less and far less than any threat about being on social media. And on top of that, the RCMP wouldn't have responded to any threat like that from anyone like that. So, baloney story, because I can recognize the untruthfulness about technical parts of his testimony there. Yeah, you can spot him. Just because you haven't caught BJ, just could mean he's good, or he's only told one lie, or something like that. Your opinion matters. Oh, cool, Chase. I like the perspective that you helped provide during the last 2 months. I appreciate that a lot, Chase. And I hope to have you back on the panel again. Really enjoyed talking to you. And I really do want to get you and Tom connected because you had some questions there. I think I can help you with that. Oh, BJ says his bank was frozen. No, he didn't. Nope. During the testimony, they didn't come up with him. And the Canadian Civil Liberties Association didn't ask him either. He was the only witness that I recall, other than the protesters that were beat, but the convoy organizers that didn't say it was. I could go back, but I'm pretty sure that after his testimony, he was not one of the ones that they were questioning his bank accounts being frozen for. That might have been a lie if he wasn't on the list. You mean the lie is that he wasn't on the list? We'll look into that, Chase. I'm pretty sure, and my chat might remember this too. I'm pretty sure that he was the only one that didn't have the problem while we were watching that testimony. Viva and Clive speak often. He's not totally alone. He works full time all week, I believe, Clive. Yeah, cool. And yeah, I don't mean totally alone. I just mean here's another option. And Viva is certainly going to be a lot harder to get on his stream than I will be. And I'll also be incredibly grateful to be able to work with him a little bit on that. But cool. And I also know that Keith is in direct contact with Viva as well. So, there's going to be a lot in our future that are railroaded on who we can speak to an interview. And I believe Danielle Smith will be somebody we're speaking to soon. Spoke to Keith about that. Gelman. Oh, what is this? Let me look that up. What is that there, Chase? Looks interesting. Gelman, Mestia, ESIA, effect. What is that? Michael Creedon coined the term Gelman anesthesia effect to describe forgetting how unreliable a source is in one area when you trust it in another. Yeah, okay, I was talking about the newspaper. Yeah, so the newspaper, yeah, you know that they're phony in like the tech crypto section, but yet you trust the rest of it. It's odd behavior. But it's reality of the situation. She may not be paid, but she has given lots of attention. There you go. So it could be a prestige, maybe powered by prestige. Maybe she likes that attention. So I think it has fed her obsession. Could be, and obsession is another one too. So yeah, you actually just nailed another one there, Alan. Obsession is another one that powers people. So she could just be obsessed with it. Obsessive compulsive health addict or something. We'll make up a term for her. BJ says back with frozen in Twitter spaces. Okay, Chase, but it didn't come up in testimony. Okay, Chase, it didn't come up in testimony. And that's where everybody else that came up. Everybody else that went up there on the convoy side talked about theirs. So what I'm going to do right now, Chase, I'm going to go pull up what day was he on. So I'm going to go find that out first. because from the day I'll be able to get the transcript, and from the transcript I'll be able to quickly find where his testimony was around that. All right, so we have day 15. Is it day 17? I should have did better notes for them. Convoy second day. Okay, you know what, Chase? I'm going to look into that one some more, because I'm pretty sure the Canadian Civil Liberties Association asked him no questions about his bank account. He said nothing under the testimony about his bank account, and I'm almost certain he was asked if his bank accounts were touched, and he said no. I'm almost certain that the question came up, and he said no. Talking about in Twitter Spaces might be the lie that you eventually find him in. So, Chase, here, let me get you the link to BJ. I have that in front of me here. Where are you? BJ, there you are. I have the link right here. Get shareable link. It's 3 hours, 15 minutes. Watch in double speed. You'll be done in less than 2 hours. Check it out. Let me know if you find it in there, Chase, okay? I want to correct that if I'm wrong on that. So now Trudeau decided to give clean water, housing, land, House Center to the Cree Nation finally after all those years, only to get their support. But I'm super happy they finally get it. Yeah, and here's what will likely happen, Green. They'll take it, be thankful, and then flip them off. It's not going to be successful at buying a single vote. That's what he's doing. He should have done that a long time ago, but he's trying to fix his reputation right now. Green happy for them too. Trudeau is not redeemed 100%. Yeah, I feel the same way, Railroad. He can still do good things for people, but it's not going to get rid of the fact what he did. And he's doing it for image, not remorse. So can't give him any credit as a human on that one. That's where BJ's lie might be. Exactly, it might be right there. To what I'm trying to say, it wasn't true under oath, then it's a lie in the space. Yeah, so I gave you the link. Go ahead and check it out. Ellen's got it, day 16, November 3rd. Okay, now that I know that, day 16, November 3rd. Day 16, November 3rd. Thank you, Ellen. I'm just pulling up the transcript here. Transcript, because we can search that together. So many of these documents. We're going to have so many to go through. By the way, Keith Wilson has 12 monitors set up. 6 along the top, 6 along the bottom. And then I asked him the obvious question, Azario, because you're going to ask this one too, and anybody else is into tech. Do you really need them all? And he said, yeah. And what he did is he took me through what he does on every single one of them. He has a sent folder up there. He's got his inbox here. He's got a working document here. He's got his files and structure here. Like, it made a ton of sense. And as a multi-screen person as well, not 12, but as a multi-screen person, I get it. And then once you've done it, you don't undo it. You can't go back. So, but he has 12 monitors. Other than like financial people, I've never seen that many of someone. All right, public order emergency. Where are you? There we go. Here's the transcript. All right, let's go find out what BJ said. Okay, there, Chase. So let's just search for, well, bank. 32 times. All right, the Canadian financial institutions that had important roles, Royal Bank Canada. Those are not questions. The story, yeah, we're not into BJ's testimony yet. Okay, next slide. So if you recall, it looks like there was a presentation that day about the financial stuff. That makes sense. That makes sense. So if I see up here, we're in this section here. Once we get to that, we'll get into testimony. BJ is one of these two here. All right. We're making our way down. Banking records. All right. So who's this? There, BJ. Yes, he was also worked for SMP, the Bank of Canada military. So Tom Gwynn was as a host of the Gwynn Report. Okay. It's nothing about his bank account. Bankruptcy, submitted to Keith Wilson via his agent. What did you do with that seed phrase and the code? It went to the bankruptcy trustee. Okay, nothing about his bank. That's okay. On February 22nd, I understand there's $1 million from the GoFundMe. This went to Tamara. Okay. And now we're in Tamara. So yeah, there we go. There was nothing in Benjamin's testimony. It's right here. He's not talking about a bank account. Okay. Let's go see if Tamara did. Transferred to Tamara in her name. Yes, that's her account. And then the TD account was frozen next day. Does that sound right? That sounds about right. So Tamara's account was frozen. Okay, Chase? So you can go through the video again. Maybe you'll find something else. But he didn't talk about bank or his bank account being frozen. And I do remember that pretty clearly because we were watching the Canadian Civil Liberties Association. All they were asking was people who had bank accounts frozen. And they didn't ask him any questions. Okay. And that was how I remembered. I'm like, oh, wow. So his bank account wasn't touched? This is James Bauer. And Benjamin. Okay, so what I'm looking for here is Rouleau. So I'm looking for Canadian Foundation. Jim, Commissioner. Yeah, I remember this pretty clearly. Their Chase, he wasn't one of the ones with bank account problems. So if he did say that in Twitter Spaces, then the lie is in Twitter Spaces. Because I would believe the testimony over Twitter Spaces because the Canadian Civil Liberties Association was honing in on bank accounts. Bingo, bango. All right, buddy. So hopefully that helps you there. But BJ, you know, if you read his book, I don't know if you read his book. It's not a nice book. He's kind of rude. And there's a couple things in there that weren't corroborated with testimony. But at the end of the day, he's a public figure. People like him. Even the guy I was spending some time with, Tom, was a fan of him. And this is also where I had some more of my debates about BJ, was with him as well. Because BJ does have a strong fan base. People who like him. And I don't dislike him. I'm just going with what his testimony told me. Copy transcript. T-script find on page. What's copy T-script mean? Copy the transcript. Find out. Do you want a copy of it? I just closed it. I can get it back for you if that's what you mean, James. Just give me a sec. It's on the public hearing website. You just go to that day. It was day 13, day 16. This is what Ellen had there. Day 16, yep. And here's the transcript. Here you go, James. Copy transcript, final page. Okay, folks, let's wrap this up. Thank you very much for this little ad hoc one. I apologize for not being ready on this one. Thank you to Railroaded, and I think Railroaded mentioned Clay also reached out and told us about it. So again, thank you all in the chat, and everybody's helping me out here. You guys are invaluable. I'm here to help you. I'm here to do this with you, so thank you so much. Chase, thanks a bunch, buddy. Coming around, asking your questions. We got to do a little research together. Mr. Green, so because of Convoy coming back, that is the reason all Cree get the House be part of each other. Wow. You think so? All right. You might be right there, Green. All right, folks. Have yourself a great night. 9 o'clock tomorrow, 9:30. The panels or the roundtables or whatever they're calling them will start up again. And we'll hopefully find out what happened to the end of the other one. Maybe they'll finish up with it. But in either case, have yourself a good night. Take care, and God bless.